Good morning, good morning, good morning. Or should I say, hear ye, hear ye, hear ye. It's day 31. We are in week 8 of the retrial of Karen Read. And what we learned in court yesterday is that we are very close to being done. The defense is on their last witness. What does that mean? Well, they're not going to call Karen Read to testify. We kind of knew that. They're not going to call Trooper Proctor to testify. And we had heard that, but seeing is believing. And it looks like no one is going to call Trooper Proctor to testify. So we will be done with Dr. Rentschler today and maybe Dr. Welcher as well. The Commonwealth is calling 3 rebuttal witnesses from all their conferences in court. And that's going to be Dr. Welcher to rebut the ARCCA testing, Hartnett from the lab, who I imagine the defense is going to ask about those cuttings on the back of John O'Keefe's hoodie and swabbing the sleeve of John O'Keefe's hoodie. And then the person from UC Davis that tested the swabs and said that there was no dog DNA. So that's where we're at with this case. And then there needs to be a charging conference. That is the jury instruction conference between the jury is charged with the duty of rendering a verdict. So that will be instructive. I hope that it is also streamed so we can see what they are arguing over the different jury instructions. At that time, we will hear more discussion about the jury instructions the defense is asking for, like the instruction regarding necessary witnesses, sometimes called missing witnesses, like the instruction regarding the hoodie and what was said to the jury. Well, what was asked of Dr. Wolf before the jury about that. Some of those things we will hear in the charging conference and see what the final set of jury instructions will look like. The defense is not asking for a third-party culprit instruction. They didn't ask for that last trial either, so that's not new. But the evidence hasn't been developed that way in this case at all. So we are going to go to court today with Dr. Rentschler. We should roll the intro and, get to court. Maybe today will be less of a cluster than yesterday was. One can always hope. Am I being too optimistic? Chat, you let me know. Let me know what you're drinking, where you're coming in from. I've got a cappuccino. We're going to talk about what I have with my cappuccino in just a minute. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. We just need to go to court for a little bit. Why? Well, today we've got our beloved hear ye's. I found them easily. The judge is going to ask the jury those same 3 questions. I've got a biscuit, but also a croissant. I'm very crispy this morning. But after 31 days of trial, aren't we all a little bit crispy this morning? You let me know, and I will let you know what I think.
All persons have any business before the Honorable Beverly Kennedy, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, you shall be heard. I state the Commonwealth of Massachusetts. Court is now open. You may be seated.
It just does not seem loud enough to me. Let me know how court volume is for you, chat.
Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors. Good morning. I have to ask you those same 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions?
The sun is so bright coming into that courtroom right now.
Research or investigation into this case?
It looks like a sunny day in Massachusetts.
Did anyone happen to see, hear, or read anything about this case since we left here yesterday?
Unfortunately, yes.
Everyone said no or shook their heads. Thank you. Can we have
Can't-
Dr. Wrenchler again?
Can't escape. Can't stop, won't stop. All right, they're bringing in Dr. Rentschler. We're going to zoom as Dr. Rentschler takes the witness stand. Very tall. They talked about it yesterday. I know the volume seems low to me too today. The court volume just, that was me. The court volume just seems a little bit low.
All right, Mr. Jackson.
So that's better.
Whenever you're ready. Are you ready, Doctor?
I am, yes, Your Honor.
Okay.
We're ready. Hey, Your Honor. Are you ready, chat? Yes, please. Are you ready, chat? Yes. Now that the court's at the microphone, it sounds a little bit better.
Dr. Rentschler, good morning.
Yeah, that's better.
Good morning.
Yesterday, when we last left off, we were discussing
I keep trying to move the closed captions. And it keeps
to review And you
shifting.
described much of that material
Much better
in furtherance of your answer
when
that
they're
you
at the
were asked to
mics.
review certain data and undertake certain testing as it relates to testing that was done by Aperture, correct?
That's correct, yes.
Did you prepare a PowerPoint presentation to illustrate
That you edited
the
last
analysis
night?
and methodology in your review and testing of this case?
I did, yes, sir.
Did you bring that with you today?
I did indeed.
Your Honor, I have a flash drive I'd like to have marked as next in order.
Okay.
After all
Is there
the
an objection?
text was removed, so nobody could read the text, you could
Okay,
only
so
just
it's marked for identity.
see pictures. It's just, I don't think I've ever seen a court manage as closely the way that experts present their evidence. Just I could never.
Let me know whenever you, pardon me, let me know whenever you're ready, Dr. Rentschler.
Oh, it's that kind of
Do you
morning,
want me to
isn't
bring
it?
up the PowerPointer?
If you could bring up the first slide, let's start with
Sure.
that.
Let's see here.
Serena Bentley said, "Happy heavenly birthday to my daddy. He would
we go.
absolutely love you, EDB
Is this representative of the PowerPoint that
or MB." I am, your mom's favorite YouTuber. So mama and dad definitely works. There's a lot of people I meet that are like, wait, my mom watches you. Yep. Very true.
you presented, or
Very
sorry, that you prepared for presentation for the jurors?
It is, yes, sir.
Okay. Are there several blank slides, just sort of placeholder slides as we walk through your analysis that the jurors will see?
There are, yes.
Okay. Let's talk about first of all, what was the purpose of your investigation? What did you seek to undertake?
So the purpose of my investigation in this matter was to evaluate the evidence, and particularly as it pertains to the alleged theory of what occurred in this case.
All right, so I'm going to strike that answer. Ask
Why?
the question again.
Sure.
But
Did
why?
you seek to undertake an analysis?
It's going to be a long day.
Aperture's testing or part of their testing.
They're allowed
I
to
did, yes, sir.
testify.
With regard to that testing, what was the reason that you undertook to
Evaluate the
analyze
evidence in this case.
Aperture's
That's
testing?
literally what they're here to do. They're rebuttal experts.
Sustained.
They're
Ultimately,
rebuttal
were you
experts.
in receipt.
They're literally rebuttal experts. Their job is to evaluate Aperture's testing. That's literally the reason that they're here. And it's a proper purpose. They did testing. We did testing.
Of a PowerPoint presentation and a report from
Goodness.
Dr. Judson Welcher.
I was, yes, sir.
Okay. Did you have an opportunity to review that PowerPoint presentation in whole?
I did, yes.
Were you able to look at his report and read his report and review his report?
I was, yes, sir.
Did you undertake an analysis based on his reporting and his...
Also, if they were leading, I don't even think I heard it, because when you're establishing the background and foundation of what somebody did, I don't think I would ever object to leading, because that's what they're there for. And that's what they're there for. So were you here to evaluate Dr. Welcher's testing and report? It's just what it is. It's foundational. So
PowerPoint
it's
presentation.
dumb.
So I'm going to see you both at sidebar for just a minute, please.
Court chat. You called it. Mm-hmm. All of you called it. All of you said, how's long till a sidebar? Immediately now. However, it is probably a good point for us to just take a breath, since this morning is popping off, since we're already at a sidebar, and just thank our sponsor for the day. We should just do that right away, because you guys have seen me eating all of my croissants and delightful things for breakfast. Wildgrain has been a steadfast sponsor during this stream and this trial, and really has kept me eating breakfast so I'm not hangry at the end of the day, which is a 10 out of 10. So we'll just take a second and thank you to our sponsor, Wildgrain. And then we'll go back to court and the sidebar will be over. A huge thank you to today's sponsor, Wildgrain, for making sure that I am not hangry during stream, because Wildgrain is what's for breakfast every single day of this trial. Whether it is the chocolate croissants that I love so much or the raspberry lemon biscuits, but also for dinners, because I just had the amazing truffle and Parmesan ravioli and it was so good. Wildgrain is completely customizable. You can build exactly what you want to fit your needs, your lifestyle, and it's really easy if you need to change around when boxes are being delivered. What I love, because it is frozen fresh and then from freezer to oven, you can just make what you want to eat then and save the rest. You do not have to make all of the cookies or all of the biscuits at once. So I make fresh biscuits every morning before trial, and you know your girl does not have a lot of time. Freezer to oven, less than 25 minutes for everything that they send. And with every order, Wildgrain donates 2 meals to the Greater Boston Food Bank and other various organizations fighting hunger. You know I love things that make life simpler. So if you are ready to check out Wildgrain for yourself, be sure to click the link down below or in the chat and use our code LAWNERD. That's code LAWNERD to get $30 off your first box, plus you'll get free croissants for life. So thanks, Wildgrain, for keeping my mornings simple and for sponsoring today's stream. Let's get back to it. And I was able to zoom past the sidebar while we were talking about Wildgrain. And yes, I do put literally one of these into the oven every morning. Sorry for everybody who's like, don't make me hungry. And B-Man, there are tons of gluten-free options for Wildgrain. I know I say it in there somewhere, but it goes by fast. There are tons of gluten-free options for there because I have sent lots of gluten-free things to my gluten-free friends and family. So if you are interested, absolutely go check it out. It has been a godsend during trial. And that was a much longer sidebar than I anticipated, honestly. I don't understand why they are spending so much time at sidebar with this expert over the basics.
Yes.
This expert's
Did you
there
undertake
to evaluate
review,
Dr. Welcher.
Analysis and testing that was done by Aperture as reflected in the PowerPoint that you reviewed, as well as the report that you received?
I did, yes.
Did ARCCA, yourself included, undertake testing based on your review of the testing by Aperture?
We did, yes, sir.
Okay. Tell me, what was the biomechanical analysis? That's the second point on your PowerPoint. What was the biomechanical analysis that was undertaken after you reviewed the Aperture reports and Aperture testing? What did you undertake to do?
So I touched on this yesterday a little bit. A biomechanical analysis, there's certain steps
I'm a
that you
biomechanist.
have to do
I did biomechanical
to actually perform a
things.
biomechanical analysis. First of all, you have to determine what the injuries are. What are the diagnosed injuries? Second, you have to determine what happened to the individual. So in this case, what would have happened to Mr. O'Keefe? His kinematics, how would his body move? Was it contacted by anything? Was it contacted by the Lexus? If so, what forces were produced
how did that happen?
on the arm, on his body? Were they sufficient to cause the injuries that he sustained? And in this case, it's a little more involved.
Right.
We have, was he hit by the car? What happened after that? Did he somehow move into the yard? And then did something happen in the yard to actually cause the skull fracture? So in order to determine if that's what actually occurred in this case, you have to look at each of those 3 separate events. And you have to evaluate that from a biomechanical analysis by looking at the force, looking at the kinematics, looking at a human tolerance, and determining or attempting to determine what happened. Now,
Determining or
if you
attempting
try to determine what happened, not only do you have to prove that that was the case and the facts support that that's what occurred, you also have to eliminate all other possibilities. Because if you're saying this is how it happened, not only do you have to show that that's true.
So next question, and I'm going to strike that. Next question.
Is there an element of differential diagnosis that goes into biomechanical analysis?
There is, absolutely.
Explain that for us, please.
Let me demonstrate. So there are several peer-reviewed articles that I reference.
Is this slide number 2, by the way?
This is slide number 2.
Thank
correct.
you.
Right.
This is injury reconstruction, biomechanical analysis of accidental injury. And that sets forth the methodology that I just described. It's well written about, well reviewed in peer-reviewed articles. This is the method you need. If you're going to opine on biomechanics, this is the method you need to do, the steps you need to go through in order to provide an actual opinion.
Look at that.
And describe
It's like
that
there's a
method just a
way.
little bit further. Does that include testing?
That includes testing.
Does that include both lab testing and field testing, if it's possible?
Absolutely. Yes.
Explain that.
In fact, let me explain. Let me get through here. You know, I just had a couple examples here. This third slide.
He's like, I'm trying to
another
explain, but there's no
reference
text on
about
the slide,
biomechanical
so
analysis.
we got a little lost.
Again, it's all throughout the literature, very well established how to do this. Now, it's all based on the scientific method, okay? And the scientific method, which you know, it was really established back in the 1620s, but this tells you how to do a proper scientific analysis.
I like that he was like, I mean,
So
we could go
you
all the
have
way
an
back, but we're not
observation,
going
you observe
to.
something. So in this case, you might say, all right, there's superficial abrasions to Mr. Keefe's arm, and there's a shattered taillight. Are those two things related? Well, the first thing you do is you research the topic area. You look through the literature. You find or look for any examples of that happening. You see if there's any reports or peer-reviewed articles written about this very occurrence. Can you actually demonstrate that if your arm hit the taillight would shatter and cause those abrasions? If this
Right.
occurs or is a common occurrence, it should be in the literature. You should be able to find
Yeah, if
information
this is
about
something
it.
that happens a lot,
Then you form
it'll
a
say.
hypothesis. Either you say, I think this injury is related to hitting the taillight, or it's not. Whichever one you choose, that's where you then start
scientific
to go
methods.
into your
I have questions.
experimentation.
And then
you have
testing.
to develop tests to get data to
just
actually
have
back up
questions.
your hypotheses.
Just stick with
So if I said, well, I think the injury is related to it, what would you do? You would go and you would test it. You would get an arm. In this case, we got a hybrid 3 dummy arm, and we got an exemplar vehicle, and we hit the vehicle with the arm. Or we hit the arm with the vehicle. We ran into it to determine what's going to happen when that occurs. Do we get the right
I
circumstances?
know what they mean by they hit the car with the arm, but don't you just picture somebody holding the arm and just beating the car with it at this point? It's just been such a long trial. But yeah, they said, how do we test this? We're not going to run into a person. That's not what we're going to do. We're going to get a arm that has sensors on it, and then we're going to do that. And the fact that they could get an arm with sensors on it and the exemplar vehicle and do all of that for well under $350,000 also makes me wonder, what the fuck was Aperture spending all that money on? Why were they paid so much? What were they doing?
The right loading to actually occur in that case. So this, and then you go back and you analyze that. And if your results don't match up with your hypothesis, you have to reevaluate. You have to go back and see if we don't get that type of injury, if we don't get the kinematics or the force associated with what we see, you have to reevaluate if your hypothesis or what you think happened is actually true or not.
Right.
So you have to continuously go through this process. And that's what experts do. That's how you perform an analysis. And that's what's important. You know, I have 3 kids. I have a 9-year-old who's actually...
So I'm going to ask you to wait for the next question.
Okay, sure.
Was there an example that you could use of sort of a real-world example that you might want
So there was an objection, and Jackson's just going to ask him a question and let him say the exact same thing.
to use to explain some or part of the scientific method?
There is, yeah, and I would like to
I have 3
explain an
kids.
example of
Right.
what's important with that. So I was going to say I have 3 kids, a 9-year-old.
As I was saying before, Brennan interjected story time objections.
Who's actually turning 10 today. Happy birthday, Kai. And I have 2.
Dad's on TV. Happy birthday, Kai. Well, happy birthday to Kai. We're just going to sit and watch your dad talk about this trial. The chat, all 30,000 of you are like, happy birthday, Kai.
2 older ones.
All right. We're going to stop this. Another example.
Go
We're
ahead.
going to stop this.
Less editorializing.
Minus all the personal.
I'm sorry, Your Honors.
Go ahead.
Details matter.
Details do
Okay?
matter.
Details in an investigation matter, and details matter here. You need details. You have to explain how things happen. Okay? You, as an expert, I can't come in and just say,
Sustained. It needs to be more question and answer.
Why?
Why do details matter?
Because your opinions have to be based on the facts and the evidence.
Why is that?
Because that's what determines your conclusions. I can't come in and say, I think.
Next question.
What if you don't have all the details and facts?
If you don't have detail.
Every other expert has testified at the beginning of what they were doing, why they did in narrative form. It's very common for experts to testify in a longer narrative. What were you doing? How were you doing it?
If you haven't performed a proper analysis, then you can't come to a conclusion that something happened. You can't depend just on your experience. You have to have the analysis, the evidence, and the details.
And
to
Brennan
come to
is
a
going to
conclusion in a
object
case.
to
How do you
everything,
best get details
which
to
we've
come to a conclusion in a
seen
case?
clearly.
You need research. You need peer-reviewed articles. You need evidence. You perform testing. You have to demonstrate what you think happened is A, possible, and B, actually did occur. And in order to do that, you need hard evidence to demonstrate that that's what actually occurred in this case.
Do you get that through both lab testing and field testing?
The form. Ask it differently, Mr. Jackson.
Can you get that in lab testing?
Absolutely.
Can you
wasn't
get that in
leading.
field testing?
You can get that in field testing as well, yes.
Are those integral to an analysis?
They are. If you don't have any other evidence, if you don't have research, if you don't have peer-reviewed articles showing or demonstrating what happens, you have to formulate, you have to get that evidence. And the way to do that is through field testing, if you have no other evidence and no other source of information to provide that type of evidence.
He's trying to explain why
go to
they
the
did the
next
field
slide.
testing. This is why they're doing the field testing.
Did you undertake, and this is a placeholder, did
Yes.
you undertake the scientific method in this case?
I did, yes.
What was the hypothesis of the incident that you utilized in furthering your analysis?
So the first step, the first part of this event is contact between Mr. O'Keefe's arm and the vehicle.
Could you describe for the jurors what hypothesis you used based on your review of the information you got from Aperture?
Sure. So the hypothesis that I looked at, Aperture, their testing and report indicates that Mr. O'Keefe had his arm out at a 90-degree angle.
Sustained.
What do you see? By the way, where are these from? These two slides.
These two slides are
What hypothesis did you review? Excuse me. This is the hypothesis they reviewed.
from the PowerPoint presentation that Aperture provided.
All right. So you didn't create these?
I did not, no, sir.
Describe the angle of the arm in the left photograph with the drinking glass in the hand.
So the angle of that arm is approximately 90 degrees. The other photographs in the PowerPoint demonstrate that for someone the same height as Mr. O'Keefe, the arm would be at about 90 degrees with an individual standing erect. That's what was demonstrated in their PowerPoint.
Do you note anything in their PowerPoint, the Aperture PowerPoint, related to the clothing worn in that left photograph?
Yes, they have the surrogates wearing a hoodie or a sweatshirt, which is the exact same type and brand that Mr. O'Keefe was found wearing at the time of the incident.
Did that play a part in your overall analysis, the fact that the individual, the surrogate, as you use the name, was adorned with the same type of sweatshirt that was found on Mr. O'Keefe?
It did, yes. I mean, that's one of the details that we have to look at. Details matter, so we look at the clothing that was worn and the evidence found with respect to that actual sweatshirt.
I'd like to stay with that for a second. Why is that important? Why would the clothing matter?
Well, because that tells us, that gives us evidence of what may or may not have occurred. Mr. O'Keefe was wearing this sweatshirt when the time of this alleged incident occurred. So if there is contact between his sweatshirt and that rear vehicle, the taillight from the Lexus, there would likely be evidence of that. And we have to look at that sweatshirt to see the condition of that sweatshirt, if there's evidence on that sweatshirt, and be able to pair that or match that up to with what happened on the vehicle.
Is that part of a normal biomechanical analysis to evaluate clothing of the body as well?
Absolutely, especially when you look at automobile pedestrian impacts.
Why?
Because clothing tells you or can tell you how the impact occurred, where contact occurred between an individual and the vehicle, what part of the vehicle, what part of the individual. So it either may or it may not, but it can give you very important clues about what may have occurred during the incident.
Is that part of the normal methodology that's utilized in the field of biomechanical analysis, especially as it relates to pedestrian motor vehicle incidents?
It absolutely is, yes. Look at the damage to the clothing. Look if you compare it up to the vehicle, to the ground, to other sources. It's another tool, another
It gives you more
detail and
info.
part of the evidence that allows you to try and determine what occurred.
Do you have experience in reviewing?
It's also another point of matching, right? The hiccups are going to get me. Excuse me. It's another part of matching because it's not just injury to the body, it's also damage to the clothes. So you have more points of comparison.
Clothing of individuals that may have been involved in vehicle pedestrian incidents.
I do, yes.
How often has that played a part in your biomechanical analysis and the methodology that you employ?
It happens quite often when we look at automobile pedestrian impacts. That's really one of the steps that you need to do. You need to look at the clothing, you need to look at that evidence and see if that matches up with any other evidence in the case.
Would it be a proper methodology to just ignore the clothing in a vehicle pedestrian incident?
It would be, yes. I mean, it's really one of the first things you should do.
I'm sorry, my question was, would it be proper if you just wholly ignored it?
No, it would be improper. It would not be proper. It would be improper if you just ignored it.
Getting back to the slide at hand, and we're on slide, just to stay coordinated, is this slide 7?
That is correct, yes.
Okay. You've talked about the left photograph. What is the right, the short video?
So this short video is what I refer to as the paint transfer test that was performed by Aperture. And what they did was take a surrogate the same approximate height and weight as Mr. O'Keefe and had him stand behind a subject, an exemplar Lexus, the same year, make, and model. And they put paint on the rear taillight cover on the fender, and then they backed it in to the surrogate's arm. And the reason for this is they attempted to show that where the paint contacts the arm, that it's the same area where the superficial abrasions were on Mr. O'Keefe's arm.
Did you utilize these photographs and videos from the Aperture report in conducting and building the field testing and or the lab testing that you ultimately undertook?
I did, yes, sir.
Can we go to the next slide, please? What's depicted in this slide?
So this is from the Aperture report.
I just want to see the slides.
And,
Okay, good.
and the third conclusion is that the location and orientation of the lacerations on John O'Keefe's right forearm and arm are consistent with the geometry and the orientation of the right taillight on the Reed 2021 Lexus LX57.
How did you interpret the phrase geometry?
To me,
I don't
geometry
know.
just means shape. So the way I interpreted this is the one test that was performed with respect to the taillight. This is the only test I saw that Aperture performed involving the taillight and the arm, is that with this paint transfer test, they concluded that, again, the area where the paint was transferred onto the arm is consistent, the same shape and orientation as apparently the lacerations found on Mr. O'Keefe's forearm.
Did this test, in your opinion, establish
And yes,
force multipliers that were
everyone has said
exerted
abrasions, not lacerations. Yes, yes, but that's what's in their expert's ultimate opinion.
on the taillight?
Their Commonwealth.
It has nothing to do with force. It doesn't describe the force exerted on the taillight or on the arm. It doesn't describe how the arm would have moved as it hit the taillight. It doesn't describe how the taillight would fracture. It doesn't describe how you would actually get the lacerations on the arm. Again, all this does is generally, and I made an error there. This report, and you can see the slide says laceration. Mr. O'Keefe did not have lacerations on his arm.
Ding, ding, ding.
He was,
What did he have?
he was diagnosed
Abrasion.
with superficial abrasions.
Is there a difference between a laceration and an abrasion?
There's
Yes!
a distinct difference, both biomechanically and medically, yes.
Is that an important distinction?
That is.
Why?
The first step of the biomechanical analysis is identify the injuries, and you have to take the diagnosed injuries identified by a medical doctor. So it's superficial abrasions. To put lacerations on, that's simply incorrect.
So I strike the end of that.
Would you describe the injuries on
But it
Mr.
is
O'Keefe's
incorrect.
arm as
But it is describing them as lacerations is incorrect.
lacerations?
No,
Would they be more properly described in another way?
it would be, yes.
What's that other way?
So they've been diagnosed as superficial abrasions. An abrasion occurs when there's rubbing or scraping of the skin, and it just rubs away the top layer, the epidermis of the skin. Now, a laceration is an actual a jagged ripping or tearing of the skin, which gets down through the epidermis into the dermis. So abrasions take much less force, they're less severe than what a laceration actually is.
In a biomechanical analysis, if it's done properly, is it proper to get is it important to get the proper injury to the body as a foundation to the entire analysis?
That's core to the analysis because you're trying to determine how an injury occurred. You have to know what that injury is. You have to have the correct injury to be able to evaluate it.
Let's go to the next slide. Bless you. This is a placeholder. I want to ask you a little bit while this is up. We can turn the lights up. First step of the analysis. What is the first step of the analysis after you determine the injuries, the type of injury?
So
I've seen a lot of you ask about abrasions, but the one thing that has been consistent is that all of the abrasions, to John O'Keefe's arm are superficial abrasions. Nothing punctures, nothing goes down to the deeper levels of skin. They are very superficial on the top, level of skin. And that's what all of the experts and the ME and everyone else has testified to, including the coroner that was hands-on with John O'Keefe. So yes, even though in the pictures they may look different, they are all superficial, not punctures, not deeper layers of the skin, which is important in this case because even when we had the testimony yesterday, there were times where, it's just going to be that kind of a morning. There were times where we had the ME expert Laposada say that she thought some of those were punctures, and that's different than what everybody else had testified to. So you can't just diagnose it as easily from just looking at it. You also need the reports from the coroners, and we have the coroner's testimony on that. Thank you all for the hiccup solutions. I will do my best when we get up.
So in this step, after you determine the injury, what we want to do is we want to look at the physical evidence. So we have the abrasions on Mr. O'Keefe's arm, and we have the sweatshirt that he was wearing at the time. So the first step in any investigation is to determine, does the evidence from the arm match up to the evidence on the sweatshirt?
Did you undertake that analysis?
I did, yes.
Is that indicated in a slide a little bit later on in your PowerPoint?
It is, yes, sir.
Okay. Let's go to the next slide, please. What are we looking at in this slide?
So this explains the injuries. And this is from on the left side, that is the diagnoses from the autopsy. The right side is from the hospital. And you can see it says blunt impact injuries of head and extremities, abrasions and lacerations. The laceration is on the back of the skull, on the back of the head where the occipital skull fracture is. When you look at the extremities, everywhere where it talks about the extremities is superficial abrasions. So the first step in a biomechanical analysis, you review the medical records, determine exactly what the injuries are. And you can see there's a picture of the actual abrasions. Those are the documented injuries or abrasions to Mr. O'Keefe's right arm.
Are these acceptable sources? Well, let me ask you this. What are the sources that are reflected on this slide that you referred to or you relied on in coming to your opinions and conclusions regarding Mr. O'Keefe's injuries to his right arm?
Again, on the left side is from the autopsy report from the medical examiner, and then the right side is actually from the Good Samaritan hospital where Mr. O'Keefe was taken.
Are autopsy records, hospital records, medical records acceptable sources for a biomechanist to rely on in determining or coming to opinions and conclusions?
They are the sources you go to determine what the injuries are. Yes.
Did you see? You reviewed the entirety of the medical records as well as the entirety of the medical examiner's file. Is that right?
I did. Yes, sir.
Did you see reference to any fractures that were noted on Mr. O'Keefe's right arm, either his arm, his forearm, or his hand?
No, there were no diagnosed or references to fractures on any part of his right arm or hand.
I'm going to ask Mr. Wolk to display.
Did you look at X-rays? Were there X-rays?
Yes, okay. So he's going to take over the TV screen.
Sure.
If that's okay, Your Honor?
Yes.
I guess we're taking a minute to put up the X-rays. That's fine. Okay. Apple Jam and PB said, EDB, these hiccups will be the death of me. I mean, this morning it's
yesterday.
trying to get me. My 2-month-old hiccups, I'm dying, but it's from cuteness. New Leonard Griffin says, hi. Hello, Griffin. And also the baby hiccups, they are adorable. But yes, a whole thing.
I want to say.
I'm hoping mine will just abate.
26. I may be wrong, Your Honor. I'll get the right nomenclature in just a second. This is one of the exhibits, one of 3 exhibits that was introduced yesterday. Do you recognize what's depicted on this?
That's the X-ray of Mr. O'Keefe's right hand taken January 31st, I believe.
Did you review this in furtherance of your analysis?
The X-rays. The Cannon Ice Cream Truck asked EDB if you ever had hiccups while asking questions to a witness on the stand. I did numerous trials while pregnant. There were all kinds of things that went on. So jurors tend to be incredibly patient when they can tell that you've got just stuff happening. It happens. Yep. Just
analysis.
I did, yes,
people
sir.
are human.
Was it part of the medical record? Medical records or these records?
It was a series of the X-rays. Yes, was attached. It was part of the medical records that were provided to me and that I reviewed in this matter.
Thank you. Just for the record,
look at
so
that X-rays.
This is Exhibit 229A, as an apple.
Bottom jeans.
Have you looked
boots
at
with the fur.
X-rays before?
I have, yes.
Have you interpreted X-rays in furtherance of your analyses in years past?
I have during my biomechanical analysis, yes.
Are you trained to look at X-rays and determine whether there are fractures, hairline fractures, broken bones, things of that nature?
I've been doing this for 20 years. In graduate school, I worked with surgeons and doctors to look at X-rays.
Is that part of the normal methodology that biomechanists undertake in furtherance of injury analysis?
It is part of what we normally do, yes, sir.
Would it be an important part of a biomechanist's ultimate analysis and conclusions as it relates to an injury analysis?
It would be, and especially in this case, if we're talking about impact to the arm and the hand, very important to determine, as I said, not only what the actual injuries are, but what injuries did not occur.
Right.
Would it be appropriate to come to any opinions and conclusions in an injury analysis?
Y'all have lots of questions about how come Welcher said there were no X-rays. I don't know. Guess what? He's going to be a rebuttal witness and they'll get to ask him. And if he didn't have, and Welcher might not have had the X-rays, if he didn't have the X-rays, why weren't they given to him? If he had the entirety of the coroner file, they should have been in there. And Welcher said, well, we can't really know. We just can't really know because we can't see. The bones are on the inside. Well, we can really know.
If you were to ignore X-rays, if they existed?
No. If X-rays exist, you need to review them. You need to determine what they represent and what injuries either did or didn't occur. You absolutely need to look at them.
Do you see any injuries represented or any defects represented in this X-ray of Mr. O'Keefe's right hand?
I do not, no, sir.
Can you describe what you do see or what you would expect to see if there were injuries, broken bones, torn ligaments, things of that nature, swelling? What would you expect to see?
You could actually see the fracture lines on the bones. They are evident along the hands or along the ulna and the radius. Any dislocations you see, there
You can
would be
see
a difference
them.
in the space at the joints between the
space
bones.
between?
Dislocation, then there would be increased space or even a decreased space if there's compression of the joints, the interphalangeal joints, the metacarpophalangeal joints, the wrist joint. There's no indication on these x-rays of any fractures or any trauma or any type of injury to the bones or the joints.
Can we go to 229B as in Bravo with the court's permission?
Yes.
Bravo, bravo, fucking bravo. So I can't
See
help
what's
myself
depicted in
today.
this photograph.
I can, yes, sir.
What is this?
So this is a x-ray. The forearm shows the ulna and the radius, which are the two bones in the forearm.
Do you see any defects, injury, trauma to these bones or anything?
I know how many of you work in the medical field. I am trying to move the closed captioning out of the way for all of you that want to look at these better yourself. So I'm just moving them as much as I can so all y'all can see the bones. Hopefully that helps. I'm going to move me out of the way a little bit. There we go.
Associated with those bones?
I do not. And when you're viewing this on the software to look at the x-rays, you can actually adjust the contrast. So you can adjust the brightness and the darkness, and it allows you to go through the whole range to better evaluate whether there are any fractures. This is a little bright, so when you're looking at this, you would actually decrease the contrast a little bit.
In terms of your review of this particular photograph, what did you note in terms of trauma or injuries at all?
I did not note any indication or any signs of trauma or injury to the forearm or to the wrist in this case.
If we could go to 229C as in Charlie, what are we looking at in this photograph?
This is the right humerus, the right upper bone of Mr. O'Keefe's right arm.
Do you notice, or did you note, did you review this in furtherance of your analysis?
I did, yes, sir.
Did you note any defects, trauma, injuries at all with regard to the, I'm sorry, the bone is the
humerus.
The humerus?
I did not, no, sir.
What about the joints associated with the humerus, top or bottom?
I did not note any injuries or damage to either the elbow or the shoulder joint.
What is your opinion and conclusion, having reviewed all three of these x-rays, with regard to the condition of Mr. O'Keefe's right arm, starting from the arm, the forearm, and the bones in the hand?
There's no indication of any type of acute injury from the x-ray to Mr. O'Keefe's right arm, either his hand, his forearm, or his upper arm.
Thank you. We can switch that back. And if we can go back to your PowerPoint.
And as noted by many of you in the chat, and Kay Micken, the x-rays say 131. That is when the autopsy was done. So,
Can we go to the next slide, please?
preparing for Mountain Life, said EDB, if the defense knew there were x-rays, why did they not challenge Wrenchler? Strategy. For this, for these moments, unless the defense did not have them and had to go get them from Dr. Scortibello at some point, we don't know. I imagine these have been in the coroner's file since the first time. And they also knew that Wrenchler would be back. Remember, the defense was fighting over Wrenchler's testimony getting split. They're allowed to say, fine, we'll wait. Because if they had questioned Wrenchler about it, he just would have been like, no, they don't. Isn't it more powerful to have them come in with the defense experts who are friendly? So they're just showing the jury that they exist. Because all of us went, wait, what? Now there's x-rays? That point might have gotten a bit lost in the cross-examination of Wrenchler because there was so much else going on. Yep.
Maybe. Let me see if I can start back on it here.
It seems like he is looking for the part of his PowerPoint that they're switching back to.
There we go.
What are we looking at in this slide?
So again, this is the hoodie or sweatshirt that Mr. O'Keefe had on at the time of this alleged incident.
Did you consider these photographs in conducting your injury causation analysis?
I did, yes, sir.
What role did these photographs of Mr. O'Keefe's hoodie play in your injury causation analysis?
So this shows the hoodie, and it was inspected by the police department, and it was noted, as you can see on the right sleeve by the triangles, there were 9 different punctures or holes noted in the sleeve of the sweatshirt.
Can we go to the next slide, please? What are we looking at in these series of photos?
So let's come to sidebar for a minute and Mr. Jackson, bring your PowerPoint, please.
They went through the PowerPoint yesterday. They went through the PowerPoint extensively yesterday, but getting into the injury is the wrong word, getting into the damage to the clothing is something that the court had discussed with counsel yesterday. And what, if anything, this expert will be allowed to testify to regarding that? That's an exceedingly long sidebar.
Number is this?
So we're going to back up as we skip that sidebar.
Jurors, I apologize that took so long, but it was necessary to do rather than sending you out. So, sure.
I apologize that took so long. This gets in. The thing is, I don't think he was there yet with asking. He was asking about what you looked at in the hoodie and not testifying about how it matches up with any injury, but did you use this information? And he said, yes, I used this information. We weren't even to the point of any type of matching or anything like that. It's just, is this a part of your evaluation? What did you look at? And they're allowed to testify about what they looked at. It's part of the info gathering.
Okay.
I am looking at questions so I can answer some of them as quickly as I can. Gail Jean
Dr.
16.
Wrenchler, my eyes aren't good enough to.
I pulled it up as fast as I could. Are the experts allowed to talk to each other? Not during trial. There's a full sequestration order for all of the experts, which also is not common. Normally, the experts can watch the testimony of the other experts, etc. But in this case, no, they cannot because of the order from the court.
See the upper right-hand corner. What slide number is this? That's
Number 12.
Number 12. Thank you. Did you look at these photographs and consider these photographs in furtherance of your ultimate conclusion?
I did, yes, sir.
Can we move to slide 13, please? Did you also look at and consider these photographs in coming to your ultimate conclusion?
I did, yes.
Can we move to slide 14, please? Did you look at and consider these photographs in coming to your conclusions and opinions regarding this case?
Yes, sir.
Can you move from slide 14 over to slide 18, please?
Can I switch through real quick?
Sure.
Yep. So we 18.
Let's go to 18. What are we looking at in slide 18?
So this is Mr. O'Keefe's right arm at autopsy, and they're holding up a ruler to demonstrate the size and dimensions of the abrasions.
And what are the yellow indicators?
Those are indicators I added based on the length of the ruler to show the approximate size, length, and width of those abrasions.
Was it important in your biomechanical analysis to measure and denote all the injuries?
It was, yes.
Did you actually count the number of injuries on Mr. O'Keefe's arm?
I did, yes.
How many injuries did he have? How many distinct and separate injuries did Mr. O'Keefe's arm present?
Conservatively, I counted 36 different superficial abrasions on his right arm.
And did you go through all the photographs in an effort to count and distinguish one abrasion and one defect on his skin from another?
I did.
For me, that close-up, which was a slightly different photo because we had the scale down there, it's easier to see that those are superficial in that next photo. And the jury will have all of the pictures. It's helpful to see the different angles.
Did, yes, sir.
And you said conservatively 36 separate abrasions, correct?
That's correct.
What does that mean in terms of the mechanism that you would expect to cause that abrasion?
Well, you need 36 different points of contact with to get through the sweatshirt and get to the skin to actually cause abrasion to the skin. 36 different separate points of contact to the skin.
How many defects, remind us, how many defects were noted by the crime lab in Mr. O'Keefe's right sleeve?
9 defects.
Can you scroll to slide 22 quickly,
And that's
please?
how Jackson asked the questions around what the court had said.
What is this?
How many defects to the sleeve?
This
but what do you
is
see
a
on the
slide,
arm?
again, from Aperture, from their PowerPoint. It's the only slide, the only photo, the only indication of the hoodie that I found in their analysis. And it also has pictures showing, looks like they try to line up the top of that taillight cover.
Sustained.
Do you see there's some sort of marking on that lower left photograph with some yellow lines?
I do, yes.
I do.
How did you analyze that marking?
I analyzed that. It goes through the part of the taillight cover and then goes through part of the upper arm of the surrogate.
And there's a parallel line to it a little bit in a V shape. There's a parallel line below it. How did you analyze that line?
I analyzed that as apparently showing that the area of the taillight.
So not apparently. What did you
How did you
analyze?
interpret that?
I interpreted that represents that area of the taillight corresponds to the area of the upper arm.
And there's a red dotted line around the tail light, correct?
Correct.
How did you interpret what that represents?
That was the part of the taillight that fractured.
Did you put any of these lines on there, or are these all from Aperture?
These are all from Aperture. I did not put any of those on there.
You see the small, it's horizontal, I'm sorry, it's vertical photograph of Mr. O'Keefe's arm?
I do, yes.
Did you note anywhere in the Aperture report a denotation of the number of abrasions, counting the number of abrasions on Mr. O'Keefe's arm?
There's no denotation, no indication that the number of abrasions were ever counted. No, sir.
Ultimately, based on your review of and all of your testing, did you come to an opinion or a conclusion as to whether or not the abrasions on Mr. O'Keefe's arm are consistent with striking the right rear taillight of the Lexus?
I did, yes.
And what is that conclusion?
That they're inconsistent with striking the taillight or being produced as a result of contact with the taillight.
Why did you come to that conclusion?
And that's
There's a number
his
of reasons
opinion, right?
that I came to. First of all, the abrasions, the numbers don't correspond to the number of holes or.
Sustained.
Did you consider, without counting the number of abrasions and the number of holes, did you consider the abrasions?
I did, yes.
Did you consider the sweatshirt?
I did.
Was that an important part of your analysis?
It was, yes.
What else did you consider?
I considered that it was not possible to line up 36 different
gonna say it again.
abrasions with
So I'm going to strike that answer, ask it differently.
Your Honor, if he could finish his answer. He was about to say contact with the taillight.
Yep, so ask it differently, Mr. Jackson.
Sure. What did the 36 abrasions, conservatively, and their interaction with the taillight have to do with your ultimate opinion and conclusion?
Well, that you have to, if those abrasions came from contact with the taillight, you have to be able to correlate them and line them up with contact, 36 different contacts from the taillight.
And ultimately, based on your understanding of Aperture's review and the photographs that you saw, you were presuming, based on Aperture's testing, that Mr. O'Keefe was wearing that hoodie. Is that correct?
Sustained.
What was the condition let me ask it this way. There's a photograph in the Aperture report that we're looking at with blue paint on an arm, right?
Correct.
Is that your understanding, or did you test that Mr. O'Keefe could have been hit wearing short sleeves?
No.
What did you test? What was your presumption and assumption in your testing?
That he was wearing the hoodie that was found on him at the time,
With the 9 holes in the right sleeve.
with the 9 holes in the right sleeve.
Watch the form of the question, Mr. Jackson.
Sure. Let's go to the next slide, please.
He's trying.
What is this?
And oftentimes
These
Jackson will
are,
push it. He's not pushing it with this witness from what I'm hearing with y'all. He's trying to step around the answers that the court is having issues with. But part of his analysis was looking at the clothing, looking at the injury to the arm, and trying to figure out how those two things correlate. And then looking at the testing done by the other company and trying to figure out how that all correlates.
The top two, and
But also, I think the more objections there is to it, the more that you can tell what his point is, because it just keeps coming up over and over and over again. So it really just highlights the point when there's constant objections to, I'm trying to figure this part out. And the jury's like, yeah, I want to know too. Like, now the curiosity is just raised.
and bottom right slide are from the Aperture PowerPoint.
How did you interpret the the two photographs on the right, the parallel lines and the red lines in that slide?
The parallel lines correspond to an area of the fractured tail light, and then the red dotted line corresponds to an area of abrasions on Mr. O'Keefe's upper arm, and there's a red arrow pointing to part of the fractured tail light.
Can we go to the next slide, please? What are we looking at in this slide?
Again, this is the paint test. This is the only test that was conducted by Aperture to look at the tail light and the arm in this case, and the interaction between the two.
Did you note whether in all of Aperture's data that you reviewed, whether or not there was any measurements to determine whether the abrasions were consistent with contact with the Lexus?
I did. There were no measurements at all taken with respect to that test. No measurements with respect to where the contact happened on the car or on the arm.
Aren't engineers like a big fan of measurements and numbers and stuff?
Itself. There
My
was
bad.
no indication of where that blue paint extended on the surrogate's arm, say from the wrist up to where the laceration or the abrasions would have occurred.
Is that important?
That's very important,
Why?
because you can't say that the area where the blue paint is corresponds to the area of the abrasions if you don't take measurements. If you just eyeball it, all you can say is by eyeballing it, it looks approximately the same. But that's not scientific. You can't come to an actual conclusion that where that paint covers the arm is where those abrasions actually were. They
Right.
could lie outside, they could lie forward, they could lie above that painted area. You can't say with any scientific certainty that that area of paint corresponds to where the abrasions are.
In this motion video and the still photograph to the left in slide 24, is that what we're on, 24?
We are, yes, sir.
What did you note with regard to the positioning of the surrogate's arm? I think that's Mr. Welcher, as it relates to the taillight and the back of the SUV.
Yes, the positioning of the arm in the photographs as well as the one test that was performed, the arm is approximately 90 degrees, level, in line
Right, that's
with
how they
the rear
tested it.
tail light of the vehicle.
Did you seek to do any testing approximating the positioning of the arm as you saw it, as you interpreted it in the Aperture data?
I did, yes, sir.
What were you seeking to determine when you did
They're
your
just going to
testing?
keep letting that thing loop
Well,
like a GIF up there. And I wonder if letting it loop is intentional or if it's just on an autoplay. But I think we will see the Welcher testing and the Aperture testing back to back, or the Welcher testing and the ARCCA testing back to back. Look, everybody with the W last names, even though Wrenchler spelled with an R, it still sounds like it's a W. And the Aperture and the ARCCA, it's just the letters are too much 31 days into this trial. But we're going to see the differences in the testing, and then we're going to hear what Brennan get up and say, but you used the 50% arm. Okay, your expert used his own arm, and
If we want to determine whether the orientation and the position of the abrasions on the arm correspond to the tail light, you have to have the arm in the position that you claim it struck the tail light and then look at the abrasions. Because if you're looking at orientation and the direction of the abrasions, you can't look at how they exist with the arm. The only pictures of the arm of the abrasions are with Mr. O'Keefe's arm extended. But that's not how he would have had it according to the test. It would have been at a 90-degree angle.
Dr. Rentschler, were there any peer-reviewed articles cited in connection with Aperture's paint transfer test?
I did not see, I was not provided a single peer-reviewed article with respect to the paint test or any indication of any test or article looking at arm contact with the vehicle or a taillight cover.
Can we go to slide 25? What are we looking at in this slide?
So in this slide, the picture on the far left is the photographs provided from the autopsy in hospital with Mr. O'Keefe's right arm fully extended. Again, those are the only photographs we have.
What about the photograph in the middle and to the far right?
In the middle and the far right, what I did was actually take that arm and then rotate the forearm to put it in a position that it would be in as demonstrated by the paint test with the arm at approximately 90 degrees.
What was the import of this this undertaking?
well, because
Well, if you look at the paint test and the way the arm's in.
okay, look, I appreciate what he's doing. Here's what's interesting about this. Any of you tried to do like a wing liner, depending on your eyelid, sometimes you know how it just skips. If you have more of a hooded eyelid, I have more of a hooded eyelid. And if you try to do the wing liner, it skips and then you move. Right. It's the same thing. If the arm's bent, you've got one of the injuries to the arm underneath the arm because of the way the arms bend. So it's really interesting watching them talk about, well, if the arm was bent at a full 90 degrees, you wouldn't have that injury that gets kind of tucked under. It's an interesting way to illustrate it. I love all of you that said that's girl math. It's 100%. You know how you're trying to do a winged liner and it skips because of the way the skin folds? Right. Right. So it's interesting to see when you look at the arm more bent, that the arm would need to be more dynamic to have the types of injury that they're talking about here.
90 degrees and having
Really
the car come
interesting.
and essentially contact and push the arm out of the way, that's going to give you or tell you the directionality or the direction of the abrasions. Because if you have your arm at a right angle and the vehicle comes and pushes and slides against it on that forearm, you would expect those abrasions to be horizontal, to be in line with that forearm.
Are they?
They're not. You can see some of them are vertical.
Which is also a good point. If the arm was oriented at 90 degrees, you would expect all of the cuts, just hang with me, arguing that these are all from the taillight, you would expect them all to go the same direction. And I would think the direction is the one on the bicep. You would expect them all to go that same directionality.
Some of
It's a
them are
good-
angled. Some
it's
of
a
them it's
good
hard
demo.
to tell what the directionality is. But if your arm, again, is being struck and pushed this way, as it's pushed and as the car goes by, if this would occur in this manner, you would expect those abrasions to be horizontal in the direction that the vehicle is actually traveling.
When you say horizontal,
I think that's really helpful testimony. Look, they say it's at 90 degrees. Okay, well, let's look at it 90 degrees. Shouldn't, if it's all glass coming this way or all tail light coming this way, shouldn't all of the injury go in the same direction? you've got to show it to the jury so they can visualize it. I think it's a really, really helpful
So
slide.
do you mean horizontal from the elbow to the wrist?
Correct, or parallel, yes, with the forearm.
Can we go to slide 26, please?
It's a really good visual.
This is yet again the same video that we saw earlier.
That is correct. This is the paint test video, yes.
And what has to happen in order for the paint in this test to reach the upper forearm?
Well, in this case, to reach the upper forearm, there has to be contact between the forearm and the taillight cover.
Can we go to the next slide, please? What is this slide showing?
Again, this shows, you can see on the right, I added arrows to kind of show the directionality
move me out of the way a
of
little
the
bit.
different abrasions. And on the forearm, they simply do not line up with the type of kinematic.
Does that help you all just chat writ large, visualize what he's explaining about the directionality of the injuries? Is that helpful to you? Because I find it very helpful. And after all the conversation that we've seen in this trial about injuries to the arm and what they are or are not, if they come, and the Commonwealth's theory is that these come from broken taillight. That's the Commonwealth's theory. The Commonwealth has to prove that these are consistent then and come from broken taillight. But if they come from broken taillight, how are they all going in different directions? And that's why there is a rebuttal expert. Because the Commonwealth didn't say these are road rash and they came from hitting the road. Because if they were road rash, what would you expect to see? Different types of defect on the hoodie. Right.
Or the type of motion shown in the paint test. Again, of the arm getting pushed out of the way and the car traveling past. If there were going to be abrasions from the fractured glass as it moves along, again, it would be lengthwise parallel to the forearm.
If the arm was positioned as it was indicated in the paint test done by Aperture, would you expect to see this pattern of injuries on Mr. O'Keefe's arm if, in fact, it contacted the taillight and if, in fact, it was abraded based on the taillight?
You would not.
We wondered
you can't
if
get,
we wondered
for instance,
if
horizontal
ARCCA would be the last witness.
abrasions on the upper arm and somehow get vertical and angled abrasions
And they are, and this is
on
why.
the forearm. The kinematics don't work out to actually produce those types of injuries.
Can we go to the next slide, please?
And this is why ARCCA is the last witness.
What are we
right?
looking at in this slide?
So again, this is the paint transfer test, and it demonstrates there were no measurements taken, so we don't know the exact size or location of that paint or of the lacerations. And you can see the photograph on the right basically shows that after doing the test, a picture of the right arm was put next to it and basically eyeballed to say
Good
it's
enough?
the same. Well, it's only approximately the same area.
Close enough? Right.
So I'm going to strike that. So next question.
Do you see any measurements?
But that's
any
what it
tape
was.
Measures, any laser measuring equipment, anything like that? in
It was
that right
eyeballed.
photograph?
Nothing. No types of measurements whatsoever.
Can we go to the next slide, please? This is on the left, the same video that we've seen several times, correct?
That's correct.
What are we looking at on the photograph on the right?
So on the right, it is the video of this test taken from the side of the vehicle.
Did you notice anything of note in this angle of the paint transfer test?
I did. I slowed this video down, and so as you can see, as it starts out, and you'll see the vehicle starts to slowly back. So there was no photographs showing the position of the arm in the back of the car. The video is from the side, and the top video, you can't tell where the arm is positioned against the tail.
That's a really good point. Because he looks much further away from the car in that side photo than in the top-down photo.
Tailgate. But whatever positions it's at, you can see as the car backs up here, look at the elbow and the upper arm. If the car backed directly in this direction, there would be no contact with that elbow or the upper arm. And remember, this test is to show where the paint would transfer and if that correlates to the lacerations.
You mean before you start the video, when you say there would be no contact with the elbow or the upper arm,
Like if the car's
you
going
mean
straight back.
the biceps area and from the elbow up?
That's correct.
He's
Is that
not-
based on the photograph on the right and the positioning of the surrogate?
Exactly. You can see right now, if the car just backed directly straight back, it would not contact the elbow or the upper arm.
Right, because
Before you
he's
play
just...
the video, what did you note when the
Does he step
car
into it?
From the angle to the right of the video on the right? What did you note as the car, just before the car starts to make contact with the surrogate? What did you note?
So in order to get that pattern on the arm, right as the car contacts the arm, the surrogate pushes his elbow forward, leans into the car against the light, and then rolls off.
Can you play that for us, please? Did you see what you were describing in that video?
No, I didn't.
I did.
I didn't see it. Can we run it back again? Can we run it back again?
And I can slow it down. So you can see even...
This is why you don't use humans. This is why you don't use humans. I was teasing when I said I didn't see it. I wanted to see it again. I was being facetious. I wanted to see it again. A number of you talked about this when this witness was on the stand in the chat. So if anyone wants to go back and watch the live chats are up on the replay crew. A lot of you were like, why does it look like he leans into it? And they didn't ask about it on cross at all. I was waiting to see if the defense would ask about it on cross. They didn't. This is why they didn't. Because why let the expert explain it when you can let your expert explain it? And this expert was fighting so much with the lessee, the point would have gotten lost. I think the point is much more highlighted now. So when you make those strategies, you have to know what your witnesses are going to do down the road. And so you see the strategy of what is asked and what is not asked. And there are some things you don't ask because it's going to come up later. And we know the defense was frustrated that Wrenchler gets to come back. Why give Wrenchler time to think about it when asking him on cross if he's going to come back in like a week? Wrenchler is not supposed to have any conversation in the meantime. So if he comes back with an explanation about this, that he tries to slip into an answer, it's going to become really obvious that he was watching or not. But why give him a week to think about it?
Even at this point, as the car approaches, it would not contact the elbow or the bicep.
I mean, you
So
can see where he's standing.
as it comes in, watch the elbow. All of a sudden, shoot in. Surrogate turns his arm in and then leans against the light cover. So
I would be very interested to see the overhead and the side running at the same time. Do you think slowing this down this way is helpful to the jury? Is it helpful to you? And I would be very interested to see if you have the hoodie on, would the hoodie shift? Because clothes move. And slowing it down that way, why are they doing it? Well, because there's no injury to John O'Keefe's feet, shins, hips. There's no injury. So he can't be standing closer to the car. because otherwise you would get injury to his feet, shins, legs, knees, hips, and that's not there. I'm going to just back that whole thing up again and let him go on to the next natural question, purely because I want to see it again. Also, once again, if you ever feel like you're asking for too much money at work, you feel like you're overcharging for the things that you do, you feel like maybe you're not qualified to go for that promotion, I would just like to take this minute as my friendly law nerd reminder. You are underestimating yourself. This company charged $350,000 to do this experiment, held out one of their experts as having a degree that he does not have, and you're over here more than competent AF, undervaluing yourself, feeling like an imposter and feeling like, well, maybe I shouldn't. You fucking should. You need to, you should. Do it. Stop it. Look at this. Look at this. The government paid them over $350,000 for this. And you're worried because you had a typo in an email that one time. Stop it. You are way too hard on yourselves. Ask for more. Because look at this. Look at this. Ridiculous. Just ridiculous. Give me the confidence of asking for $350,000. So go on, law nerds. You've got this. You're way too hard on yourself. You're way too hard on yourself.
Did you see what you were describing in that video?
I did, and I can slow it down. So you can see, even at this point, as the car approaches, it would not contact the elbow or the biceps. So as it comes in, watch the elbow.
I'm watching the elbow.
All of a sudden, shoot in.
Whoop.
Surrogate turns his arm in and then leans against the
I
leg.
really want to see them run the overhead and this camera at the same time, because I want to see if the car is like pulling the elbow forward. I just want to see them both at the same time, you know?
Light cover. So this is not indicative of someone standing there and having a car back into their arm. In order to get that pattern of pain on the arm, someone would have to stand there, and as the car approached and contacted their arm, they would have to actually push their arm forward and lean into it to get that pain pattern.
Is that, in your view, proper scientific testing?
Sustained.
And again, a lot of you mentioned the glass in the hand. The glass was broken. So if the glass was still in the hand and it broke that way, wouldn't there be injury to your hand if the glass that you're holding breaks like that?
Let's move to the next slide, please. What is this?
And so this is that same event, and you can see I slowed it down even more just so you can see the actual movement of the elbow and the upper arm to get that pattern.
Thank you. Can we move to the next slide, please? This is slide 30. And let's go to 31.
Yeah, this is 31.
I'm sorry, 31. What conclusions or opinions did you reach or could you reach after reviewing the totality of the results of the paint transfer test?
The paint transfer test, all it can show is the approximate of where the arm was covered in paint as the surrogate jammed his elbow in and rolled against the taillight cover. So it tells us nothing about what may have actually occurred, how the lacerations were actually, or the abrasions were produced. It doesn't talk about the kinematics of the arm to actually cause those abrasions. All it does is
It doesn't talk about how the taillight breaks.
Under this specific condition, if someone was to stand there and then shoot your elbow forward and lean in, you would get paint on this approximate part of the arm, because we don't even have any measurements for it. That's the only thing that that test demonstrates, and that's the only test that was conducted to look at the interaction between the arm and the Lexus in this case.
Does it make Brennan's questioning seem petty when he's like, but you used a 50th percentile arm? Because you used a human who's going to move their body. And no one's stepping into the car if they see a car coming.
Did you reach any opinions and conclusions regarding whether the physical evidence is consistent or inconsistent with the injuries to Mr. O'Keefe's right arm?
I did, yes.
And what are what's the basis?
The
for those
basis
opinions?
is looking at the number of laceration or the number of abrasions on the arm, as well as the orientation and direction of those abrasions. And they don't correspond to how the arm would interact with the vehicle if it was at a right angle and struck by the...
You know what I want? I want the entire report. We're not going to get it. Emily, just, you said ask for more. I'm just going to ask it. In my ideal world, I want to see the full reporting that ARCCA did when they were given, here's the medical from John O'Keefe. The coroner's report, the hospital report, the photos, here's the medical. Here's the photos of the car. Here's the scene. Here's the damage. Tell us what happened. I want all of it. Because it seems to me that when they were given, here's the injury, here's the vehicle, here's the scene, tell us how this happened, the answer that ARCCA came back with was, we can't tell you what happened. I want to see all of the different experiments they went through, all of the different scenarios that they considered. What happened? It's the job of the Commonwealth to explain what happened and how it happened. Not just parts of it, all of it. Not just could have happened this way. How did this happen? And a lot of you are saying, can we see it after the trial? No, because it is sealed, because it's part of the federal investigation. And unless that ever becomes public, which I don't think it will, we're not going to see it.
The rear of
And yes, for all of you saying Cross is going to be, yep, we'll see what it is.
that vehicle.
They still didn't explain how the
Do you hold that
taillight broke.
opinion to a reasonable degree of scientific certainty, Doctor?
I do, yes, sir.
I stepped right into the middle of his opinion. Apologies, sir. I want to see all of it because I want to see answers, because answers are needed.
And direction of those abrasions. And they don't correspond.
He's still in the middle of his opinion. Sorry,
Right
sir.
on.
I did, yes.
And what are what's the basis?
The
for those
basis
opinions?
is looking at the number of laceration or the number of abrasions on the arm, as well as the orientation and direction of those abrasions. And they don't correspond to how the arm would interact with the vehicle if it was at a right angle and struck by the rear of that vehicle.
Do you hold that opinion to a reasonable degree of scientific certainty, Doctor?
I do, yes, sir.
Can we move to the next slide, please? Actually, slide 33.
So the injuries don't correspond with the testing done
I may have just a moment. Your Honor.
by Aperture, is what he said. All right, and we are moving on to a different line of
Any
questioning.
of the testing that you saw in terms of the paint transfer test or any other testing that you saw included in the Aperture report and the Aperture PowerPoint presentation indicate that there was any consistency or any results that were consistent with Mr. O'Keefe's right arm being struck by the taillight, causing 36 plus abrasions to his right arm while wearing the shirt, or the sweatshirt, with 9 holes in it.
That's sustained. You have to ask that differently, Mr. Jackson.
It was compound, and then there were the 9 holes.
Did you
The point is
determine,
made.
based on the testing by Aperture, whether or not it was consistent, that paint transfer test was consistent with Mr. O'Keefe's arm being damaged by the taillight?
He just said that.
I did.
Okay, and what is that conclusion?
That does not represent that at all. The evidence from that test, again, it's only puts pain on the arm. So in no way does that determine or demonstrate how, if the arm struck the taillight cover, how the taillight cover could shatter, how the movement of the arm could interact with the cover to produce those abrasions.
Did you go, I'm sorry.
There's just no evidence of that. There's no steps taken to demonstrate how, if that's even possible, would that actually occur in a case like that? First, you have to show it's possible. I saw no peer-reviewed articles, no research data, and the only test that was done that links the injuries to the taillight cover is this paint test.
Is that the paint test in which the arm was leaned into the car?
In which the elbow was shot forward and then the arm and upper arm was leaned into and against the cover.
Doctor, did you also...
Sorry, I was muted as I was eating. I saw a number of you in the chat asking, how did we even get to the point where the blue paint test came in? There were motions about that pre-trial, and the court let it in. But there were motions about that pre-trial.
go on to further your injury causation analysis by performing impact tests to evaluate the kinematics involved?
I did, yes.
Can you describe that for us, please?
Sure. So,
And yes, chat, the court let it in without having a voir dire on the experts and their qualifications like we did with Dr. Russell. Yes, yes, yes. All of that.
one of the steps involved in the biomechanical analysis is the kinematics, the motion. So we need to look at the motion of the arm. If the arm hit the taillight cover fractured, and you got abrasions, you need to be able to show that. You need to look at how the arm would actually move if it was struck by the vehicle. I've seen no peer-reviewed articles or research to demonstrate that. So what you need to do then is do testing to look at how the arm would actually move and whether it's possible to create those conditions to actually get that injury.
Did you use an ATD hybrid 3 arm?
Yesterday I was trying to explain this to Dr. B, and I was like, the ATD, ADT, AV, SUV, I don't even know. And to hear Jackson be like ADT, ATD, same. I don't know either. I'm going to use them synonymously.
Arm for testing?
We did, yes. We used a 50th percentile male ATD hybrid 3 arm.
Is the use of that hybrid 3 arm accepted in your industry in terms of testing?
Yes, it certainly is. As I said yesterday, it's the gold standard for testing. And the arm itself is used just for that very purpose. In fact, there's a number of studies. They use the 50th percentile arm to look at airbag deployment.
Yes, we've heard.
One of the issues with airbags for the driver is it comes out of the hub of the steering wheel. So if you're steering and you're turning your car and you hit something and the airbag goes off, what happens? It blows right into your forearm, and it can actually cause fractures. We see that quite often.
Among other things.
So they perform testing with the 50th percentile arm to look at the forces and acceleration on the arm as airbags go off. Very similar to if your hand was hit by the back of the arm was hit by the back of the car and propelled forward. That's very similar to having an airbag deploy. Actually, this would probably be more severe. An airbag's almost like a giant pillow enveloping the arm, and here we have an SUV actually contacting the rear of your arm.
Quite a bit of.
Can we go to the next slide, please?
Sure.
This is 35.
Let's see, here's 35.
There we go. Thank you. What's depicted here?
So this was testing done at 15 miles an hour. So this is with the hybrid arm and suspended so that it was actually impacting the right rear of the Lexus as the Lexus was traveling at 15 miles an hour.
Was there acceleration that was noted on the arm, force and acceleration?
There was on both the arm as well as the hand, yes.
What was the result of the damage to the taillight based on this test?
So in this test, there was actually no damage.
Not just
As you can see, it catches kind of the hand and the forearm. And if you want to describe it as kind of a glancing blow, there was not enough force at 15 miles an hour on this glancing blow to actually fracture the taillight.
Is the position of this arm relative to the SUV consistent or inconsistent with the original spot that the surrogate in the paint test was standing as it related to the SUV?
It's consistent. We lined it up so it's consistent with that original location so that it would not impact the elbow or the upper arm.
We tried to
So at that
replicate what they were
position,
doing.
If there's impact to the arm at 15 miles an hour, it doesn't cause the taillight to fracture. And it's also important to look at the kinematics. If you look at the acceleration data below, that hand and arm is accelerated. The hand's accelerated up to the speed of the vehicle in about 2 to 4 milliseconds.
How long does it take to blink your eye?
250 milliseconds. It takes a quarter of a second to blink your eye. So this occurs if your hand's hit at 15 miles an hour by a car, it's going to be accelerated up to the speed of the car about 50 times faster than you can blink.
Can we
I'm
go to the
just
next slide,
moving
please?
myself out of the way from the slides the best I can. Oh, well, now we can go back.
And what are we looking at in this?
So this is lab testing at 17 miles an hour. So the housing and the cover was basically propelled into the forearm of the dummy at 17 miles an hour.
What was the acceleration that was noted on the arm?
So when you look at the arm, the acceleration here is almost 300 Gs.
What does that mean?
I would like to see a test because I thought it was a good point on cross. I don't know how much that point will resonate today after juxtaposing the two different testing, but I was also curious what would happen if the taillight kept going. They explained that the force is going to be the same. The taillight is going to, if it's going 17 miles an hour, it's going to speed the arm up to the speed the taillight's going. But it would be interesting to see a test where it keeps going. The arm's just going to move out of the way, though. So I don't know if it will really matter, but I thought it was a good point of cross when they were saying, but the car was still accelerating. Okay, so the taillight should keep going. Okay. That was me.
So, 300 Gs, if you look at weight, if you say the weight of the arm is 10 pounds,
but you can
300
see that
Gs
wrist
means there's
just
3,000
snap.
pounds of force acting on that arm.
Is that enough to break a bone?
It's more than enough to break a bone.
Is that enough to to tear ligaments?
Absolutely, yes.
What about the bones in the hand? Are those
The phalanges.
stronger or the same resistance as the bones in the forearm? Or are they more delicate?
No, the bones in the hand are, as you can imagine, much weaker because they're much smaller. When you look at the carpal bones, the metacarpal interphalangeal joint, which is basically your knuckles, they are much smaller and it takes much less force to fracture your hand bones compared to your ulna or your radius.
Let's go to the next slide, please. What are we looking at in this slide?
So this is a 24-mile-an-hour impact with the arm of the dummy contacting the rear, again, tail light. And it shows you the motion, the dummy suspended, shows you the motion of the dummy and, again, the force and acceleration. Now, that right video I put in because that's real-time video. We've been showing the low speed, but look on the right. This is the actual speed at 24 miles an hour. That's what it looks like
so
if you have your
fucking
hand
fast.
out and it's struck by an SUV.
Is the arm accelerated in this? Do the same physics apply? Is the arm
Like the real speed one is like something out of Final Destination where the car just comes accelerating out of nowhere. It is so fast. And for those of you watching trial for the first time, I know there's a little over 20% of you generally in the chat that haven't watched this case or saw one of the docuseries and were like, what do you mean it's going to retrial? None of this was in the last time. This testing hadn't been done. The Commonwealth had a completely different expert. The jury didn't have these visuals of what could or could not happen based on, gravity and physics and the injuries that we see. And so all of this is new this trial, which is really interesting to see how the defense is using the additional testing as a rebuttal to the Commonwealth's new testing with the blue paint. The Commonwealth explained it better this trial than last trial, but I think so are the defense experts explaining it better this trial than last trial. Everyone has a bit more leeway is not the right word, but based on the way the Commonwealth brought in new experts, it gave the defense the ability to bring in the experts in a different way. So this is all being presented very differently to the jury. And I think the recreations are helpful. We saw that in the Gwyneth Paltrow case, how important the biomechanical engineering breakdowns were for that jury on how the ski collision happened. The question, though, this is clearly a much different case, and they are dealing with a homicide here. The questions are a lot the same in, can you explain how this happened? Here's the end result that we know of. How did we get there? And I just don't know after 31 days if the jury can say confidently, this is how we got there. So I think the testing goes a long way in that.
Accelerated up
That
to the
car is
speed of the
moving
car
so
in
fast.
milliseconds?
It is, yes. It's all about weight, right? Because you have a 6,000-pound car and you have a 10-pound arm. It's whatever speed that car is going, your arm, your hand, whatever's
Brennan's
sticking out
got
there
issues.
is immediately
Excuse
going to
me,
get.
sir, that arm is not 10 pounds. Ooh, we know what's coming on cross. That arm actually weighs 9.38 pounds. We know what's coming.
Accelerated up to the speed of that vehicle.
The video on the right is in real time. Like you said, it's sped up in milliseconds. Is that right?
That's correct.
Is the Hybrid 3 that's used in this test, is that suspended from above?
The dummy in this test is suspended from above, yes, like a pendulum, barely touching the ground.
Is the dummy connected to the ground in any way?
I mean, his name is
No,
Randy.
it's just its feet are barely touching.
What would happen if there were forces applied to that dummy that went perpendicular to the travel of the vehicle? What would happen to the dummy?
The dummy would swing out like a pendulum in that direction.
Based on your review of the test that was done, the 24
Chad, I
mile-an-hour
appreciate
test,
your
were there
riding for the
forces
honor
on
of
that
Randy.
dummy that were perpendicular to the car such that the dummy would swing out or be forced out or be propelled out away from the car?
No, there were no forces from the testing, and it's simple physics. Your center of mass of
Easy
your
for
body
you to say.
is basically at your umbilicus or your belly button. So in order to move the body, you have to apply a force at that part of the body. If your arm's struck, it's not going to move your body appreciably. All it's going to do, your arm's like a moment arm, it's going to spin you around. Could there be some motion forward or backward if you take a step? Possibly. But
Well, there's a
the
full
center of
pirouette
mass of your
happening
body isn't
on
going to
that.
move. You have to get struck by the vehicle to have the body actually move in a specific direction.
But it is,
Can we go to the
Randy
next
is
slide, please?
suspended, but there is a full pirouette.
What
But
is this showing?
Randy's foot is also
So this
run
is a
completely over.
slow-mo of the overhead from the real time. There was a GoPro that was recording that real-time video, and this is a slow motion of that video.
I'd like to ask you a couple of questions. As you see the vehicle contact the arm, what happens to the arm as it's being
Well, that's
contacted
not a
in those
natural
milliseconds
angle for
where
the
it's
arm.
being accelerated up to 24 miles an hour?
Well, the arm's accelerated up and pushed away from the body. So whatever part of your arm or body is contacting the car, that's going to be pushed forward away from the rest of your body. So not only is it loading the arm with an impact force as it strikes the arm and the hand, but then it's actually stressing the joints too. It's like imagine having a car come and 3,000 pounds of force pulling your arm forward at the elbow, at the shoulder joint. It's putting a lot of force and pressure on that appendage.
What's the G-force for
It
the
does pull it forward and
24-mile-an-hour
then
impact?
spin.
G-force, let me see
Could
exactly.
you pause that video for a second?
Sure.
Because I want to ask you a couple of questions.
Yes,
about
we're
it.
all
Let me
just
see
mesmerized
exactly what
watching
that
it on loop.
G-force was.
Do you need to refer to something?
Yes, my report.
With the court's permission?
Yes.
Thank you.
So at 24 miles an hour for the arm, the acceleration is 302 Gs, and for the hand, it's about 435 Gs.
Does that translate to over 4,000 pounds of pressure?
Well, for the arm, it's close to 3,000 if you say a 10-pound weight, and for the hand, that can be anywhere from 800 to about 1,600 pounds of force acting just on the hand itself.
Understood. Can you back this up a couple of frames?
Sure.
Pause it where I ask you. One more frame back. One more back. Right there. What's happening physically to the arm? To the right arm?
It gets
at the point
wrecked.
of impact?
I mean, I know that's
So
not the scientific
there is
explanation.
a force on the hand, on the forearm, where it contacts. Now, your arm just isn't going to hit and the force be distributed evenly across the entire part of the arm.
Can you? I
That's
need
not
you
how
to
your arm is
expand on that. We've heard a lot about load distribution, so we're gonna need to get back to that.
actually articulated. Even if it was, again, that's similar to an airbag deployment, where at these levels you would get fractures. But if it hits the hand, now, if Mr. O'Keefe's holding a glass at the time of this impact, think about that. What happens is you're holding a glass. It exposes the knuckles. So if you're holding a glass and your arm's at a 90-degree angle,
Your knuckles
and the
will
car
be more
comes back
prominent.
and hits your hand, it's going to strike
It's a very
right on
good
the
point.
knuckles. The force is going to be applied right at that joint.
That's
And
a
then
really
it's
good
gonna,
point.
Likely hit along the forearm back near the elbow.
What's the shape of that arm in this still photograph?
Arm shaped. Oh
Well,
no, it's like a
somewhat of
reverse
an
S curve.
of a normal shape, because the arm should be level with the body. The forearm should be even with the shoulder. But you can see.
I mean, has anyone watched, any UFC fans in the chat? There was a fight. Oh, I'm gonna have to call Dr. B. I think it was Anderson Silva who absolutely wrecked his leg in a kick, and it wrapped round absolutely the wrong way. And my husband and I both went, that's not the way the leg goes. Like, I will never forget watching the leg. And that's what this video is reminding me of, is watching that arm. Though Rescue Randy is, Rescue Randy, he will recover. They can rebuild him. I cannot forget us sitting there going, that leg is not supposed to go that way. It was horrific to watch. And it's the same thing you're seeing with the arm. It is wrapping around a way it's very clearly not supposed to go. And his leg was wrecked. So again, you can see it on the video, how much damage there would be to the arm. And I think that's common sense for the jury, that they can look at those stills and go, yeah, that's not going to happen. A lot of you remember that fight. Yeah, a lot of you remember that fight. And some of you are saying football injuries too. I watch less football than MMA. Emily, we find that shocking. I know you don't. I know.
As it gets pushed forward,
Emily,
it's
combat
accelerating
sports? I played water polo. Yes.
forearm away from the arm and the rest of the body.
Does that abnormal shape
He's
suggest
explaining
anything to you
this
in terms
incredibly
of what you would
well.
expect
Yes, hockey
regarding
too.
the bones in that arm?
Again, there's thousands of pounds of forces acting on the arm and also on the joint itself, not just the arm or the bones we have to consider and how much force to fracture, but think of the elbow joint and think of the shoulder joint. It takes much less force to dislocate an elbow than it does to actually fracture it.
Did you see any evidence based on your review of the medical records, including your review of the x-rays?
Having the x-rays is so helpful.
There was no evidence or indication or diagnosis of any dislocations or fractures to the arm at all.
Fractures or broken bones at all?
I dislocated my shoulder in a pool.
Can we go forward another?
There's no way there was the same amount of force as this.
And at this point, the arm has already been struck and accelerated, is that right?
That's correct.
Do you see the taillight material?
I do, yes.
Okay. It's basically now broken, is that correct?
That's correct. It has now been fractured, yes.
All right, let's go one more frame forward.
Yes, the taillight is fractured at this point.
And the taillight material, did you make note of that in this frame?
I did, yes.
What direction is that taillight material going relative to the vehicle?
It's going forward.
And where is the arm?
The arm has been
I
pushed
accidentally
away.
threw my
Now, you have to remember,
pen.
as that arm, if it contacts and fractures the taillight,
The car
it's
keeps
not
going.
exposed to the fractured pieces that still exist on the taillight itself, because those pieces that fracture haven't gone anywhere because they're against the arm itself. And then as the arm moves away, the pieces then move with the vehicle.
Are the taillight pieces upon fracture moving at the same speed as the arm upon contact?
That's correct, yes.
Is that a matter of physics?
That is a matter of physics, yes.
Is there any possible way for the broken pieces of taillight to out-accelerate the arm upon contact when the arm's being deflected away from the
It is not. I don't believe it's physically possible. That was not demonstrated in our testing, and I've never seen that demonstrated in any peer-reviewed articles. Now,
Right. So if
you can see
if
here.
the arm breaks it, how does the taillight scratch it? Which is questions a lot of you have asked over the last several weeks. Okay, but if the arm is what breaks it, then how is it also getting cut by it? And the response from Dr. Welcher was, well, the arm gets pushed along with the vehicle, and that's what cuts it. And he's saying the arm, the pressure on it is holding it together. It breaks, but the arm pressure is holding it together. And as the arm moves, then it explodes forward, moving at the same speed because it's already in motion, because it's part of the car that's in motion.
Here again, also the light and the fragments are being propelled forward. So you also have to consider where Mr. O'Keefe was found. He was found in the yard about 10 or 20 feet from the road. There was no exact measurements. But if you look at the motion of the taillight, it's going forward. Now, if Mr. O'Keefe has to move diagonally to the top left of that corner.
So if the tail light is moving in the same direction of the car, how is their tail light projected up into the yard? Because there's no tire tracks up onto the yard. And there's nothing to indicate that the collision with the vehicle was coming vertical to the yard, not horizontal to the yard. So if he was hit and stayed in the same place, wouldn't the taillight have gone beyond that? Some of it's in the road, but wouldn't the taillight have gone beyond that in that kind of cone shape down the road and the yard? Not where John O'Keefe was if he went sideways. It would continue down.
And if he's not hit with the center of mass, he can't get to where he ends up before the taillight fragments have already gone forward and been deposited on the ground. Average running speed is like 4 to 6 miles an hour. Even if this SUV is going 10 miles an hour, the lights fracture, they're dispersed on the ground, and then Mr. O'Keefe somehow ends up to his point of rest. But you wouldn't find the fragments on him because they've already been pushed forward, come to rest before he even has a chance to get to where they find him.
Let's go to the next slide, please. What is this slide showing?
So this is just frames taken from that actual video showing the interaction from the top left, then you go down to the bottom left, and then the top right and the bottom right. Just shows you the progression of the contact and the movement of the arm.
Is the bottom left frame the same frame that you stalled on just a second ago at my request, showing the deformation?
Paused on, not
right arm?
stalled on.
That's correct, yes.
Thank you. Next slide, please. And is that just a close-up of the same?
That's just a close-up of the same, yes.
Okay, next slide. And is that a final close-up of the arm after it's been deflected out of the way?
That's correct, yes, sir.
Does this also illustrate what you just described in terms of the trajectory of the broken taillight fragments?
It does, yes, sir.
Do you see any defect at all in the right sleeve of that hoodie?
There is no defect in that right sleeve of the dummy. No,
Was
sir.
the dummy's sleeve examined following this test? Closely examined up close rather than just photographed?
It was examined and photographed, yes, sir.
Was there any defect in that right sleeve at all?
No defects at all were noted in that sleeve. No.
Next slide, please. What are we seeing here?
This shows some of the
Photos?
photographs taken of the sleeve and the arm to show that there's no defects whatsoever And it shows the damage to the Lexus. And again, at 24 miles an hour, not only do you get damage to the taillight on the fender there.
I realize the nope also being Yannetti gets confusing for those of you particularly listening in the background. That the Yannetti nope is the soundboard nope, not Yannetti's not just sitting in court going nope. Apologies.
But you also get damage to the taillight on the liftgate.
Was there any damage on the taillight of the liftgate in the subject SUV?
There was not, no.
Next slide, please. What are we looking at in this video?
And so this was 29 miles an hour with a suspended hybrid 3-arm.
Was the arm in the relative orientation that you saw depicted in the paint transfer test by Aperture?
It was, and in fact, in this one, there's actually contact. We moved it in so that you would get contact with the elbow and the upper arm as well. So it's in the position after Dr. Welcher moves his elbow in and rolls his shoulder into the taillight cover. We evaluated that position with this test.
And do you see any damage to the liftgate taillight based on this test?
There's extensive damage at this speed, yes.
What about the damage to, damage would you expect to see to the arm itself at this speed and in this orientation?
At this speed, I mean, we're talking 4,000 pounds of force on the forearm, and with the hand, 1,400 to probably 3,000 pounds. I mean, well above levels where you would get fractures.
Next slide, please. What are we looking at in this slide, these two photos?
This was the final test that was conducted in using a dummy, and it was impacted at 29 miles an hour. And this was a center of mass impact.
Why was it important, Dr. Rentschler, why was it important
to
too
many
do
W
a center
sounds.
of mass test?
Even Jackson did it. Welcher, Rentschler, Wolf, other Wolf. It's a lot.
Because
there's also a very small little bug in my office that's going to make me crazy. So there actually is a little bug in my office. So if you see me doing all of this, it's why.
if we have an auto pedestrian impact and you want to see where the pedestrian ends up, you have to evaluate how they were impacted by the car. In order to have the pedestrian move any substantial difference, it has to be hit at the center of mass. Again, it has to be hit at that belly button area to propel the body in a certain direction depending on the speed and direction. If there's no center of mass impact, how does someone get to the point of rest? You can't correlate a side swipe where the arm gets contacted and say if someone ends up 20 feet away, there's no way to correlate that that arm impact caused them to somehow move 20 feet away. It wouldn't be as a result of the actual incident. It wouldn't be a result of the impact pushing their body in that direction.
From a physics standpoint, is it reasonable to believe that your arm could be struck, just your arm could be struck as it's out in front of your body, and you could be propelled backward, say 7, 8, 10, 12 feet as a result of that strike?
No, it's not reasonable. That's not physically possible. And you look at the arm itself, and we're looking at talking about the injuries and the abrasions compared to fractures. So if Mr. O'Keefe's arm was hit at 24, 29 miles an hour, what this suggests, and there were only abrasions, what this would suggest is that if the taillight doesn't cover or fracture, you can have your arm hit at 24 miles an hour and you wouldn't have any injuries at all, which from a biomechanical standpoint doesn't make sense. If the claim is that the fractured taillight's the only thing.
So I'm sustaining the objection to that. I'm going to strike that portion, Mr. Jackson.
Let's go to the
strike what
let's go to the next
portion?
slide.
You're not even clear about what is being stricken.
What are we looking at in this video?
So here's the video showing that strike at 29 miles an
He's
hour
explaining.
with the center of mass impact to the dummy.
What's the import of this particular test? Why was this important?
Oh, the sliding. They
what did you
yeeted
conclude
Randy.
following this impact test, the center of mass impact test.
There's a couple of reasons. A, it shows there was extensive damage to the rear of that Lexus. So if you had a center of mass hit, you would have damage to the liftgate, to the fender, to the sheet metal. you would have substantially more damage than what we had in this case. And secondly, which
yeeted
I believe is
Randy.
just as important, it shows the post-impact trajectory of the
I gotta
dummy.
fix my in-ears.
So again, if you're struck on the corner by the Lexus, the dummy goes straight back in line with the vehicle. There's no force and no direction to actually cause that dummy to move off into the side
And
of
that's
the
at
vehicle.
24 miles an hour.
So you can't be hit center of mass with the vehicle going straight back and somehow end up 10 or 20 feet to the side of where the vehicle is traveling.
So in this circumstance, would you expect the taillight material to be distributed straight back in the same center line as the vehicle is traveling?
Yes, absolutely.
Would you also expect the body to be struck and move in the same center line as the vehicle?
Sustained is too.
Sure. What about the body? What directionality would you expect on a center mass hit?
It was leading.
The body's going to move in the direction that the vehicle is moving, that main direction, that main force.
Here's why I'm less fussed about leading with some of the experts. A, because everybody has the expert opinions, so they know what the experts are going to say. B, it is not assuming the answer to say, and was the dummy that we just all watched going in the same direction as the car? Can you explain why? Yes, it assumes the answer that it was Randy was going in the same direction as the car, but we also all just watched it. So it's not giving the witness the answer. And really the issue with leading is feeding the witness the answer. That is the concern. It doesn't apply as much depending on the situation, but Brennan has been objecting to it and they've been sustained. To be fair, when Alessi objects to it with Brennan doing it, they've all been sustained as well. It's just at times it is necessary background.
Moving straight back, the body is going to move primarily straight back.
I also think
Did you reach an opinion or conclusion
When it's
regarding whether the right arm can...
when it's egregious leading, there should be objections. There's times where it just sometimes is to break up the flow. And lawyers will absolutely object to break up the flow.
That main direction, that main force, moving straight back, the body is going to move primarily straight back.
Did you reach an opinion or conclusion regarding whether the right arm kinematics are consistent with fracturing the taillight cover and sustaining the abrasions that you saw on John O'Keefe's arm?
I did, yes.
What is that opinion?
My opinion that it is not consistent with contacting and fracturing the taillight cover.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
Can we move to the next slide, please?
So that was the next
And-
opinion that it's not
Okay, that's just
consistent.
a moment, Your Honor.
Sure.
On what do you base...
Lucky Hamster in the chat said, but why isn't anyone actually rescuing Randy? I have grave concerns. I mean, the grave concerns are abundant. And Jenny BU in the chat, this was a great question. And I wanted to, this is something that's been on my mind as well. And I've seen similar questions come up in the chat quite a bit. Did anyone test what a phone does when hit by a car going that fast? It was not in his pocket. John O'Keefe's phone was recovered underneath him. He was found laying on his back. His phone was underneath him, not in his pocket. It is something that I think the defense is not talking about because they're going to argue it. Because now the jury has seen these. How does the phone leave the pocket and end up exactly with John O'Keefe and not go flying in the same direction as the general debris field? It is a great question. But I think the defense is going to save it for argument. It is not the defense's job to answer all the questions. It's the defense's job to point out all the questions that aren't answered. And they don't want to give the Commonwealth an opportunity to answer those questions. Also, I think there are things, and I probably would have felt differently about this a couple weeks ago. I think there are things Brennan has not considered. And my thoughts on that would have been different before we saw Brennan get totally lost in the sauce with John O'Keefe's hoodie and being like, look at all these holes here, 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 here. Brennan was completely lost in the sauce and didn't back up far enough or know his own case well enough to know that those were cuttings from the crime lab. So it's very possible that Brennan hasn't even considered this in argument. So the defense is going to save it till argument. The Commonwealth needs to answer those questions because I imagine when the defense argues it, if they do, the jury's going to go, yeah, How did the phone stay with him and end up exactly under where he was if this happened the way the Commonwealth said? And I'm sure we can run scenarios together as a chat with the 50,000 of us that are here and go, could it have been this? Could it have been this? Could it have been this? Sure, we could have. But we're in a criminal trial where the Commonwealth has to prove that only one thing happened and that Karen Read did that one thing. So for us to go, well, could it have been this? Or could it have been that? Or could it have happened like this? That means there's multiple reasonable possibilities. And if there's multiple reasonable possibilities, and some of those possibilities point to not guilty, then the jury is told that that's the way they have to decide. So the Commonwealth has to answer those questions. The defense doesn't have to give them a heads up on all those little nuggets. They keep those on a notebook to put in their bullet points for their closing, that I'm sure they are already pretty well written. Regency, and a number of you asked, was the phone broken? No, there was no damage we knew of to the phone. We did not hear about a cracked screen. We did not hear about scratching on the back of the phone like you would expect to see with a road rash. We did not hear anything about damage to the phone, and it was still in working order enough that it was still registering data, and they used it to show the decrease in phone temperature. Somewhere in evidence, there should be photos of John O'Keefe's phone. We have not seen those. So there should be evidence of what the phone looked like before they did the extraction. No damage to the phone we've heard of. The phone was found underneath him on the grass. We've heard about the temperature dropping, but we've heard nothing about a cracked screen, a shattered screen, scratches to the back, anything like that. We've heard nothing about it. So we just don't know. All right, let's continue. They're good questions, you guys. You guys have great questions. Here's what's hard for the Commonwealth. If there are this many questions this far into the case, it indicates to me that the Commonwealth has not answered all of the necessary questions. Because y'all weren't asking this many questions as we were getting into the Sarah Boone case after the Commonwealth's case or the prosecution's case in chief. There were some in Murdaugh, and then he testified. Then there were less. But there are so many questions day after day from all of you that have watched this for 31 days. That's not helpful to the Commonwealth.
Your opinion that you just told the jurors.
That looking at the kinematics of the arm, it's inconsistent.
We have now talked about 900 things. I'm going to back up and let him give his opinion one more time as they get into the foundation for that.
Contacting and fracturing the taillight cover.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
All right, I didn't back up quite enough.
Kinematics are consistent.
That main force
Okay, there we
moving
go.
straight back.
I'm going to let him give his opinion one more time.
Primarily straight back.
Did you reach an opinion or conclusion regarding whether the right arm kinematics are consistent with fracturing the taillight cover and sustaining the abrasions that you saw on John O'Keefe's arm?
I did, yes.
What is that opinion?
My opinion that it is not consistent with contacting and fracturing the taillight cover.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
Can we move to the next slide, please? And
They're going to get into the basis for that
Okay, just a
opinion.
moment, Your Honor.
Sure.
On what do you base?
Emily, you backed it up so you wouldn't pause again, and then you paused again. Asnet, I hope I said that correctly, and if I did not, I apologize. This is a great question. When we get to another sidebar, I'm going to answer this, but I also wanted chat to think about what questions were answered for them. Everyone's immediately going to say it was snowing. There are a few. We'll talk about those.
The jurors.
That looking at the kinematics of the arm, it's inconsistent with the evidence we have with the actual abrasions to the arm, the evidence on the sweatshirt, and that at these speeds, you would likely expect fractures, certainly to the hand, and likely to the ulna and the radius in the forearm, if your hand or arm was struck by the rear of the SUV.
Would expect fractures. And
Can we move to slide 48, please?
Dr. Welcher's out on that was, well, there's
What are we
no
looking at in
x-rays.
this?
We
slide.
expect fractures, but there's no
This was a
X-rays.
study where they used an impactor and they contacted the
We're back to the thrusting of the impactor, are we? To see how the load is distributed? Good. Good.
dorsal or top part
Good.
of cadaver hands.
Good, good.
And they looked at the force that was exerted and they looked at how many fractures were produced as a result of that.
Did you review scientific literature regarding hand injuries under this sort of impact loading? Is this representative of that?
It is, yes.
Next slide, please. What is this?
So this shows the position, and this is taken directly from the Aperture
Oh,
paint
I
test.
love
You
this
can see-
slide. This is the nerdiest, most delightful shit I've ever seen. They have taken the scientific study and juxtaposed it to the study that Welcher did. Look at the nerd is so strong in this. I love it. Look at all the bendy bits of the hand. Oh, it's so good.
the position that Dr. Welcher had his hand against the tailgate right at the time of impact. And you can see that corresponds, the contact areas correspond to the areas of the hand that were actually tested in this case.
Next slide, please.
It also makes sense to me that ARCCA would have at top of mind a study regarding protected, unprotected hands, given the amount of work they do with the NHL and people, gripping sticks and running into boards and all the rest of it. It's a very different thought than Welcher saying, nah, I don't need to know the numbers.
What is this showing?
So this shows the forces produced during the test as well as the forces produced during our testing. And maybe the next slide here actually better. If you look at the knuckles, which are the blue middle region, and then the metacarpal bones, which are the lower one. So for the metacarpal phalangeal joint, the knuckles, on average, it took 397 pounds of force to fracture that joint. Well, the 15-mile-an-hour test produced a minimum of 483 pounds. And more realistically, that's just with the hand weight. There's going to be more weight because it's attached to the wrist. More realistically, it's twice that, so it's around 900 pounds of force. But what these tests show is that the force produced on the hand, as represented by the PowerPoint from Aperture, even at 15 miles an hour and likely below that, you would expect to get fracture of the hand bones, of the knuckles, metacarpal interphalangeal joints, and the metacarpal bones if you contacted the rear of that vehicle at that speed.
Did you see any indication in the x-rays you saw or the medical records that you reviewed that Mr. O'Keefe's hand was damaged in such a way that you would expect?
There were no indications whatsoever of that, no, sir.
Next slide, please. What are we looking at in this slide?
This was a test where they actually looked at the force on the elbow. So this is a direct longitudinal force against the elbow. Now, there's no indication of exactly the test. The paint test has the arm horizontal, but there's no indication, there's evidence of whether maybe it would be angled or if it's straight horizontal. But even if your arm's angled a little bit at the point of impact, the forces, again, on the right are what we determined from our testing, and those are minimum. Again, that's just with the forearm. If you include the entire arm, it's about twice that. So even at 10 miles an hour, you're going to have 600 to 1,200 pounds of force acting on the arm.
Is that enough to break it?
That's enough. If you strike the elbow, that's more than enough to actually fracture the different bones of the elbow.
If an arm was hit at that speed with those forces, would you expect the x-rays to show no trauma, no broken bones, no fractures, no hairline fractures?
I would not expect that, no, sir.
Next slide, please. What are we looking at in terms of this slide?
So these are just more articles that I referenced, and they look at impact force on the forearm, so the ulna and the radius. It takes, just to have a transverse blow right against the bone, it takes about 1,100 to 1,200 pounds of force to cause a fracture. We're at that level already at a 10-mile-an-hour impact.
What about a 24-mile-an-hour impact?
24, we're at 1,400 to 2,800 pounds of force.
Did you see any trauma on John O'Keefe's arm that was suggestive of an impact of that nature, of that size, of that force?
There was no trauma. There were no fractures. There wasn't even an indication on the arm of where it would have contacted the vehicle. So if there's fracture at the taillight, there's going to be a force at that point on the arm where it actually contacts the taillight and causes that, right? There's going to be a force riser to cause that damage. There was no bruising. There was no lacerations. There was nothing at the alleged point of contact which would indicate an impact that produces thousands of pounds of force on the arm. No evidence of it whatsoever.
You just mentioned this in your answer, but I want to ask a little bit.
I have seen my kid's personal Uber driver said my daughter chipped a bone in her elbow doing a back handspring, less force and impact. I have seen quite a few elbow injuries from handsprings, from simple cartwheels, etc. The elbow can be really, really particular. Also, both of my kiddos have broken their wrists from falling off of things with much less force than getting hit by a car. So, yes, falling off a bike, falling off a swing, yeah. And even those breaks, you can still see them in the x-rays. And most people have real world experience with that themselves. And the jurors likely do too. The jurors remember their own injuries, the injuries of family, siblings, and loved ones. Right.
Further, we've talked a lot about bone fractures and ligament damage, et cetera.
A lot of you are talking about roller skates and
In any of these
Heelys.
tests, would you expect to see bruising, at least bruising, all over the arm at the points of contact?
Absolutely. Bruising occurs when the blood vessels just below the skin are ruptured, and it causes blood to flow into the arm.
Was there any indication that John O'Keefe suffered even a minimum amount of bruising on his arm at all?
No indication of any amount of bruising whatsoever on the forearm.
Right.
Next slide, please. And let's go to the next slide. I think we want to jump to slide 50. What slide are we on?
What slide are we on? I get it.
This is 55.
Tef in the chat said, as a Wisconsin night, 30 miles an hour and backwards sounds like tires not purchasing on snow. I agree with you that that's what it sounds like. The testimony from the witnesses, and again, the jury will get to decide, they were talking about the accelerometer and they showed that there was some tire slippage, but then the tires did gain purchase and they put in the accelerometer. The question they didn't answer, so they said at some point the tires were slipping and then got purchased and sped up to upwards of 24 miles an hour based on the accelerometer. What I don't think they ever answered was if there was even enough distance on the road for the car to go back as far as they said, and they didn't discount that distance based on tire slippage. So there was some tire slippage, but they also, the Commonwealth says, based on the accelerometer, upwards of 24 miles an hour and going. So they can't really back off of that speed now because they went to such lengths to prove that the accelerometer on the car showed that it was going that fast, and they can't really move away from that at this point. It's pretty locked in.
Let's go to the next slide. There we go. That's what I'm
A lot of you have
What are you looking at here?
injuries.
So
to
this
hand,
again
elbow, et
is
cetera.
from the paint test, and it
Thank you for sharing
shows, even as the arm gets pushed in, the vehicle's not in line with the center of mass with Dr. Welcher here. So it's not a center of mass impact. And this is important because we've just looked at the arm, and we've looked at the kinematics and the force and whether that's consistent with what happened and the injuries. The next step is to look at what happens if the arm gets hit. How does Mr. O'Keefe end up where he does in the yard? So that's post-impact movement or trajectory of the body. You have to evaluate that if you want to link all these events. If you want to link the head injury to contact with the car, you have to know what happened in between. You have to know the details. And so the next part was to evaluate that.
Is there any indication in any of the testing that you did or any of the review of the medical records medical records of John O'Keefe, including the autopsy records, all of the autopsy records, the x-rays, and the hospital records, any indication that John O'Keefe was struck center of mass?
None whatsoever. No indication at all that he was struck center of mass.
Do you have an opinion or conclusion to a reasonable degree of scientific certainty about whether he was struck center of mass?
I do.
And what is that opinion?
I don't believe that he was. The evidence indicates that he was not. If he was struck center of mass, imagine that. You're getting hit at the pelvis. You're getting hit on the thigh. You're getting hit at the knee. And then the body's being propelled forward. Your arm would get pushed into your body, into your ribs, into your torso. You would have very significant and substantial loading to your body, initially the right side of your body, as that impact occurred. And there's no evidence whatsoever that that occurred.
Switching to a glancing blow, a blow of just the arm, not the center of mass, but just the arm. Do you hold an opinion and a conclusion as to whether or not a glancing blow or a blow to the arm only would propel Mr. O'Keefe?
Sounds like he's
7, 8, or
getting
10
close to the
feet
end
perpendicular to the line of
of
travel
his
of the
direct.
vehicle?
I do.
What is that?
It would not be possible. Our testing demonstrates that. The peer-reviewed articles demonstrate that. I've seen no evidence anywhere in this case that would suggest or even indicate that if you get a glancing blow or a sideswipe blow, that somehow would produce enough force to push you 8 to 10 feet into the yard. I don't believe it's possible. I've seen no research that would indicate that would occur.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
Can we move to the next slide, please? And let's go to the next slide. Let's keep going. Okay. What are we looking at in this slide?
So this slide, it's a paper that describes how to evaluate vehicle pedestrian impacts and how someone moves in the projection of that body.
Did you seek to analyze a fulsome understanding of whether it was possible that Mr. O'Keefe was
There's
hit
the
on his
fulsome.
lower extremities?
I did, yes.
Why did you do that? Why was that important?
I feel like at this point, it's just because we're all Hogue fans and he says fulsome more than anyone I know. But yes, lawyers love the words fulsome. Just love. I don't know any other profession that loves that word as much as lawyers.
Well,
Try to get this
because
out of the way.
with automobile pedestrian impacts, the lower extremity, your legs, your ankles, your knees, that's the most injured part of the body during autoped impacts. So if he's going to be impacted
Vehicle
at that
versus
speed,
pedestrian.
especially center of mass, there's likely going to be injuries to his leg, to his knee. The bumper lines up with the knee. That's one of the most commonly injured parts, as the bumper pushes into the knee, fractures the tibia, the fibula, or damages the knee joint.
Did John O'Keefe suffer any injuries to his lower extremities suggestive of a vehicle impact?
No, I believe the only injury was a half-centimeter
He had a scraping.
abrasion
Yeah.
on the outside of the right knee.
Could Mr. O'Keefe have suffered a half centimeter abrasion on the outside of his right knee by being struck by an SUV at 24 miles an hour?
Not without other
I
injury.
don't believe so. I don't see how those kinematics would work.
Sustained.
There would be other injuries.
Do you have an opinion as to whether or not that injury was from being struck by an SUV at 24 miles an hour or somewhere around 24 miles an hour?
I do.
What is that opinion?
I do not believe that injury is consistent with being struck by an SUV at approximately
Right.
24 miles an
Do
hour.
you hold that opinion to a reasonable degree of scientific certainty?
I do, yes.
Did Mr. O'Keefe suffer any other injuries to his legs or his lower extremities other than that small, how big was it? How many centimeters?
Half-centimeter abrasion.
That small half-centimeter abrasion. Did he suffer any other injuries to his lower extremities indicative of being struck by a vehicle?
I don't believe so, no.
Let's go to the next slide. Taking a look at the photograph on the right, concentrating on that for a second. How did that SUV get in that condition?
That was by striking the dummy at 29 miles an hour, and that was a center of mass hit with the dummy.
Were you able to review photographs of the subject SUV, Ms. Reed's SUV?
I was, yes.
Did her SUV suffer
Her
or
SUV didn't
suggest
look
any
like
kind of
that.
damage anywhere close to this?
No, the only real
Nope.
damage was to the outer taillight cover on the fender itself was fractured.
Next slide, please. We've seen this.
Yep,
This
we've
is the
seen
video that was the center mass impact?
That's correct, yes.
The photograph that we just saw previous, what relationship does that photograph have to this field test?
That was the
damage.
condition of the SUV after it struck the dummy here at 29 miles an hour.
Can we go to the next slide, please?
A number of you asked
are we
in the
looking-
chat when we were talking about the position that John O'Keefe was found in, about Jen McCabe saying that they turned him over. I don't believe that statement. I don't think it was a volitional misstatement to 911. I don't have any evidence of that. People say weird things when they're stressed, but the lividity on John O'Keefe's body when he is recovered says that he was on his back and stayed on his back. So whatever Jen McCabe said, I discount, because again, you also have a lot of statements in this case that are born out of stress. So I don't put much weight in her saying they turned him over, because there's no evidence. There's no independent evidence of that other than Jen McCabe said a thing. She was clearly stressed the same way that Karen Read was stressed. She was not verbalizing her stress the same way Karen Read was. But it was clear to me that Jen McCabe was stressed, that Carrie Roberts was stressed, that Karen Read was stressed. And I've heard people say all kinds of weird stuff on 911 calls when they're under stress. So I don't put a ton of stock in it, especially when it's clear from John O'Keefe's body that he stayed on his back for a substantial amount of time based on the lividity. So
Yet in this
that's
series
why I
of,
don't give it the
diagrams?
credence.
So this is some more recent testing that was done, and this test compared impacts between a small sedan and an SUV, and so it's looking at damage or injury to the legs as a result of this type of
Really,
impact. And
really
these impacts are
helpful
actually conducted
diagrams.
at a speed of 24.7 miles an hour. They used cadavers, people who donated their bodies to science, set up the cadaver.
Really interesting studies that they're showing how vehicles strike pedestrians. Isn't it wild that they're also using 24.7 miles an hour? That is an unusual coincidence.
Cadavers and struck them at just about 24 miles per hour.
Did this support your opinion and conclusion concerning the lower extremities of Mr. O'Keefe and the possibility that he was hit by an SUV at speed?
It does. If I can go to the next slide, it actually.
Sure.
So this shows you for the SUV, it's the last column on the page there. The last three columns are the injuries associated with the SUV strikes. There's fractures to the pelvis, left knee injury to the ACL, the MCL, fracture of the tibia and fibula. There's extensive damage to the legs of all three of the cadaver subjects that were struck.
I feel
at
like he's
24
listing
miles
out the
an hour
surgeries
with an
that
SUV.
I've had,
Did Mr.
none of
O'Keefe
which were from a car accident.
Show any signs of any
The
of these
ACL, the
He did not,
MCL,
no.
Next slide, please.
the this, the that.
Is this, what are these photographs and diagrams on the right?
Those are photos of
So
John O'Keefe's legs.
this was taken from the PowerPoint from Aperture, and so it shows that the medical diagram.
I'm going to pause real quick because, chat, I want to ask you guys a question. There's 50,000 of you in here, and we saw Dr. Welcher's slides. We saw Dr. Welcher showing I don't want to call it a test case because that's not right, but the comparison case with the injuries from the car accident, with the broken taillight, with the car kind of crumpled, tissue stuck in that crumpling, and the injury to the individual that they showed on screen. Briefly, some of you saw it, some of you might not have. Do you find that type of comparison case slide more or less helpful than the comparison slides from the scientific journal showing the shape of the back of an SUV and different types of injuries they saw from a person being struck by the SUV? Which one do you find more helpful in understanding the explanation here? I guess I've asked now two questions. Did you find Welcher's more helpful or Wrenchler's more helpful? And you can just, I don't know, you can use the wrench emoji for Wrenchler because his name's hard to spell. And I've asked, apologies for asking now two different questions entirely, but which one did you find more helpful, however you choose to express it?
shows the half centimeter abrasion. And if you look at the
It
picture
was
on the
totally
left
compound. It was a bad
of the
question.
surrogate, you can see
The point's made, though.
So the bumper would line up from the knee all the way up to the pelvis. So a vehicle at speed of 24 miles an hour, if it impacts that knee or that leg, it's not going to produce only a half centimeter abrasion. It's going to get the leg, and it's going to cause significant damage to the knee and to the leg itself.
When you say from the knee to the pelvis, are you talking about the width of or the height of the bumper itself being from the knee to the pelvis?
I am, yes.
Would that be the contact area that you would expect if there was even a glancing blow to the knee and the hip?
That's correct. You can see on that picture there where that bumper, the rear corner of that bumper, where the bottom reflector is, it extends from the knee all the way up to the pelvis.
Can we go to the next slide, please?
As they're switching slides, Joe in the chat asked, could the jury hang on different counts? They can come back with a split verdict. That was part of the problem last trial. We can talk about that as we go to jury deliberations. But yes, they can do a split verdict. I think we'll see that treated differently. We're a pretty long ways off, but yes, juries can come back with split verdicts. They can find a verdict on some counts, not on other counts. And if that happens, then yes, a prosecutor can retry just the counts that were hung on. Those get into a lot of strategic decisions and practicality, but we can talk about that as we get
What are
into
these diagrams?
closing arguments.
Again,
in this
these
case.
are just reports, peer-reviewed articles demonstrating that auto-pedestrian impacts result in lower extremity injuries and fractures.
Did you review all of these peer-reviewed articles that you've told the jurors about?
All these articles about
academic
lower extremity
articles
injuries.
In furtherance of coming to your opinions and conclusions?
I did, yes.
Did you see any reference in the Aperture report that you reviewed and the PowerPoint slides that you reviewed that the concomitant peer-reviewed articles were sought in the paint transfer test
No.
or cited?
Jackson, do you feel left out of the word of the day? Because Jackson throughout this trial is becoming more and more Alessi with his vocabulary, which is just funny to me. But early on in trial, Jackson, you got the shank of the evening as the phrase of the day. So I feel that you're fighting for it with concomitant, but I might allow it. We'll see how the day goes.
There was only one article that was cited in that report with respect to automobile pedestrian impacts.
Did it have anything to do with the paint transfer test?
It did not, no.
Next slide, please. And let's keep moving until we get to the, yes, there we go.
The virtual juror
What
said,
does
I think
that
they have a
slide
contest going. They
So
might.
this is the opinions that were offered in the Aperture report. And if you look at the top, number 4, it says the totality of the evidence is consistent with the right rear corner
None of them
the
have said
Reed Lexus,
crapulous
again,
yet, though, so-
impacting John O'Keefe
You
and
know.
Mr. O'Keefe striking the rear posterior
Oh,
aspect
there's
of
a
his
note.
head on the frozen ground.
There's a note about the cell phone under the body. There it is.
And when you look below that, it basically has the references or the support for that one conclusion.
This is from
See you both at sidebar.
This is from Wrenchler's report. The court's asking to see everybody at sidebar. I just want to take a minute. Hold on, I'm going to back up so I can. Okay. This is a screenshot from Wrenchler's report. The totality of the evidence is consistent with the right rear corner of Reed Lexus impacting John O'Keefe and Mr. O'Keefe striking the rear posterior aspect of his head on the frozen ground. Cell phone data, physical evidence around body, which says taillight, bar glass, cell phone location under body, body only at point of rest, arm, forearm lacerations, air temp and frozen ground, HAT line, and fracture location consistent with fall and posterior head strike. I agree with that. I think that's been well proven. I don't think that necessarily means that there was added force to that. Head most commonly injured body region in pedestrian impacts. The range of the occipital bone fracture force has been reported between 1,150 and 2,150 pounds. I think when they get down lower here, they say testing has shown occipital skull fractures, not occiput, occipital skull fractures from drop heights as low as 40 inches. So with the testimony from Dr. Wolf, Hungry Like the, or the real thing. Dr. Laposada, Dr. Scorti-Bello, at minimum, and Dr. Welcher, all of them have concluded that the injury to John O'Keefe's head could come from a fall backwards. All of them. None of them said more force was needed. And unfortunately, I dealt with way too many vehicle collisions as a DA. I dealt with quite a lot of them. And there are some injuries that you look at and you're like, that does not just come from falling off of a bicycle, from falling backward. There's more force needed to cause those injuries. All the witnesses here have solidified that that injury did not need additional force than just a fall backwards. And Dr. Wolf even said, we see exactly this injury with people having a heart attack, shoveling snow, and falling over backwards due to that heart attack. No additional force. So that injury can come from falling backwards without more. All right. They're approaching sidebar. Are they going to leave this up on the screen while they approach sidebar? Seems like it. Seems like it's staying up. All right. Fair Green 42 said, Emily, does Welcher know about this testimony? He should still be under sequestration because he knows he's testifying again. So he shouldn't, because he's under sequestration. I imagine Jackson will ask Welcher about it. I didn't even catch that. Dr. Barbara Clock, I do not catch
Dr.
spelling errors well.
Wrenchler,
I didn't see that he misspelled ARCCA.
Can we move to slide?
The experts are here for a battle of the experts. It means they evaluate each other's testimony. Those were Welcher's conclusions.
70, Mr. Jackson.
That's what was.
They're allowed to ask about Welcher's conclusions.
I wish my eyes were better. Slide 70.
Oh. Let me.
Silent Rage
Restart
5
it
said,
here.
EDB, sweetie, you're showing your age with the Duran Duran reference. Oh, I'm old AF. I mean, I don't hide that. I've been a lawyer 20 years. There's no way for that to be true and me to be 20. I mean, I have a 17-year-old. I think my knees are actually older than
Thank you.
my
Okay, what are we looking at in slide?
earthly
this is slide
age,
7,
but
yes. What are we looking at in?
my brain is clearly 15. The rest of me, not so much.
Slide 70, Dr. Rentschler.
So this was the one article that was referenced in the Aperture report with respect to automobile pedestrian impacts. And there was a chart from there that was referenced in the PowerPoint that indicates the head's the most commonly injured body.
I remember this chart from Welcher's PowerPoint.
Body region in pedestrian impacts.
And what significance did that reference have in your analysis?
Well, that's not accurate. This article was written in 1979. And the first.
I remember this. Well, first of all, that article was written in 1979. Look, man, half the chat wasn't born yet. The other half the chat was like, the 70s.
First modern SUV, the Jeep Cherokee, wasn't manufactured until 1984.
Really?
So
I didn't know that.
This is an article that's 46 years old.
Sir, I feel very called out. Wait, how old am I? No, I just had a birthday. Definitely not 46 anymore. Head injuries being the most commonly injured body region to a pedestrian in 1979. Why does it matter? Because there are some scientific studies that go back to the 70s that are probably just fine. In law, they go back to the Magna Carta all the fucking time. Why? Because it doesn't change as much and the law is foundational. But he makes the excellent point that the first modern SUV didn't even happen until 1984. Cars changed. Cars changed significantly between 1979 and 2022. It's an excellent point.
Well, that's not accurate. this article was written in 1979. And the first modern SUV, the Jeep Cherokee, wasn't manufactured until 1984. So this is an article that's 46 years old that doesn't actually relate to this type of an impact. And that's the only peer-reviewed reference with respect to automobile pedestrian impacts that was cited in the entire Aperture report.
Can we move to slide 71? Do you recognize what's depicted in this slide?
I do, yes.
What is depicted here?
So this was hybrid. This is the 50th percentile hybrid 3, the same.
It's a very awkward junior high school dance.
Dummy that we utilized. And Dr. Welcher performed a test where
Can I interrupt you?
Sure.
So this ATD, anthropomorphic test device, was not a 95th percentile test device?
It was not, no.
The 50%?
It was a 50th percentile, yes.
Is that the same exact, not the same exact, same exact sized ATD that ARCCA utilized?
Well, Dr. Welcher didn't want to use one that was taller than him. I feel that very strongly. Dr. Welcher was not using the ATD, XYZ device that was going to be taller than he was. He was very proud. He was like, I am 6'1". He was very proud.
It was, yes.
Okay.
And to get the forces on the head, Dr. Welcher scaled the acceleration results based on the weight, which is what I was talking about yesterday. You scale the results from the 50th percentile. That's exactly what Dr. Welcher did in this case.
Is that an appropriate way to adjust for the size of an ATD?
It absolutely is, yes.
Okay. Go ahead.
Right.
So this test,
So the jury sat through 100 years of Brennan fighting over 95th percentile versus 50th percentile for this witness to get on the stand, for the jury to be shown, look, it's the exact same one the Commonwealth's expert used. You lose the jury's patience when you fight over shit that does not have a point. Why all the fighting over the different size arm when your expert used the same thing?
He did. He took a 50th percentile dummy, stood it up, and then let it drop backwards and strike its head on a concrete surface.
Next slide, please.
Right.
By the way, Dr. Wrenchler, did the last slide include a video?
I believe it did, yes.
Can we go back?
Or I'm not sure it's on this slide. That's just a screenshot.
I see.
Yeah.
I see.
Yeah.
There is a video.
So let's go back to that slide for just a second. I thought this might be the video of it.
Oh.
So in the lower portion
Isn't there
of
a
the
video of
center
him
of the screen,
dropping?
You see Dr. Welcher holding the ATD. Is that correct?
That's correct.
Did you review a video of what happened next? This is not the video, but did you review the video?
I did, yes.
Describe for the jurors, since we don't have access to the video, what did you see happen from this point forward?
So Dr. Welcher releases the dummy, and the dummy just falls rigidly backwards, almost like a tree, and impacts the concrete.
Right.
Can we jump from your PowerPoint to a video that I have and ask you if you recognize it with court's permission?
Is the video in evidence?
It's in Dr. Welcher's PowerPoint.
Is it before the jury? Is it in?
It is.
Okay.
I don't remember if we saw it or not at this point. I think that we did, but I don't remember if we did. And that's what the court was asking. The court was asking, is the video in evidence?
Okay.
A lot has come in over
Do you recognize
these
this?
weeks.
I do, yes.
Is this just look like the same screen, basically the same thing that you just
That's
took
from
a
the
screenshot
Aperture
of?
report.
It is, yes, sir.
Okay. If we could play the first couple of seconds of the video
A lot of you say we do remember the video.
and pause it. As that video
Thank
began
you,
to
Chad.
play, did you recognize this as being the same video that you reviewed earlier?
It is, yes, sir.
And did you utilize this in coming to your opinions,
I did, yes.
and conclusions in this case?
I did, yes.
Thank you. Let's go ahead with the court's permission when we play the video.
Yes.
Thank you. What did you see? Describe what you saw
Well, the head bounces.
in this video.
So this is a passive rearward fall of the ATD dummy. So just releasing and let it fall. Obviously, it's a dummy. There's no musculature. There's no response to that dummy. So this is what would happen if a rigid individual just fell backwards onto
Like-
a concrete surface.
Dr. Wolf
Can we see it one more
testified
time,
about.
please? I want to ask you one other question. I'm going to ask you to take note, Doctor, of the impact location. Did you see that?
I did, yes.
What kind of surface is that floor, if you can tell?
That, I
Concrete.
believe it indicates it's a concrete surface, concrete floor.
Did you notice if the falling backward like that, the dummy slid across the floor or was propelled across the floor, anything like that?
It did not. It just dropped and angled backwards and hit directly on the floor.
Okay, let's go to the next slide. I'm sorry, if we could revert back to your PowerPoint.
The ATD that they are dropping does have sensors. And we saw some of that in Dr. Welcher's report. That is not Randy. That is the censored crash test dummy, so you can see the acceleration, which they talked about in
And if you could pull up slide, I think it's 72.
Welcher's report somewhere.
Let me, every time we do that, I have to restart the PowerPoint.
Streaming is dynamic.
Okay.
Why did you include this video one more time in your PowerPoint here?
Because, again, this is the pain test, which indicates the position, at least that Dr. Wrenchler had himself at to get the impact with the taillight cover. And notice, again, so it's not a center of mass hit. It hits his arm and then he slides by. So if that were to occur, he would rotate or move to the left. So if Mr. O'Keefe did that and somehow ends up falling backwards, rigid directly onto his head, he's going to have to rotate at least 270 degrees and then stop and then fall directly backwards onto his head. There's no explanation of the kinematics.
Sustain us to the end of that. I'll strike the end.
Do the kinematics support
What did you
just
strike?
suggested?
The end? What's the end?
Sustain us to form.
What do the kinematics support?
I'm going to see you at sidebar for just a minute.
Why?
Jurors will be taking our break.
I think she said jurors will be taking our morning break now or soon. I don't know, because they cut. Well, we'll see if they go up to the OnlyFan, because they do that when they take their morning break. But, oh, they must not. She must have said soon, because they don't go to the OnlyFan and they get past this sidebar pretty quickly. All right. He's allowed to ask about kinematics.
May I continue?
Yes.
Thank you. Dr. Wrenchler, based on your review of everything...
Wrenchler.
Did I do that again?
Yes.
My goodness.
You did it again. I like that he's like, do not call me Welcher.
May I continue?
Yes.
Thank you. Dr. Wrenchler, based on your review of everything...
Wrenchler.
Did I do that again? My goodness. This is Dr. Wrenchler in the video, correct?
Correct.
All right. I was staring at that. I apologize. Dr. Wrenchler, based on your review of the video in which Dr. Wrenchler is positioned, as well as the drop test that you saw, as well as the discussion of the body placement, where you discussed the body placement, do you have an opinion as to whether or not the testing that you reviewed from Aperture is consistent or inconsistent with John O'Keefe being struck by the vehicle, propelled perpendicular, backward, say 7 to 10 feet, and falling straight back onto a hard surface as depicted in the drop test?
The testing's inconsistent with those types of kinematics or that type of scenario.
On what do you base that opinion, sir?
That's based on the testing that was performed, the evidence available in this case, and the kinematics of how somebody would move post-impact after being struck by an SUV.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes.
Can we go to the next slide, please? Can I
Okay.
have just a moment, Your Honor?
Yes.
The jury did not go out for their break. I think the court said we'll be taking the morning break soon because they never went up to the only fan, which they do when the jury goes out. So the jury is still in. We zoom past the sidebar. They have not taken the morning break on stream yet, unless they did earlier and we didn't see it. Because we've been zooming. But the court is also trying to get through.
Finally, Dr.
All of this, and we're a bit behind in
do
real
you have
time.
an opinion, or did you reach a conclusion, whether the biomechanical evidence in this matter is consistent or inconsistent with Mr. O'Keefe's right arm being impacted by the subject 2021 Lexus 570, resulting in a backward fall leading to the head injuries that he suffered?
I did, yes.
And what is that opinion?
My opinion is that the evidence is inconsistent with Mr. O'Keefe being struck on the right arm by the SUV and then moving laterally into the yard and falling backward onto
And
the
do you
back
hold
of his
that
head.
opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
Thank you. That's all I have, Your Honor.
Okay. So now we'll take our break, folks. We'll see you in about 20 minutes.
Please rise for the jury.
All right, now the jury is taking their morning break. We have the zoom room to move past the morning break. So we're going to skip the morning break entirely and come back for the cross-examination of Dr. Wrenchler. And are we surprised? At the morning break, we have gotten through the full direct examination of Dr. Wrenchler. Yesterday, we saw that Brennan said he had about an hour, he thought, of cross-examination. That should be done before lunch then. The defense may rest by the lunch break. They may not. Who knows what is going to happen from here, because there may be substantial redirect. There may not, depending on cross. I expect this cross will be shorter, but again, we will see. I think that the defense with this witness did a very good job of using visuals. Even though we know this is a pared down PowerPoint, the jury doesn't know that. I think the visuals they used were helpful to explain to the jury why the injury to John O'Keefe's arm and the injury to the back of the head are inconsistent with the Commonwealth's theory of the case. And I think the defense did a good job of highlighting that what Rentschler was testing is what Welcher did in his test. Not that Rentschler was trying to solve the problem. He talked about being asked to figure out if this was consistent in his testimony yesterday, and he said that it wasn't. But now he was saying, look, I'm trying to test what Welcher did and see if Welcher's test with the paint and holding the cup and hitting the car is consistent or inconsistent with what we know from the damage to Karen Reed's vehicle and the injury to John O'Keefe. Because the thing that we know for certain in this case is what the injury to John O'Keefe is. And I think that it is in question for some, but the damage to Karen Reed's SUV as it purports to be, whether you think that the taillight was less damaged or more damaged, there is some damage to the taillight. But as the Commonwealth purports it to be, there is damage to the taillight on two different levels of that taillight. So is the injury to John O'Keefe and the damage to the taillight as it purports to be in the Commonwealth's theory consistent? And as they walked through this expert's opinion, it was, this is not consistent and this is why. And we saw, I think, more visuals on that. And then we saw the slowing down and the breaking down of how Rentschler did his testing. Things that Chap pointed out when we saw it in Rentschler's direct. The defense didn't cross-examine Rentschler on some of those points, but Rentschler did nothing but fight with Alessi saying, I'm trying to help you here, guy. My interpretation of vibes. I'm trying to help you here. But the defense didn't cross-examine on, aren't you stepping and leaning closer to the SUV there? No, they wait and pointed it out with Rentschler. And then it's going to be real interesting to see Welcher come back and testify. I know after Welcher's pissing match with Alessi, I was exhausted and I was like, I don't know if we need to see any of Welcher testifying again. But after Rentschler talked about the way that Welcher's experiment went, I'm actually kind of interested to see how that goes when he comes back. Are you? Are you ready to see Welcher come back now? I kind of am. I'm kind of ready for it. And if I interchange those names, I should just start saying ARCCA and Aperture, but I'm going to get those flipped too. Shit's flipped. But now, like, bring the Wrenchler again. Let's ask it. Let's slow that video down. I got questions. I got questions about those x-rays. I have questions. And if you have questions about the x-rays, go watch today's case brief on the Emily Show channel after court today or during the lunch break. I'm interested to see what you think. Let me know in the comments over on the Emily Show channel where we do our daily case briefs. We skipped the morning recess. Let's go back to court for cross-examination. Shall we? Yes, we shall. Yes, we shall. Come on back, court. Come on. We're ready. I backed up too far. Shocking.
All right, Mr. Brennan.
Thank you.
And we're on to cross-examination.
Dr. Rentschler, facts matter, don't they?
They do, yes,
Facts.
You said it many, many times. Facts matter. Isn't that correct?
sir. It was details, but facts matter too.
Do details matter?
Facts do matter too. I feel very seen. But yes, he said details matter. And for Brennan getting up to say facts matter and him saying, actually, sir, I said details is just a fucking 10 out of 10. It's just a 10 out of 10. Actually, I said details. The details are so important that you've picked the wrong word. So that's okay.
Doctor?
I just need to back that up. It's pretty funny. It's pretty funny.
Dr. Rentschler, facts matter, don't they?
They do, yes, sir.
You said it many, many times. Facts matter. Isn't that correct?
It was details, but facts matter too.
Do details matter, doctor?
They do.
They're critical, aren't they?
If you want to prove that something happened a certain way, they're critical, yes, sir.
When you were talking to the jury and giving opinions about where Mr. O'Keefe might have fell or not fell, you were discussing where Mr. O'Keefe was lying on the side of the yard, weren't you?
Oh, the 10 feet
Where he came to rest?
versus
Came to
the
rest.
7 feet.
Well, approximately, we don't know the exact position, but yes.
You said 10 to 20 feet, didn't you?
I believe so, yes.
You said that 3 times, 10 to 20 feet. Do you
Yeah.
think Mr. O'Keefe was 20 feet from the roadway?
Well, I think he's maybe 10 feet, but 20 feet is from, if you're hit by the car, you need some distance to travel. He couldn't travel just horizontally, or perpendicularly. So it would be at least 10 to 20 feet if you look at the total distance.
You have no idea where the point of impact was in this collision, do you?
Nobody does.
I'm asking you, not nobody.
Yeah,
Excuse me.
So go ahead and ask the question.
Doctor,
Jackson. Don't object. Jackson, don't object. Jackson, let him cook. Let this witness go. Let him go. Let him go. This is not a witness you need to worry about. Let him ride. I know the urge. You can object. You can point out to the jury what the other counsel's doing. I don't think you need to with this witness. Look at his face. He's like, bring it. Bring it, guy. Bring it. Ask me about eating lunch. Let's go.
Wrenchler, before this jury, have no idea where the point of impact was of this collision, do you?
That's correct. There's no evidence.
Play exhibit 2, please.
That's right. There's no evidence of where the point of impact is.
10 to 20 feet, Dr. Wrenchler. Did you ever see this photograph before or part of this video?
I'm sure I have.
Well, when you say you're sure you have, are you guessing or have you seen it or not seen it?
I'm sure I've seen this before, yes.
So you've seen this before.
Yes.
And when you looked at this video, did you look at the street and look at the area where Mr. O'Keefe was?
Sure. Yes.
Sure?
Yes.
20
Where?
feet, Dr. Wrenchler?
The way I explained it to you, yes, sir. 10 to 20 feet.
Details matter, don't they?
They certainly do, yes, sir.
Take that down, please. Did you speak to anybody today?
Excuse me, Brennan, can you show me where in that video John O'Keefe was? Thanks. That would be super helpful. It'd be real helpful for me.
before you testify about Dr. Welcher's testimony in court?
I did not today, no, sir.
Before today, did you speak to anybody about Dr. Welcher's testimony?
I did not, no, sir.
At any point, did anybody discuss certain issues with you today that they said would be particularly important?
I don't believe so, no, sir.
When you began your testimony yesterday,
He just saw the
before
report.
you even finished your credentials, you began talking about your work with the NHL and how important it was to use a 50% hybrid 3 dummy. Do you remember that testimony?
I did, yes, sir.
And you hadn't even finished your credentials yet. Was it brought to your attention that there was an issue in the testing because you or Dr. Wolf or you and Dr. Wolf?
He was asked about it. He was asked about it by Jackson.
Chose to use a 50% dummy?
Not at all, no, sir.
In your preparation for your testimony, was it discussed at all that at the beginning you should get ahead of the issue and talk about the 50% dummy?
I didn't know it was an issue, no, sir.
Well, you know that the 50% dummy represents somebody who's 5'9", correct?
Approximately, yes, sir.
Approximately 173 pounds.
171, 172, somewhere around there.
And Mr. O'Keefe, how much did he weigh?
216, I believe.
How tall was he?
He was 73 inches, I believe.
So that is not a representative height and weight for Mr. O'Keefe, is it?
That height and weight, no, sir.
And so if you were making projections or analysis based on limb weights, they would be inaccurate if you didn't make adjustments, correct?
Well, they would certainly, the force on the limb would be less if you use a lighter limb. So if Mr. O'Keefe is heavier than the hybrid 3, and I use a hybrid 3, the forces I calculate would be an underestimate of the actual force acting on his body.
If you didn't
Didn't I say I was hoping someone would answer that? If it's lighter, there's less force, so it is a more conservative estimate, a lower estimate. It gives the benefit of the doubt. It does not overstate the force. It does not overstate the injury. Because Brennan would make the same argument the other way. That's heavier than John O'Keefe's arm. So that shows more damage to the car. That shows more force on the arm. That shows more injury. How can we trust that? You overestimated it because it wouldn't work, right? It would be the same argument, just the other way.
make an adjustment, but you relied on the numbers from the test 3, the hybrid 3 dummy, ultimately the conclusions would be off, wouldn't they?
They would be an underestimate. Yes, the actual forces would be higher.
And so did you make any
Damn it, Brennan.
conclusions? Or did
I don't normally complain about Brennan being quiet, but in this moment, he's wandered off.
you know that when Dr. Wolf did his tests using the hybrid 3 dummy, he didn't make any adjustments?
I gained him up.
What do you mean? What adjustments would he make? You get the acceleration. The acceleration's not going to change, and that's what we utilize. Then you can scale the weight of the body. But I'm not sure what he would have made adjustments for.
When you looked at the ratio, force and mass, if you use a lighter weight, the mass changes, doesn't it?
If you use a light, sure, yes.
And that changes the force equation, doesn't it?
That can, yes.
And so when you were discussing yesterday at the beginning of your testimony about the 50% dummy, had that issue been raised with you?
No, sir, it had not.
You had testified before, hadn't you?
In this case?
Yes.
Yes, sir.
And you knew there was a sequestration order?
Prior?
Yes.
Yeah, I didn't discuss the case with anyone, no, sir.
Well, you didn't discuss it with anybody, you said?
I did not, no.
Before you testified last year, you were receiving information from your employer.
Brennan, hold on, I'm going to get him back up.
The party that retained us told us things. I I didn't break any sequestration. They were the ones in contact with the court. So it was my assumption that whatever they were telling me was allowed by the court. They were the client. I didn't discuss anything with them or tell them anything, but yes, they told us certain things.
Before you testified under oath last year, you were getting updates from your employer about details of this case, weren't you?
Yes, Your Honor. Maybe approach.
Maybe we can approach briefly.
Interesting. Brennan has got to be real careful about how he asks these questions about the FBI, because that's not in this testimony. And if in the prior trial they were given information before their testimony, it doesn't really matter, because in the intervening time, or the in between, they were hired by the defense and given the full case file. So that makes literally no difference. And I don't think it undermines their credibility in the way Brennan might hope. So we're going to zoom past this sidebar and back to the cross. Is Brennan going back to the microphone so we can hear him? Great. No, wait, where are you
Before
going?
you testified
Go back.
last year, you were receiving information, not from the defense, from your employer, about other witnesses' testimony during the event, weren't you?
I don't know if they told us about witness testimony. They told us about certain evidence. I had no contact with the court, with the prosecution, with the defense. I had no idea what was going on. We were retained by a certain organization, and they contacted the court. They were in talks with the court about, I guess, what we could or couldn't do. Anything I got was from that organization.
Okay. The dramatic pause doesn't make it shady, Brennan. It also doesn't change the fact that they were hired by the defense in the meantime.
Order 2, 118, line 15.
Oh, we're going to try to impeach him.
Did you
with what?
testify under oath that they did inform me, yes, about testimony and situations and events that came forth
That's improper
in
impeachment.
the event that I was not aware of?
Objection. That's not inconsistent.
I don't know. They told us about evidence. I don't know if it was specific to who testified to what, but they told us certain things, certainly, yes.
That's not
What I
proper
just said
impeachment.
to you, are those your words, sir?
I have no idea. I mean, if that's what's in the record, I assume it is.
Would you agree it certainly helped you prepare?
It helped me prepare.
Yes.
It didn't make a difference to my analysis or conclusions.
Made no difference at all?
It did not, no, sir.
This is what I want to happen now. I'm going to diverge from reality into alternate reality. Here's what I want to see happen next. So what were those discussions about? Well, actually, we were just talking shit. We were shocked that this case was going forward. We couldn't believe what some of the law enforcement officers did. We were shocked by the way the witnesses were testifying. It didn't make any sense with the investigation that we were running with this other entity. You know, we had run all these tests with the vehicle, and yet here you are in trial. And we had no fucking idea what y'all were doing. So we sat around and talked shit. Ask him. Hey, somebody testified this, that. Does that square with your testing? No. Who would say that? Let's roll the tape. It's on YouTube. Let's go look. It was the office gossip. And if you're the U.S. attorney that can call up ARCCA and say, hey, does this make any sense? Aren't you going to do it? Lawyers are nosy as fuck. Hey, does this even make sense? Hey, can you do that? hey, Dr. Rentschler, they said this. What do you think of that? Come on, Brennan. Just keep asking. Keep asking. The entity that hired us wanted to talk about what they were saying because it didn't make any fucking sense. Keep asking him. You're going to end up with an answer you don't want.
Would you agree it
Oh,
helped you
boy.
understand what was going on during the trial?
Also, his answer was quite good. It didn't matter. Our analysis was already done. Nothing they said mattered to us. Our analysis had been completed.
Would you agree it certainly helped you prepare?
It helped me prepare.
Yes.
It didn't make a difference to my analysis or conclusions.
Made no difference at all?
It did not, no, sir.
Would you agree it helped you understand what was going on during the trial?
I don't think it made a difference at all, no. It doesn't change the facts that I evaluated or the analysis I conducted or the conclusions I came to.
And so as you sit here today, you are denying that information certainly helped you prepare.
That's not what he said.
How did it
He
help
said
me
it didn't
prepare? It
matter.
didn't change the opinions I offered. It didn't change what was in my report or what I'm opining to or testifying to today. It hasn't changed anything I've ever testified to.
I'm going to ask you a very specific question. I want you to give me a very specific answer.
What was that word? What was that word? Was it specific?
So just go ahead and ask the question.
Are you denying that receiving that information certainly helped you prepare?
Honestly, I can't remember. It didn't change my opinion. I don't see how it would help me prepare. I remember there was evidence about trace DNA found that we didn't know before. That didn't change my opinion then. It doesn't change my opinion now. It doesn't have anything to do with my opinion.
Details matter, right, sir?
Details can matter.
Details matter. So let's talk about detail.
Sure.
Are you denying that receiving that information certainly helped you prepare? Are you denying it?
He said, I don't know how it would.
I'm going to allow it.
It's asked and answered. Why are you
I
allowing
don't think
it?
that it did. It's been a year, but certainly it didn't change any of my opinions or what I opined to. It didn't change anything with my testimony.
I'm going to ask you one more time. I'll ask you a different question.
Asked and answered.
Receiving that information
Asked and
from your
answered.
employer, are you denying it helped you understand what was going on during the trial?
Asked and
I'm
answered.
going to allow that.
Why?
I don't even think that it did. I don't understand that.
He's answered it 3, if not 4 times. It's literally the definition of asked and answered. You don't get to ask again just because you do not like the answer. Asked and answer doesn't have exceptions like the hearsay rule to be like, objection, I don't like the answer, so I'm going to ask again. He's answering the question.
I understood what was happening. I understood what the theory was. So saying that there's trace DNA doesn't change anything. It doesn't affect what my understanding of the trial was or what was happening or what allegedly occurred.
He's just mumbling in the background.
When you were
Did you hear
traveling out
Brennan?
to testify,
Brennan was saying something under his breath. I don't know what he was saying under his breath, but that sounded like Brennan saying something under his breath. I don't know what he said. That's what it sounded like to me.
Understand that. I understood what was happening. I understood what the theory was. So saying that there's trace DNA doesn't change anything. It doesn't affect what my understanding of the trial was or what was happening or what allegedly occurred.
when you were traveling out to testify last year, you had phone conversations with the defense, didn't you?
I think I had like 2 phone conversations, 2 or 3.
So that sounds like a yes, you did.
Yes, there was one right before my qualification, my voir dire, where I talked to Mr. Jackson, and that was it. Other than that, I think it was just planning and scheduling.
Mm-hmm. Was there any discussion on how you could portray yourself as independent?
I don't believe there was.
So you don't believe?
Yeah, there was no.
They had a lot of conversation about how to explain who hired them without saying who hired them, which is a very unusual circumstance.
No need to.
That's not the question. Details matter. Was there any attempt?
Is that a question?
So the objection's sustained. I'm going to strike that, folks, okay? Questions, Mr. Brennan?
Was there any attempt in your conversations to portray yourself as independent as far as your arrangements were concerned in coming out here?
No, I don't think so, because there was no need to, because it was independent.
When you had conversations with the defense, did they offer to give you transportation, assistance getting here?
They provided a ride to and from the airport, yes.
And did you tell the defense that you prefer to take an Uber so that it would appear independent to a jury?
No, because I didn't take an Uber. I took their ride. If I wanted to appear independent, then I would have taken an Uber.
Did you have a conversation about that you were thinking about taking an Uber?
It didn't even cross my mind, sir.
And then after you testified, did you stay independent?
What do you mean independent?
Well, did you have any bias forming in you?
Any bias?
Bias, yes.
What do you mean? Did I have any bias?
Well, after you testified, where did you go?
Home.
Well, I was waiting for my ride, and to get back to the airport, they had to take other people, and so they were having a lunch afterwards, and they said, come have a sandwich, and then your ride will take you to the airport. So I went,
You
and
went
I
to
had a ham
lunch.
sandwich.
Had a ham sandwich.
God damn it. There's a ham sandwich. They aren't even muffins.
Did you testify at some point that after you had something to eat, you just stood in the corner?
I did. I sat at a table, ate, and then went over and literally stood in the corner waiting for my ride.
When you sat at the table and eat, did you just eat your ham sandwich? Or did
Did you have
more go
chips?
on?
Wait,
I
were they
ate.
Pringles? What kind of chips did you have? What's your favorite kind of chip? Sour cream and onion? No. That's a lot if you're going to travel. Vinegar? All dressed? Basic? What are we doing for chips? Did you have anything to drink?
People were talking. I really didn't talk much at all.
Did you listen?
Well, certainly, I'm sure I did, sir.
Did you laugh along?
I assume if something funny was said, I probably laughed.
Did you have awesome shooters and talk to awesome people? This line of cross-examination after the direct has just gone sideways into ridiculousness. Did you laugh?
Did you talk about your testimony?
I don't, at this point, I don't even remember.
Let me alert you to something. When you were there at the luncheon, did you see a camera crew
I believe I did, yes, sir.
filming and
If all of you are asking, how would they know this? Because they have the uncut footage from the docuseries that Alan Jackson and Karen Read wanted to have made. The footage is from the docuseries that was released prior to this trial. I think there's another film crew following them around now, but that's why they know, because the Commonwealth has all of the uncut footage from that docuseries. And they were filming, Jackson had them filming everything. And we only know that because I covered the docuseries briefly, and there was an article from the production company saying that the defense reached out to them. But does it matter? We'll see.
documenting, right?
There were a lot of cameras, yes.
You know that you might have been on some of that footage?
That's fine. I could care less.
Okay. So do you think maybe you were talking about the case and their answers and laughing it up a little bit?
I have no idea. Possibly.
Roll
You
the
were
tape.
Involved in conversations with
Just
the
play
defense
it.
attorneys? were
Play
you?
it. Roll it. Let's
What
see.
do you mean conversation, sir? I had just gotten done testifying. I was having lunch. Whatever was spoken about at the table, I'm sure I heard.
You
Roll
know what
it.
a conversation is when someone speaks to you and you answer.
Sure.
Did you have conversations with some of these folks?
Sir, I can't remember conversations I had last week, let alone a year ago. So I probably did, but I have no clue
you remember any-
what we would have talked about.
Do you remember?
Sir, shh. Don't say the quiet part out loud. Me, when I'm like, Dr. B, I told you this. And he's like, I swear you didn't. I'm like, I swear I did. Roll it. Just roll the tape. We just want to see it.
Accolades you might have been receiving because you had given certain answers to the then prosecutor on the case and laughing about the answers?
I have no idea. I can't remember last week what I had for lunch last Tuesday. How would I remember a conversation from over a year ago?
Are you going to roll the tape of them laughing at Lally?
Do you remember when you were having conversations with some of these folks and you were laughing about when the prosecutor asked you about other evidence like DNA? You had a response, well, the physics doesn't change.
He just said that the physics
I
doesn't
don't
change.
specifically remember that, no, sir.
How long were you at the table eating your ham sandwich with the
Can somebody get Brennan a fucking sandwich? He is so salty. He is so salty.
folks there enjoying the event? How long do you think that went on for?
I honestly don't know. 10 minutes? How long does it take you to eat a ham sandwich? 10 minutes?
And after you finished your ham sandwich and then you told us you stood in the corner, you got a ride back to the airport?
I did, yes, sir.
Yeah. After you got back
Where
to
the
the
sandwich
airport,
got ordered from? What kind of bread was it?
ultimately your
What about the
company
condiments?
billed
Mayo?
the
Mustard?
defense
What
for
else?
your time
Cheese?
preparing and traveling and testifying?
I believe they did.
Well, you wrote your bills down, didn't you? You wrote your time down?
Well, I don't know who gets billed to it. I think it was actually, I wrote my time down and it was the same time code for the original employer that we had. I'm not involved in billing. I don't know who the bill goes out to. I just put my time in and do my work.
Do you know that the defense paid that bill?
I have no idea if they paid it or not.
And then now you have a new contract with the defense. Or I should say you have a contract with the defense, don't you?
I assume ARCCA does. Again, I'm not involved in that. I don't do any part of the financials. I just do my job.
Do you keep your billing?
I enter my billing every week, yes.
Do you know how much you've been paid so far in this case?
I haven't been paid anything. I'm a salaried employee for ARCCA. I have no idea how much ARCCA's been paid.
How much has ARCCA been paid because of your work so far?
He just said I had no
I have
idea.
no idea. I'm not involved in the financials, sir.
You have no idea how much time...
Brennan's back at the mic, so I'm
your
gaining that
company's
back
gonna
down.
get for the work that you've done and continue.
Is it more or less than $350,000? Just the one question.
To do on this case, you have no idea.
Yeah, it's not my concern. It's not my department, so I don't.
That's a no?
That's a no, sir.
Now, when you
Yeah,
communicated
no.
with
That's
the,
different than no, yeah.
defense, you texted, didn't you?
When?
At any point.
There were some texts, yes.
And at some point, there was a court order for you to bring a copy of your text?
This line of questioning, this one actually about the text messages is probably more helpful. Brennan keeps doing this with his cross, though. He thinks certain things are served that aren't, and then it overshadows the other things that might be a point of contention that might make the jurors raise an eyebrow. The jury at this point's not raising an eyebrow about somebody eating a sandwich with the attorneys after testifying. But the court order, maybe they would. So start with that. It's just wild. But after the bickering back and forth about the sandwich, everybody's like, okay. If everything's too much, it's too much. And maybe you do this at the end of your cross and ask him about his testing. But if everything's nefarious, then nothing is, right?
I believe so, yes.
But when you say you believe so, details matter.
Yeah.
Do you know whether there was a court order for you to bring your text?
I believe there was, yes.
Did you comply with that court order?
I complied with whatever I had.
Did
Yes.
you have any of the text messages?
I don't believe so.
What happened?
Well, there were like 2 text messages about where I could get my ride and what time. And so after that day, like I do many times, I'd probably erase those texts.
When you say probably, did you delete the text that you had with the defense last year during
He swiped out the conversation, deleted it.
Again, I had like 2 texts about scheduling, and I'm sure I deleted them like sometime around that time, like I do with most texts.
Did you ever use Signal?
I did not, no, sir.
Why not?
I have no need to.
Why would you have a need to?
I'm going to allow it.
I wouldn't have a need to. That's why
He
I
said,
said
I
I
have
don't
no
use it.
need to.
What's Signal for?
It's for, I think, for encrypted messages.
And texting.
Do any of your colleagues use Signal to have conversations with their clients?
I'm going to allow that you're aware.
Why?
I have no idea
It's
what,
not relevant
what my
at
fellow
all.
employees or cohorts do.
How
One
is
of your
this
fellow
relevant?
employees is a gentleman by the name of Dr. Wolf. Yeah.
That-
You worked very closely with him on this case, didn't you?
I've worked with him on this case, yes, sir.
And
Brennan,
working with him.
stop it. If you keep talking about working closely with Dr. Wolf, the chat is going to get jealous. Brennan, we cannot stand for making chat jelly. Well, we are down this ridiculous rabbit hole.
On this case, were you aware of his habits, of whether or not he used encrypted apps like Signal?
I'm going to allow it.
I'm not aware of Dr. Wolf's habits, no, sir.
What kind of toothpaste does he use? Does he make coffee in the morning? What kind of coffee? Does he make
When you
coffee for
worked
his spouse?
On this case, when you began, you
Is
worked
it a
with
latte
a gentleman by
or
the name of
cappuccino?
Mr. Klein.
But Scott Klein is another engineer at ARCCA that worked on the case, correct?
And you worked with Dr. Wolf.
That's correct, yes.
You worked as a group?
Well, I mean, we all worked on the project together. I'm located in the Pittsburgh office, and Mr. Klein and Dr. Wolf were in the Philadelphia office. So we didn't physically work together, but we worked on the same project, obviously.
When you first began your testimony yesterday, you said that you were restrained in what you could do. Do you remember that testimony?
I do, yes.
And when you said you were restrained, were you attempting like a preemptive strike because of certain things you didn't do to try to ward off any questions about that? Objection.
Sustain.
Let me ask
What?
it this way. Were the rules different regarding your initial investigation for you as opposed to Dr. Wolf?
I don't know that they were. I don't believe they were.
Did Dr. Wolf have free reign to do whatever he wanted?
Sustained.
Were you given free reign to do whatever testing you wanted?
I don't believe we were, no.
You, though, were you?
Was I?
Yes, were you given free reign to do whatever testing you wanted?
I mean, there was budgets, and we had to stay within certain values. So I wouldn't say I was given free reign because I couldn't do whatever I wanted.
Did anybody tell you what tests you could or couldn't do?
I don't think there was a list of specific tests or not, but you would discuss what would be done or what we could do and what the cost of those tests would be.
Were you free to suggest any tests that you wanted to?
I'm assuming I could suggest whatever I wanted to, sure.
Were any of your suggestions denied?
I can't remember. I don't know that they were. I mean, we had what we were constrained is what the client
What the
wanted to
question
know. And
was.
so we tailored our tests to
So
do
the
that
question-
and tried to keep the budget and the cost of what we did in our analysis down for that very purpose.
Could you have suggested crash tests?
Probably could have suggested whatever I want.
Did you suggest crash tests?
Oh, he's going to get into why didn't you do this? And he's going to start getting the same answers as Dr. Laposada. Once we determined that it wasn't possible, there was no further testing that was needed. That's the direction that Brennan's going in. And that's what Dr. Laposada said. Do you care what speed the vehicle's going? She's like, the vehicle didn't hit this deceased. So no, I don't care what car. I don't care how fast the car was going. The deceased wasn't hit by a car. So I don't care. It's the same. Did you test whether this injury would occur from falling off of a horse? No, there's no indication that somebody fell off a horse. So we didn't test somebody falling off a horse. Okay.
Honestly, I don't know. I mean, it might have been brought up, but pretty sure that would not have been within the budget. So
I want you to be detailed. I don't want you to guess.
So without that
The commentary.
Go ahead and just ask the question, please.
Did you suggest doing crash tests last year?
I can't remember. We obviously didn't, but I don't know if that was brought up or not.
Do you, since your memory is difficult,
Sustained. Okay.
Jackson said, may we approach? I think Wrenchler can handle it. Maybe I'm pettier than Jackson is, but if Wrenchler was my expert, a part of me would be like, go for it. But it can make the witness look bad if they start clapping back. But I think I would also, at that point, say, objection, Your Honor, we just insult witnesses now? That's what we do? Sure. Okay, that's a long sidebar. Brennan is treading into territory that he knows he can tread into, because even if he puts these witnesses in a position where they need to answer what their former employer asked them to do, they might not be allowed to. And I don't think he's worried about it at all.
To remember things, do you write them down?
That's one of the ways you can do it, sure.
Do you do it? Do you write down things so you don't forget?
Depends what it is.
Okay.
Do we have a question? Or just more commentary?
You provided a CV, which is a resume.
Oh, we've
That's
moved
correct,
on.
yes.
Resume outlines your education,
Yes, sir.
areas of specialty,
Correct.
and then it highlights your accomplishments as far as the focus of your specialty or the focus of your profession, what you like or what you do a lot, right?
Some of it, yes, sir.
So, for example, you have a number of publications that are peer-reviewed.
Correct.
And peer-reviewed publications mean that you've written something that's been evaluated and considered by other experts in the industry
Yep.
and have been adopted or recognized, correct?
Well, that it's been published, yes, sir.
You have a long list of peer-reviewed articles dating back to 2003. Is that correct?
Yeah, as I said yesterday, most of my peer-reviewed articles are all written when I was in graduate school. Correct.
Have you had any peer-reviewed articles since 2003?
Probably not. No.
And your peer-reviewed articles, 2003, deal with the evaluation of selected electric-powered wheelchairs.
That was one of them. Yes, sir.
The next one, intelligent walkers for the elderly.
Correct.
Comparison of fatigue life for 3 types of manual wheelchairs.
Yes, sir.
Evaluation of a pushroom activated power assisted wheelchair.
Correct.
Displacement between the seating surface and hybrid testing dummy during transitions with the variable configuration wheelchair.
The hybrid 3. Yes, sir.
Assessment of manual wheelchair ride.
Correct. I was looking at forces and accelerations on the body. Yeah.
Fatigue life of 2 manual wheelchair cross brace designs.
Fatigue
Yes,
life
sir.
on a real wheelchair is like a
Evaluation
huge
of selected
issue.
ultralight manual wheelchairs.
So, okay.
Yes, sir.
Augmentation of 100 key ISO wheelchair test dummy to accommodate higher mass.
Yes, sir.
And so you would agree that all of your
Wait, can you just ask him if he has
Peer review
family
article.
in the wheelie community? Because now I'm very curious, because he did a lot of his work in mobility, which I think is very cool. But now I have a lot of questions. It's not about this case. Now I'm even more curious. Okay. So we worked on making walkers and wheelchairs more effective for people. Okay.
deal with wheelchairs.
Well, wheelchairs and the kinematics and kinetics forces associated with propelling wheelchairs and injuries associated with that. Yes, sir.
Do any of them deal with pedestrian collisions?
No, they don't.
You've written a book chapter,
Yes, sir.
Smart Technology for Aging.
Yes, sir.
Can you?
And again, nothing
Sir, we
on
need it.
pedestrian accidents.
That's correct.
Expanded abstracts, you've written a few.
I have, yes, sir.
Suffice to say, dealing with wheelchairs.
And assistive technology, that's correct, yes, sir.
Any have to do with pedestrian collisions?
I don't believe so, no.
Looking at your CV, you can
Though at Metallica, there was a moment where I thought there was going to be a wheelchair pedestrian collision. The gentleman was saying, "Move, I bite ankles," which I thought was very funny, but people could not always see him in the concert crowd. And I was waiting for him to just start blasting, like, "Move, bitch, get out the way." But I was worried at that point. I was like, somebody's not going to hear you and move out of the way. They did, though. They got right out of the way. It was just, but I think you can definitely have a wheelchair versus ped collision because pedestrians don't always get out of the way or know that there's a wheelchair behind them. So I was waiting for him to just push play, but that's beside the point. Why are we getting into, so sir, you did all this work? You did all this work, but not pedestrian collisions. Kinematics on the human body are, okay. You guys know what I
note
mean.
any area of specialty you'd like. Correct?
You can put down whatever you like, I suppose, sure.
Sure. Have you listed any specialty as pedestrian collisions?
Well, not specifically. That actually falls under impact biomechanics, biomechanical injury causation. So I didn't list it specifically, but it certainly falls under the actual expertise that I perform.
Right, because kinematics and bodies and wheels.
Now, doctor, when you worked with Dr. Wolf, did you have a chance to look at his report?
I did, yes.
If you saw anything in the report that was off or mistaken, would you have an opportunity to discuss that with him?
I'm sure I would, yes, sir.
Did you find anything about his report that was wrong as far as data?
I don't recall. If I did, I probably would have talked to him, but I don't recall.
You and Dr. Wolf were collaborating together, weren't you?
Yes, sir.
And when you collaborate, you relied on each other's data at times, didn't you?
To some extent, yes.
And
Some
relied
things
on your
Dr.
experts'
Wolf
data
did, you
too.
relied on ultimately for your interpretation and your conclusions.
I did, yes.
Did you write a report and talked about the acceleration of the ATD, the test dummies, regarding its hands and arms?
I did, yes.
When you wrote your report talking about this very specific data, do you remember what you determined was the acceleration for the ADT right hand at 29 miles per hour? How many G's that was?
Let's see. Accelerations for the right hand.
Page 6.
Yeah, it looks like 863 Gs.
And when you were comparing data with Dr. Wolf, if something was different or off, would you correct it?
Oh, I'd talk to him about it, sure.
Okay. Did you ever talk to him about his collection of data regarding peak acceleration that the arm and hand experienced at a 29 mile per hour collision?
Well, when I think that 863 is from 1,000, the CFC 1,000 hertz low pass filter. And in his report, he used a lower number from a 180 hertz. So they're both accurate numbers. It's just how you actually filter the data.
So you know what I'm talking about, right?
I do, yeah.
Yeah.
And I ended up using a lower number than when I did my calculations.
Could we have Exhibit 1, please?
I think Exhibit 1 is the photo of John O'Keefe's arm, if I remember correctly.
You've talked a lot about this photograph. Do you see it?
Yes, they finished each other's
I do,
sandwiches.
sir, yes.
And you described, well, you didn't describe, you read that these were superficial abrasions, correct?
That's the diagnosis, yes, sir.
Any of those wounds of puncture in your mind?
I don't make medical diagnoses, so I'm not going to comment on that, sir.
Well, you talked about x-rays and injury. I know you don't make medical diagnosis, but you were very
Ooh,
careful
the sarcasm.
about what this was. Not a laceration, right? It is a superficial abrasion.
That was what was diagnosed by the medical records, yes, sir.
And you were very careful to make that distinction when you
He took the information from the ME. The ME said superficial abrasions, so he said superficial abrasions. Regina George wore cargo pants and a tank top and flip-flops. So I got cargo pants, a tank top, and flip-flop. What? Brennan, what? He didn't make a diagnosis. He took it from the ME's report.
were critiquing Dr. Welch, weren't
Sustained in
you? And so you also looked at x-rays, didn't you?
Yes, sir.
And when you looked at them, did you try to give the impression that you've read them, even though you're not a doctor and you can interpret them?
Sustained.
Were you trying to interpret them for us?
No, it was actually interpreted by the medical examiner that there were no acute injuries.
So when you were giving all that information to the jury about the x-rays, was that your personal opinion, or were you just regurgitating something you had read?
That was the medical examiner's opinion, but certainly you can look at the x-rays and see that there are no actual fracture lines or space displacement between the joints. But it's the medical examiner and his diagnoses that I rely upon.
So when you were going through an explanation of all these different photographs and x-rays, you weren't trying to portray that you were giving your own personal opinion about it?
I don't give diagnoses, but if there's no fractures on an x-ray as diagnosed by an MD or physician, you can look at the x-ray and then you can see why there are no fractures. You can look at the x-ray and see where the fractures are if there's a diagnosis. So the diagnosis was no fracture, no acute injury, and that's certainly consistent with looking at the x-ray itself.
Hey, Brennan, why didn't your expert have x-rays? Why didn't your expert have x-rays? I'm real curious.
So when you were looking up the x-ray and holding it up, was that just a prop? I mean, were you simply just regurgitating what you read in the report? Or were you
Now
doing
it's
a
asked
certain
and
kind of-
answered.
Sustained.
Were you doing any kind of
Now it's asked and
analysis
answered.
yourself when you were sharing with us what those x-rays showed or didn't show?
That's argumentative.
The analysis is that there's no fracture or acute injury, and that's what the medical diagnosis is, and that's what the x-rays showed.
Are you giving us your opinion, or are you regurgitating what you read in a report?
That is
Both.
what the medical diagnosis is, that there's no fractures and no acute injuries. That's what the medical opinion is.
So you're regurgitating what's in the report.
Sustained in that form.
Did you see any MRIs?
I don't believe any MRIs were taken or performed.
In
no.
x-rays, does it depict deep soft tissue damage?
Normally, it does not depict soft tissue damage, no.
How about muscle tears?
No, it does not.
So now, Brennan, are you going to bring your expert in to say, well, we don't know if there was ligament damage? The medical examiner did a visual examination of the different layers of the muscle of John O'Keefe's legs to see if there was bruising. And you're going to rest your case on, but you didn't see an MRI? Really?
How about tendon tears?
Not normally, except you can see laxity in the joints if there is tendon or ligament tears. Normally, you can see laxity in the joints, but it doesn't show the ligament or the tendon itself.
Nerve injuries?
No, sir.
Avulsion fractures?
Yes, sir.
People sometimes get MRIs to see if there's a fracture that doesn't appear in an X-ray.
You're not getting an MRI for an avulsion fracture, Brennan. What?
Yes.
Sometimes x-rays are the best for looking at bony fractures. MRI is looking at soft tissue injuries.
Speaking of wounds, you've cited a number of references, a number of materials in your reports, haven't you?
I have, yes, sir.
And one of them that you've cited is forensic pathology.
Yes, sir.
This is a legitimate source to you, correct?
Yes, sir.
And you've relied on it for at least part of the basis of your study or opinions.
Well, I relied on it because it speaks and looks at the difference between, for instance, a laceration and an abrasion.
Brennan, I'm going to feed my
A
Snorlax.
person could be struck by a motor vehicle and not indicate any bruising to that area, wouldn't you say?
At what speed, what part of the vehicle were they contacted, what part of the body were they contacted? It depends on the amount of force associated with that. There's a number of variables involved.
Okay. Does
Right.
the absence of a bruise indicate that there was no blunt force trauma to the area?
I'm going to allow it. Can you answer
Why?
that?
Oh,
Well,
now
the
we
absence of a
now we can give medical testimony. So now we can give medical testimony. He can't talk about the report that he was hired to evaluate. He can just give medical opinions. Sure.
bruise, can you repeat that again?
You were talking about bruising.
Yes.
Does the absence of a bruise necessarily indicate there was no blunt force trauma to an area?
No, you have to look at all the evidence and you have to look at the force. If there's 4,000 pounds of force applied to the body or to the arm, then certainly you would expect a bruise. And if there's no bruise, then you would have to question if that impact or contact actually occurred. You don't just look at that by itself in isolation. You look at all the variables and facts involved with the case to determine if an injury occurred.
Have you ever seen collisions where more than one person was hit or struck by the vehicle?
Multiple pedestrians, you mean?
Yes.
Yes, sir.
And have you ever seen in a
Sadly, so have we.
collision where the vehicle's going the same speed
We didn't
when
go
it
over
hits
it a ton in the
multiple
Brooks
different
case.
people, there can be multiple different injuries?
That is so vague, and you'd have to go back and look at a specific case, look at the injuries, look at the vehicle, look at the people. You can't just say, is it possible this could occur? You have to
Anything's
look at a
possible.
specific case and demonstrate that that could actually happen.
Well, I'm not
Excuse
asking
me,
for-
Dr. Wrenchler, we learned that A, bones are inside the body, and B, anything is possible, and that Lexuses can be spaceships. So, vague is not vague. I will not accept vague. It can be a spaceship.
Possible. I'm asking in your experience.
I'm being hyperbolic because I'm
have
annoyed.
you-
I'm going to allow that.
Have you ever been involved in evaluating multiple pedestrian crash where there are multiple pedestrians hit by one vehicle and they sustain different or, in some cases, no injuries? Has that ever happened in your study?
Sure, because it depends where they're hit, what part of the body they're hit on, what the force is for that hit. The people aren't going to be hit the same
It
multiply
depends.
by one vehicle. You can certainly have multiple people and different types of injuries.
Have you seen people hit by a vehicle at a particular speed and have certain injuries, and then you've seen other cases where people are hit by a vehicle similar speed but have no injuries? Have you ever seen that?
I'm going to allow it.
So what do you mean by injuries?
Have you ever seen, in any of your cases, a pedestrian hit at a certain speed and have injuries, and another case where you look at where there is a similar type collision with different injuries?
What?
So again, do you mean abrasions, cut, laceration, fracture? Do you mean same cards? It's not something that you look for and compare between cases. You'd
it
have to go
depends.
back and actually study the cases and look at the details.
Give him the full, it
Having
depends.
experience in pedestrian collisions, you can't think of a similarity between cases as far as vehicles and speeds and totally different injuries occurring.
I'm going to allow that. Can you?
It's
do you
asked and
mean
answered
hit the same way with the same type of car at the same speed with the same force?
with different results.
I'm going to allow it. Can you answer it?
I don't believe I've ever seen a case where two people were hit with the same car at the same speed with the same force with different injuries. I don't even know if you can correlate that.
Looking at Exhibit 1, have you done any study about the directionality of glass or broken plastic?
What do you mean by directionality?
About when something shatters, how it shatters. Does it shatter the same every time, or when plastic shatters, does it shatter differently?
It certainly depends on the impact.
Do you have any studies where plastic shatters exactly the same way on different impacts?
I doubt that it shatters exactly the same way.
It has a lot of different variables, doesn't it?
It could.
Depends on a number of different equations, doesn't it?
I mean,
Well,
everything
it
depends.
depends on the testing you do. If you want to see how it shatters, and if you're claiming that it shattered in a certain way to cause a certain injury, if you don't have any peer-reviewed evidence, if you don't have any research, then you have to do the testing, because you can't just say, well, it's possible it could shatter this way and cause that injury. That's not conclusive. You can't use that to come to an opinion about what happened.
Oh, that wasn't what I was asking you. I was asking you if you have seen in cases that when plastic breaks, it breaks differently.
And his response to
Well,
you was,
sure.
what?
I mean, the testing we've done here, the taillights covers fractured differently, and we didn't get any contact. So I have personal experience just with this case alone.
We'll
sir.
get to the contact. When you looked at all the tests you did, the plastic broke differently in each and every case, every experiment, didn't it?
Sure, it's broken like that, and I've never seen a case where you get these types of abrasions.
I didn't ask you that.
He didn't ask that.
Is that funny?
No, it's not funny.
Okay.
So,
I need to see Brennan's face to see why he's responding that way, but that's not what Brennan asked. The thing is, Wrenchler knows where you're going, Brennan. And so he's answering the question that hasn't been asked. And Brennan is now piecing down his questions. But Brennan's also just clapping back in a way that is dismissive and rude.
Every experiment, didn't it?
Sure, it's
I wanted to hear
broken
what
like that, and I've never seen a
Jackson
case
said.
where you get these types of abrasions.
I didn't ask you that. Is that funny?
No, it's not funny.
Okay.
so I'm going to strike the comment. Next question. Next question, Mr. Brennan. No more comments.
When
She's told Brennan no more comments twice now in this, if not 3 times in this cross-examination. And normally I would be like, Jackson, you can't just yell over the court, but it seems to be the only way that the court is going to say anything to Brennan. So I don't know what else the attorneys are supposed to do, because it's wild.
you did your experiments, the sizes of plastic that broke were different in each experiment, weren't they?
They were, yes.
The number of breaks in each experiment were different, weren't they?
They were, yes.
The angles of the break changed from piece to piece, experiment to experiment, didn't they?
I'm sure they did.
Did you watch the videos and watch the damage and take a look and count
Yes.
how many pieces broke in each experiment?
Oh, probably
I
not
didn't
that.
specifically count. No, we looked at contact to the sleeve and to the dummy itself.
You never counted the broken pieces in each experiment?
I did not. There was no need to.
Not a matter if there's a need, did you?
I did not. No, sir.
And he did not, because he didn't see a need to.
You had talked quite a bit about Dr. Welcher's test with the paint, so I want to ask you some questions about that.
Sure.
Were
I
you
wanna
ever
hear it.
under the impression that Mr. Welcher, you can take that down, please. Were you ever under the impression that Dr. Welcher was trying to reenact the actual collision when he did that blue test?
I'm going to allow it.
Well, that was the only.
The funnier answer would be, and this is a professional witness in a courtroom, so I'm sure he will be more respectful than where my brain is right now. Did you think he was trying to reenact that night? Well, he was holding a glass. He was dressed as the victim. He was completely dressed as the victim. So based on the cosplay, yes, I thought he was LARPing what happened in the accident. Will this witness do that? No. But also, based on everything that he did, yes, I thought he was trying to recreate it. I thought he was trying to reenact it. Yes, I did. Because what else do you think he's doing? Because the other option that I see, and chat, let me know what options you see. The other options that I see are that he's trying to match the injuries. He's not trying to explain. He's not trying to test. He's trying to match. But if he's trying to match, then he has incentive to lean into the car, to stand forward into the car and the rest of it. So what else is he doing? Is he trying to recreate?
You some questions about that. Were you ever under the impression that Mr. Welcher, you can take that down, please. Were you ever under the impression that Dr. Welcher was trying to reenact the actual collision when he did that blue test?
I'm going to allow it.
I'm
Well,
glad you allowed
that
this.
was the only test he performed, and he referenced that test for his opinion that the position and orientation of the lacerations are consistent with the taillight cover. So if that test was not intended to signify or demonstrate the position of the arm, he has no evidence to say the position and orientation of the arm in the lacerations, which are abrasions, are consistent with the taillight cover. That's the only test he did. So if it doesn't represent that, it's really meaningless in his analysis and conclusions.
Now that you've shared your opinions, can I get back to my question?
Sustained. So, Mr. Jackson, Mr. Brent,
Why are you telling Jackson to stop? Brennan has done it over and over and over, and you've said no more comments, Brennan. And he keeps doing it, and you don't say shit to him. At what point are the lawyers in court going to lose their mind? Apparently, this is the point. Because you haven't said anything to him other than no more comments. I'm going to back up and let the attorneys yell at each other. Because, again, normally I would yell at the attorney that they can't do this in court. But he has asked at least twice now for Brennan to be admonished, and the court has said no more comments, Mr. Brennan, just questions, and then he keeps doing it. So at some point, what do? He's asked for sidebar, didn't change. So yeah, at some point you stand up in court and you yell. I'm going to give him that one. He has been pretty patient this trial with the way Brennan has done cross. It seems the patience have worn out. Also, the court established yesterday, if you keep asking, she'll change her mind. And that's on the judge. So yeah. Earlier in the trial, I was like, Jackson, sit down. What are you doing? This is ridiculous. Now, I don't think there's anything else that can be done. Because Brennan won't stop. And it seems that he's forgotten his role as the prosecutor. And she should admonish him in front of the jury. All right, I want to hear what the lawyers say. I'm going to gain this volume up so the speaker into the mic's going to get loud, but I'm going to gain it up.
That test was not intended to signify or demonstrate the position of the arm. He has no evidence to say the position and orientation of the arm in the lacerations, which are abrasions, are consistent with the taillight cover. That's the only test he did. So if it doesn't represent that, it's really meaningless in his analysis and conclusions.
Now that you've shared your opinions, can I get back to my question?
Sustained. So, Mr. Jackson, Mr. Brent, all right, I'm going to see counsel at sidebar.
The clerk looks exhausted. Jackson sounds pissed, and he has the right to be. And Brennan doesn't seem to be bothered. What I heard Jackson say was, I'm going to ask that counsel be admonished. And she was telling Mr. Jackson to stop making a record because she's asked for no speaking objections. So then she said, fine, sidebar. And Jackson stopped when she said, let's go to sidebar, which some lawyers wouldn't do. They would keep yelling. Are they just going to go to lunch? Is the court just putting all the lawyers in timeout? I think the jury's going to lunch. And everybody went to lunch. All right, well, it will give the attorneys a minute. And yes, the court can admonish the lawyer. The jury is at lunch. yes, the court can admonish the lawyers in front of the jury. Counsel, no more comments. She can also pull them to sidebar and say, if there are any more comments, it's $500 in sanction per comment. She absolutely can. Rock and Roller said, Emily, have you ever seen anything like this? Oh, it was way worse in New Mexico with Carrie Morrissey, and I am forgetting the defense attorney's name off the top of my head. It was wild in the Hannah Gutierrez case, and then at the beginning of the case with Alec Baldwin, because Carrie Morrissey did the same thing. And so with not Spyro was the attorney for Baldwin, Bowles, yes, and Bouillon. And it just kept ramping up with them just fighting with each other. It was worse in, what was the case that was recently in LA? The defense attorney was also from New York. It was John Lewin's case. I am forgetting the name of the defendant, but it was worse in that case too, where they were just screaming at each other. And then the judge would be like, jury out the ASAP Rocky case, thank you. And jury would be like, the judge would send the jury out and just be like, stop it, stop it, stop it. And the attorneys were like, I couldn't watch it. The attorneys were fighting so much, my blood pressure was 10 out of 10. So yes, no, I've seen it way worse in a lot of cases. This has been mild, but I find it distasteful. It will shock you that I, as a very neurodivergent girl, lean into the rules. There are rules of order. You can't do that. But if you start to throw fouls, I will throw fouls back. And that is what's happening in court. Brennan is starting to throw fouls. Jackson is clocked at 3 or 4 times during this cross, and then is throwing fouls back. They have been pretty mellow. Brennan's comments are not nearly at the level of some of the attorney fighting we've seen. I do not like it. I also find it incredibly off-putting when Brennan is acting as a defense attorney doing the prosecution work. I find that there is less tolerance, particularly for me, of that style of cross-examination when you are the prosecutor. Less room for commentary, less room for, well, I know you don't want to answer the question. Oh, you don't like that question? The jury can see it. Am I going to give him a hard time if he goes, okay, and then ask the next question? No. But it is over and over and over again with commentary as the prosecutor. And it is almost every single witness. We have not seen a ton of that from Alessi's crosses. We saw more of that in Jackson's crosses last trial. We have seen less of that in Jackson's crosses this trial. And even after the court has told Brennan to knock it off, he doesn't. He just doesn't. It is a lot. And if you have questions about the testing, get into the questions about the testing. I want to see good lawyering. I don't like all the obfuscating. I can't even pronounce it properly at this point of the day. So let's do a little bit of a wrap up for today. I'm going to take a break for lunch. You should take a break for lunch, but let's do a little bit of a wrap up for where we're at the lunch break. Because I said, will we get done with witness Wrenchler before the end or before the lunch break? And the answer is, well, 100%.
Nope. Nope.
No, we won't. No, we won't. Because the cross-examination of Wrenchler is not focused on the testing that Wrenchler has done up until this point. We are just starting to get into what testing Wrenchler did in the cross. We had a thorough investigation of ham sandwiches, and who Rentschler ate lunch with and whether or not it was awesome, and if he laughed when people made jokes, and if he stood in the corner, and who paid for his transportation, and whether it was an Uber from the airport or not. We thoroughly investigated that area of questioning. And Rentschler remained steadfast that I haven't changed my opinions in this case. Those things do not change the examination that I did. Okay. So the questions that might impact the jury, I think, get lost under the snark about sandwiches. The jurors might disagree. If the jurors are looking at this witness as a hired gun for the defense who's just going to come in and say whatever the defense wants, they might feel differently. And we often see that in prosecutions where people feel that the fancy paid experts from the defense are the hired guns. I don't think that holds in this case because we're not looking at hired witnesses versus non-hired witnesses, which is truly a misnomer, but jurors don't often see it that way because oftentimes the experts for the Commonwealth are from the state crime lab or from law enforcement, and they're paid for their jobs on salary, just like experts for the defense are paid by their company on salary. But the juries often see it differently. When you have, the crime lab analyst who's like, the cases show up and I do my job. They see them differently than hired experts who are chosen. But that's not the case here. And Brennan seems to forget that. The case here is that you had an expert from law enforcement, chose not to use that expert from law enforcement, and went out and picked another expert and paid them multiple six figures. So I think you lose the steam of these experts were paid by the defense when we know how much your experts were paid. And I think the number of how much they are paid undermines that argument. All the experts in this case were paid to come in and testify. I think it just neutralizes the serve of, oh, you just paid people to come in here. I think the amount that the witnesses for the prosecution were paid takes all the wind out of the sails of that argument. It really does, because it was a staggering number. And I've never seen anything quite like that. Hundreds of thousands of dollars. Absolutely wild. But what we're seeing today is that Brennan's not even asking about Rentschler's testing. And we've seen that in other cross-examinations too. I was critical of Alessi and a cross for the same thing. We're not talking about what the expert did. We're talking about the expert. Are we going to talk about Dr. Rentschler's testing? Or are we not? Are we going to continue saying, oh, but you didn't see an MRI of John O'Keefe's arm, so you don't know if there was ligament damage or muscle damage? I don't know if that helps the Commonwealth move beyond the testimony of Dr. Rentschler, which is not helpful for them. The testimony of Dr. Rentschler is these injuries to John O'Keefe could not be sustained by being struck by a vehicle. And he went through a couple of different options of being struck by a vehicle and falling backwards, being struck by a vehicle walking and falling backwards. He went through a couple different scenarios and said, you can't get this injury pattern from a collision with the car. And he went through and talked about the different ways that the taillight would send out fragments and why those fragments wouldn't cause the injury to John O'Keefe's arm. And I think the visuals on that were incredibly helpful. Tell me what you think. Do you think the visuals on why it doesn't make sense that fragments from the taillight cause those injuries helped more than any of the other testimony we've seen so far? I think it was very good visuals, and jurors will remember the visuals of the arrows pointing at the different directions of the injury to John O'Keefe's arm. Because in all the videos we saw of the taillight is moving in the same direction out and away from the vehicle. So we will see, but we're definitely not done with Dr. Rentschler's testimony, and I feel like we're going to go into testimony into the morning tomorrow, but that still puts them on track for closing on Friday. So on this Wednesday, we're waiting to see when the defense rests, and it will be after this witness, and whether or not Brennan will get admonished by the court in front of the jury, not in front of the jury, and whether the commentary versus the questioning will persist after lunch. We'll see, won't we? Let's do a few questions, and then we will get, well, to a lunch break because the jury's not back yet. And it's a good opportunity for me to, I don't know, get a ham sandwich. I don't even think I have ham in the house, but who else is having a ham sandwich for lunch? I don't know. Minsky, thank you for the gifted memberships. I see that you've gifted a tremendous amount of memberships. You've just made it rain. Thank you so much for the gifted memberships. Welcome to all the new law nerds. As we get into the gifted memberships, all of you who got memberships are going to be like, oh my God, there's no more slow mode. Yes. There's no more slow mode if you are a member on the channel, so you don't get timed out by the slow mode, which the mods, I'm sure, are like, oh boy, the chat is moving faster. So thank you for all of those gifted memberships. That's tremendously generous and builds this community. So thank you. We have grown with each trial as we do. So for those of you that have found this channel during the trial, welcome. For those of you that have been here for quite a while, isn't it always fun to see the new law nerds being like, oh my God, I love being in the chat. It's so much fun. Melanie Webb said, Miss EDB, have you ever stood up and yelled? Oh yes. Oh yes, I have. Not often in front of a jury though. But yes, there have been times I have been frustrated, and there have been times where I have been very frustrated in my advocacy. Never been fined. So that's never happened. Kells asks, has the judge ever overruled out loud the prosecution? Yes. In cross-examination more, but yes, she has. Minsk said, my bias and agitation in the injustice and BS of the investigation, I can say that your explanations and opinion helped me get grounded. So glad we caught up with you on the live. Good to see you. And yes, there are times where I know that the chat is more frustrated than I am. There are things during the normal course of work in the court system that are more normalized for me and I don't get as frustrated by. One of the best examples of that is the court ending at 4 p.m. I don't get frustrated. It does not fluff me at all that the court ends at 4 p.m. I am not fussed about it. It's not uncommon. The courts end at different times based on court staff, based on contracts, based on if their clerk needs to pick up a kid, whatever it may be. I'm not pressed about it. I'm not mad about it. And you're not going to hear me being like, but Your Honor, why don't you just work another 3 hours? Because I don't know the circumstances of this courtroom, and I don't know what the court reporter's contract is versus the court clerk's contract. I'm not pressed about it, but I know it regularly rubs people the wrong way. Same with the judge coming in, 15, 20 minutes after 9. I generally assume the court's reading things in chambers because the lawyers are filing things in the morning. I'm not pressed about it. There's a lot of times where the court makes rulings and I'm like, that's within the court's discretion. It's not my favorite ruling. I don't love it, but that's within the discretion. And then there's times I get really frustrated, and I will tell you, but I have kind of a scale, and not everything is code red. So when things are not a code red, I'm going to tell you, this is a normal part of court. Court can be frustrating. Some days are good days in court. Some days are bad days in court. Today has been particularly frustrating with the way some of the questioning and direct got shut down vis-a-vis how open cross-examination was. It was disjointed for me, and I got very frustrated. June said, it's too bad, EDB, that attorneys can't have someone watching coverage for the attorneys. Oh, I don't think the attorneys in court need help. I actually don't think it would be helpful. I'm sure that if the attorneys want input from anyone, their law clerks probably keep an eye on what the internet is saying. Here would always be my caution. What the jury is thinking and what the internet is thinking is likely wildly out of sync. The internet has seen more of this case, has seen more of these attorneys, has seen the emotions running up. The internet sees the interactions with the lawyers when the jury's not present, during the argument for the motions, during the argument of what evidence is coming in, during motions in limine, during the request for a mistrial. The jury doesn't see any of that. So what we are seeing, even though we are watching the evidence come into court, we are still seeing more of it than the jury does. So the way that the jury sees this case and the way that the internet sees the case are likely very different. And so though the lawyers might keep an eye for what big questions are out there and try to answer those questions, the perception of this was a good day, this was a bad day is going to be different. But I do think it's helpful for the lawyers to look at where those big questions are and see if they can answer those questions or poke at those big questions. I do think that's incredibly helpful for them. But we've seen this in other high profile cases, especially where bosses get involved. The trial attorney does not need the feedback of 15 other attorneys. They just don't. They need to try their case and run their race. If there is something big and glaring, hey, you might want to point out this. Hey, I noticed this one question's outstanding, fine. But go into court and ask these questions is not a good strategy. And taking in too much input is not a good strategy. The lawyers need to literally run their own race, and most of them start trial with the idea of their closing in mind. And they need to stick to that. That is more true for the prosecutors than it is for the defense. The defense has the ability to shift a bit because their job's to raise doubt. What about this? What about that? They can just kind of throw out questions and see if the jury finds those alternatives reasonable. For the prosecution, shifting the goalpost feels uncertain, and it is, I think, difficult to convince members of society that you should send someone to prison when you're not sure what happened. And so for the prosecutors, they really do need to tune it out and follow their own case. And I think that there were times last trial where it felt like Lally was trying to preemptively chase what the defense might say, but the defense could just change what they're going to say. They don't have to be locked into one thing the same way the prosecution does. Chasing the defense strategy is a losing strategy for a prosecutor. Denise said, so you had a ham sandwich. I believe this witness has made it clear that he had a ham sandwich. I think it's been well proven. The witness ate a ham sandwich. What's not well proven is what kind of bread it was, what condiments it were. Was there cheese, not cheese? Lettuce? No lettuce? There's still many more questions that could be asked. Jake B said details matter is the new what if any. The details matter today has been much, especially since the witness is like, no. When Brennan started with facts matter and the witness is like, no, I think I said details matter. It's like, right. Robert Hall said, how is this line of questioning allowed? If we're talking about the sandwich and things, it might go to any bias or favoritism towards the defense. When we're getting into why is he allowed to now give medical expert testimony, I have no idea. So, okay. Brennan is salty that he wasn't invited to lunch. It feels like it. It was just a wild way to question. And it just doesn't, it just isn't impactful in the way that, how much is your contract? Oh, $325,000. What? That's more impactful than a ham sandwich and an Uber ride. It's a lot of money. And that's a number that is so high that it is going to stick with the jury. Anything under $100,000, the jurors might be like, okay, they're experts, they get paid, maybe I picked the wrong career. But once you start getting over $200,000, most jurors are going to sit there and go, what did you say? How much money? For less than 6 months of work? What now? It's a shockingly large number. So that is going to stick with the jury differently. But it's been quite a lot. Jen V said, can the defense say Proctor isn't dead in closing? No. We're going to see if the defense asks for the necessary witness / missing witness instruction and how that gets argued about they could have called Proctor. But I think the friend coming in and saying that they are still friends, the defense can say, you heard from so-and-so who is still friends with former Trooper Proctor. That they can say, that's in evidence. And they can talk about that being in evidence. Music to My Soul said, open the door to the FBI, Brennan, do it. Brennan was really on thin ice with who hired you, because there could get to a point where this witness has to be allowed to explain why they didn't do different things. I think Brennan is likely confident that the court would side with him on that. And so he is skating on that line very closely. Very, very closely. So I'm going to take, what time is it? Court is still not back. I'm going to take 10 minutes to 1 p.m. Central. We will send an app notification. Do not worry. If the court is not back, then I will put a little note in the chat and we will come back. Jennifer said, when this is over, where will we be going next? To a little more sleeping in and to some days off, because we've got other trials coming up for the rest of this year. But we'll catch up on some of the stuff, don't worry, that we haven't caught up on. And there's still the Emily Show podcast and the Emily Show case briefs over on that channel. So there's a lot we've got to catch up on. But we're going to finish this one out first. We're going to be on jury watch soon. Melody said, happy 21st birthday to my daughter, Emmy. Emmy, happy 21st birthday. Have a good one. Have a safe one. Have fun. Don't forget to eat food and enjoy. Law Nerds. I'm going to take a quick lunch. I'm going to grab, Miguelina, will you grab the link to our lunch video? Because the music through StreamYard has been sounding really strange and I don't think I have it pulled up quickly. So if you don't mind grabbing that, I think I can try to grab it quickly, but I wanted to answer some questions. So thank you for that, because we've been using the StreamYard music, but well, our music going through StreamYard, but it's been sounding really weird to me on my end. So I just want to be cautious and mindful, because it was, well, frankly, it was just annoying the shit out of me. And I'm trying to lean into not annoying myself or y'all. So there is that. All right. Court is still on lunch. I'm going to take 10 minutes for lunch. Hydrate, get some food. Let me know what you're having. I'm probably not going to have time to make a ham sandwich. I don't even think I have ham. But get some food and we are going to take the lunch break. So I will see you guys in a few minutes. Get the Law Nerd app while we're on break and we will be right back. Let's get this rolling. See you guys in a minute. Emily, you got to put it full screen. I know. Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. Trying to stay in the loop with this trial? I know sometimes it's hard if you miss a day. That's why I've got daily case briefs dropping over on the Emily Show YouTube channel and the Emily Show audio feed on your favorite podcast app, so you can stay in the loop even when things get busy. Court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break. The Law Nerd app has all of your live court notifications to keep you in the loop. Take care of yourself. Trial days are long days. chat. Welcome back. I'm leaving my lights off for now just because it has gotten very hot in my office and I'm trying not to have the fan just blasting into my microphone. So we'll just see. So if you're like, Emily, something is it? Yes. It's sunny enough outside to make my office very warm, but I hope that it's also sunny enough outside to make it not matter if we keep the lights off. So I'm just trying not to be so hot over the break and into the afternoon because it is warm today. So, you guys ready to get back to court? I think we're going to get to the defense resting today, but it's really going to depend on how much more of Cross there is. It just seemed like we had finally gotten to the substance of Cross when the lunch break was taken. Hopefully we are almost done. But we will see. We will just have to wait and see. So let's
bring the jury
and get back to court, shall we? I think that would be helpful. Let's go back to court. They just got unmuted. So,
All right.
court is in
Mr.
session.
Brennan. Jurors, hopefully it'll be comfortable enough in here this afternoon. The court officers has done a great job keeping the AC going while we were out of the courtroom. So.
I wonder if it's also getting hot in court. The court said hopefully it'll be comfortable in here. The court officers have been keeping the AC going. They have like
Dr. Rentschler.
window units and fans.
You wrote a report back in February 2024.
Right back into Cross.
Yeah, that's correct, yes, sir.
And in that report, you provided a number of opinions, didn't you?
I did, yes.
Do you remember if you opined or had the opinion that the injuries on Mr. O'Keefe's arm would not result from impact with...
A lot of you are saying, wait, isn't she going to just admonish Brennan? Probably not in front of the jury. There might have been something that happened at sidebar. And if he does it again, we will see what happens then. So we will see. But they had a sidebar, and we will see what happens.
A non-damaged tail lamp cover.
But no, she's not going to
I
open with
believe
that, I
that's
don't
correct,
think.
yes.
And the amount of force required to fracture the tail lamp cover would result in extensive soft tissue and likely bony injury to Mr. O'Keefe's right arm.
Correct.
And so your opinion back in 2004 was that if a person's arm were to cause the damage to that taillight on that Lexus, you would expect to see extensive soft tissue and likely bony injury.
Yes, soft tissue referring to ligaments and tendons of the elbow and shoulder, correct, and the wrist.
And so you're saying not superficial abrasions, but in the arm?
2024.
Yes,
He's rolling
when you
with
look
it.
at it, and
Brennan
from,
does that
you
a
can
lot.
see from the testing we did for this
Today we've got
case,
black cherry
for
Waterloo.
this round, that the arm extends and you have contact with the arm, you would expect at those speeds damage to the tendons and the ligaments, the elbow, the shoulder, likely the wrist.
In the x-rays that we looked at, or that we saw, and you offered the words of the medical expert, there is no MRI studying any ligament damage, is there?
There are no MRIs that I'm aware of, no, sir.
And x-rays wouldn't fairly depict some of those internal injuries that you're referring to, would they?
As I described before, it can show laxity of the joint, but it normally doesn't show the actual soft tissue damage itself, no, sir.
There was an entire autopsy. So injuries would have been accounted for.
And a crash test dummy is different than a person, isn't it?
Certainly it is, yes,
No
sir.
muscle,
That's correct.
no ligaments.
That's correct.
The crash test dummy does not react or respond like a human being.
You can't have it both
Well,
ways.
it does to a certain
though.
extent, yes.
There are differences.
Certainly there are, yes.
You can't have it both ways. If the crash test dummy's not good enough to test on, how is it good enough for the drop testing that your expert did?
And so when you're looking at a crash test dummy, you can agree that there are significant differences between what you might see on the dummy's arm and what would maybe happen to a human being's arm on the inside.
There can be. That's why you have to look at the acceleration and the force, and that's primarily what the ATD is utilized for.
But focusing on the actual observation of the arm.
That's
you
not
would
how that
agree.
works, though. That's not how that works. You have to use the arm in connection with the sensors on the arm. You can't just say, but just looking at the arm, it looks fine. It's
Doctor, that looking at a crash test dummy arm is not comparable to actually looking into a human being's arm with an MRI and seeing if there's any damage on the inside.
No, of course, that they're not the same. No, sir.
You were speaking about references earlier. You did have a chance to see Dr. Welcher's report, didn't you?
I did, yes.
And in his report, there were a number of references, weren't there?
There were different references, but I think maybe 26 within his report.
In addition to his references, you were sent a number of gigabytes of information, weren't you?
I was, yes.
And in those gigabytes, there was different references to different materials, wasn't there?
Well, first of all, there were only 26 references in his report that he cited to for his opinions. There was material contained within the batch of documents that they sent over. There was a bibliography or CV of different papers that he had submitted, I think 20 pages of papers that weren't referenced in the original report. And the most recent paper in that AutoPed packet was from 2004. Most of them were from the 60s and 70s, but there was an additional packet of information.
When you read his report and saw his references, did you look up the references?
I did, yes, sir.
Okay.
that was me. That was full user error because it just jumped back. Emily, you and the pause game have not been strong. Thankfully, we're not very far back today. I don't think Brennan was expecting that answer. Do you? As I refine this, I am going to talk with you while I find where we were. I don't think Brennan was expecting him to say, actually, yes, he only cited these articles to his opinion, but he did send over a 20-page bibliography, but the most recent article was from 2004. And so, you know, those aren't really the references, but also they weren't cited in his report. So I don't think he was relying on them. He just sent me over a sheet of stuff. Okay. So we've got to get back to the bibliography of it all. And I want to make sure we are in the right spot because not much happened after lunch. So,
and so your opinion back in 2004 was that...
Oh, yeah. We're pretty close to caught up in real time. So we're just getting to the bibliography of it all.
An extent, yes.
So the 20 pages of stuff is where we were stuck.
There's only one reference specifically with respect to automobile pedestrian impacts.
When you looked at his references, sir, did you have an opportunity to read any of the articles?
I did, yes, sir.
And many of them are peer-reviewed?
Yes, sir.
In addition, when you looked at the 20 pages of materials he sent over that were not in his report, how many references did you read out of those 20 pages of references that he offered?
You need to say you're
Well,
referring
I
to
didn't
your
read
notes.
any because they weren't.
Sir, if you're referring back to your notes, you need to tell them. You can't just pull stuff out of your bag and look at it. Nope.
Referred to in his report for his actual opinions in this case.
Do you know whether or not he considered those references or whether he read those references?
I'm going to allow that.
That's
He
calls for
didn't cite to
speculation.
any of those references in either the PowerPoint presentation or in his report. That's the knowledge I have of whether he reviewed those.
So you don't know what he considered or thought, do you?
Well, what's in his report?
I know what he cited to and he referenced to in his report in PowerPoint. That's the extent.
The question is, you don't know what he was referring or reading or relying on.
And it was answered.
Other than what was in his report cited, correct?
Well, right. If he referred to the other articles, yes, certainly other articles in the 60s, 70s, and 80s he may have, but they don't really pertain to what happened in this case.
How many references were in your May 7th report?
Well, I think there were...
Are we just having a measuring contest of how many things you can cite? I don't think it helps.
Uh, 26, I think.
Those 26 references, are they offered in your report to suggest some type of support for the proposition that you're promoting in the report?
Well, they support the opinions or the methodology or both with respect to what I've offered in this
The
matter.
reason why you put a cite in is suggesting that it supports whatever proposition you're footnoting on that.
To some extent, or the methodology or some information pertinent to that opinion, yes, sir.
Regarding crash test dummies and prediction
I
of
will
soft
say-
tissue injury,
Lawnards, we have cited at least 15 book references, innumerable music references, almost the entire discography of Metallica, and quite a few movies. So I think we have lots and lots of sassy footnotes in our coverage. Definitely more than 26, but it's also been 8 weeks.
you provided 3
Footnote
sites,
noise.
didn't you?
And soft tissue injuries?
Yes.
And that doesn't even count the TV
Can you
references.
show me where that it says
Music,
that, sir?
Footnote
movies, books,
11 of your
TV.
report, Mr. O'Keefe's right arm kinematics during impact with the Lexus are inconsistent with producing the documented cuts damage to his right sleeve as well as the abrasions to his right arm. Did you write that?
Yes, and which one was that again? I just want to make sure. What was the number?
You cited footnotes 24, 25, and 26.
Yes.
And when you cited 24, 25, 26, did any of those 3 sites, in fact, those are the only sites that you cited for that proposition, correct?
Yes, sir.
So your entire basis of sites is limited to those 3 articles or 3 papers, yes?
For reference, it's not, the testing obviously proves differently, but yes, for that one comment there, those were the 3 that were provided, yes.
So you're
Starting
saying
with number 24.
you're saying that for one proposition you cited 3 sources for one proposition? Okay.
When you looked at 24, did it ever suggest,
Sure.
this paper, did it ever suggest that it was appropriate to use a crash test dummy in the material of a crash test dummy
Oh, now we know where he's
to
going.
make an
Don't
analysis or determine whether or not there would be documented damage to someone's skin?
No, it didn't, and that's not what I did in this matter.
In this article you cite supporting the claim that you made, there is nothing in here that would suggest that a crash test dummy is appropriate to use in making that determination, is there?
There is not, no, sir.
In fact, in this article, it gives you details on what actually should be used to make that analysis, doesn't it?
No, sir. It looks at, it tells you certain ways to look at sharpness and how lacerations are caused.
This is titled Skin Tissue Cutability and its relation to lacerations,
Cutability is-
severity, indices.
Wild word.
You know that. You cited that.
That's correct, and it looks at specifically, I think, laminated glass and its ability to cut the skin.
Number 24 in your site, correct?
Yes.
Okay.
And it tells you 3 types of skin were examined and used for this type of study. Post-mortem human skin from 2 different body sites, Cameos leather, and Napa goat skin. Is that correct?
Right, to look specifically at laminated glass and it's the cutability of that type of glass.
And the reason why the study is giving those suggestions is because a crash test dummy's arm and
Are you saying that it wasn't cut that way? Also, the goat's not happy. I wonder if Hank's point is going to be that you wouldn't see cuts to the arm because of the type of material it's made out of. You wouldn't see cuts to the crash test dummy or the ATD arm. But what about the hoodie?
fabric, the way it's made, is different than how real skin would respond. Yes?
Well, it is different, sure.
Yeah.
And I didn't do that type of comparison.
You did not do any comparisons with any of the suggestions
Okay.
in the site that you cited in support for your proposition, did you?
Oh, I did not evaluate that. No, not in that manner. No, sir.
And then you cited number 24 or 25. You cited a book, Forensic Pathology, correct?
Correct.
And in this forensic pathology book, in the entire book, it never suggests that crash test dummies are appropriate to use when making this type of analysis, does it?
Brennan, did you read the entire book? Because you should have read all the scientific reports in this case before you read the book. Just curious.
Correct, and that's why I would not do that type of analysis with respect to lacerations. That's not what my analysis involved, sir.
My question was, nowhere in that book does it say that crash test dummies are appropriate for analyzing skin lacerations on a collision, does it?
Sure, I mean, for that sake, it doesn't say it's inappropriate either.
And then you also cited an article, your third article.
He's like, right, it doesn't talk about it at all.
Understanding the acute skin injury mechanisms caused by player surface contact during soccer. Did you cite that?
I did, yes.
And again, there's nothing in there that talks about the use, the appropriate use of a crash test dummy when you are trying to support the proposition that someone's arm is consistent or inconsistent with producing cuts and damage in a collision.
That's correct.
So he's asking him about things that he's not testifying to
aware
and testing he didn't
of
do.
Literature
Okay.
relative specifically to the use of the hybrid 3 crash test dummy, which was used in this case.
There's a lot of literature with respect to the hybrid dummy, yes.
Have you ever heard of the person by the name of Stanley Bakatis?
I don't recall that I have.
Okay. How about Harold Mertz? Isn't he a leader in the field with crash test dummies?
He is, yes.
Would you agree that we also do not believe that
I'm half waiting for Brennan to start listing out the members of the band Crash Test Dummies. I'm just waiting for that to happen.
current instrumented arm configuration is suitable
'Cause why
either
not?
for prediction of soft tissue injuries? Would you agree with that?
Well, for laceration, sure, it shouldn't be used
Some
for
of you
that.
said
It
the
shouldn't be
exact same
used in
thing.
that manner. That's why I don't use it in that manner.
Do you have any source that says it's suitable for determining superficial abrasions?
I do not, no, sir.
You have no other sites whatsoever supporting that proposition, which led inevitably to one of the opinions you gave to this jury, true?
No, not true. That's a misrepresentation of what I performed, the testing that I performed, and the results that I analyzed in this case.
Now, you've talked a lot about Dr. Welcher's pain test. You don't have any information that Dr. Welcher ever claimed that his test was intended to represent exactly how Mr. O'Keefe's arm was when he was hit.
What was the purpose of the test then? You're asking again. You understand that his test wasn't meant to represent how the injury happened to John O'Keefe. Then what was the purpose of it? And why did he write a whole report about it? And isn't that the basis of his entire opinion? What was it for then? Because if that's not the point, then it's not relevant. And unless he was right, it shouldn't come in. I'm going to back up so we can ask that question again.
Led inevitably to one of the opinions you gave to this jury, true?
No, not true. That's a misrepresentation of what I performed, the testing that I performed, and the results that I analyzed in this case.
Now, you've talked a lot about Dr. Welcher's pain test. You don't have any information that Dr. Welcher ever claimed that his test was intended to represent exactly how Mr. O'Keefe's arm was when he was hit, do you?
Well, the evidence I have for that is that in his report, he says that the orientation and position of the lacerations are consistent with the orientation position of the tail light cover. And then right under that, he has reference to that test that he performed. So again, if he did...
It's the basis for his conclusion, and his conclusion is that they're consistent. So yeah, he's trying to replicate it.
didn't intend to do that, then there's no evidence that he can provide with respect to the arm impact at all. That's the only test that was performed to look at the arm and the tail light cover. If it doesn't represent the actual position, then apparently he has no idea how the arm was positioned or how it was impacted.
Let's get back to my question.
Yes.
Is there anything where Dr. Welcher has informed you or written that he is intending to represent the actual arm angle of John O'Keefe when he was hit by Alexis?
Again, I just described what he has in his actual report. So he didn't write specifically that that's what it's intended to do. It seems he's inferred that. And again, that's the only test that he's performed or referred to in this case.
You inferred that.
inferred that that's how he believes that the arm was positioned?
I think we understand your perspective is that the only test he performed, but what I really want to get at is your conclusion, your assumption that Dr. Welcher was suggesting that there was a specific arm angle that occurred in this case that he was identifying. You don't see that anywhere in his report.
Well, it would be pretty odd
What?
if the one test he ran didn't actually represent what he thought happened. I don't understand what the value of that would actually be.
Did Dr. Welch ever represent that he was trying to describe the actual body position of John O'Keefe when he was hit?
Actually, he doesn't state that. He states very little in his report or in his PowerPoint. He demonstrates through the video of his arm like that and contacting it, and then he holds his arm up to a picture of Mr. O'Keefe's right arm to compare and apparently demonstrate that it's in the same
And then he
area.
testified to it.
But again, he doesn't actually state that opinion. He doesn't state any opinions that the contact actually occurred, except in one point, and has no evidence or foundation for that.
Would the answer to my question be no?
You would have to ask Dr. Welcher, I suppose, but if it's not, again, then I'm not sure what that test actually accomplished
Well,
or
I'm asking
represented.
you. You've made assumptions and then have given opinions to this jury based on your assumptions, haven't you?
You've made assumptions that the test was to support the expert's conclusion. Yeah, he assumed that the test was to support the expert's conclusion. Otherwise, the expert's conclusion has no foundation. Are you trying to diss your own expert by cross-examining this witness? What is happening? Oh, you just assumed that's what he's trying to prove. If not this, then what?
I've evaluated the evidence in the one test he ran. If that's incorrect, well, then I would have to correct my opinion and my assumption and say that not only is the test not actually show what occurred, but he hasn't performed anything to actually link the arm contact to the taillight cover. If it doesn't represent that, you're right, I'd change my opinion that there's no evidence, no analysis,
No foundation.
no conclusion whatsoever.
I'm going to try to make my question a little clearer.
Oh, your question was clear. It was dumb, but it was
Is
clear.
there anything in the report where Dr. Welcher has stated that the arm angle in the demonstration was in any way attempt to replicate exactly how John O'Keefe's arm was when he was struck by a weapon?
I don't believe anything's written in the report with respect to that, no.
Is there anything in the report, Dr. Wrenchler, anything, that states Dr. Welcher was stating or claiming that he knew the body position of John O'Keefe when he was struck?
He said they matched.
I'm going to allow that.
So no, I guess there is no opinion or conclusion that he knows how Mr. O'Keefe was actually positioned at the time of this alleged incident.
Do
You're
you
correct.
know whether Dr. Welcher has been clear that he does not know? Let me say this a different way. You would agree, Dr. Welcher has never stated in his report
I had
that he
to
can
I
identify.
had to gain this up. We're going to get a lot of the background fan noise, but Brennan wandered away somewhere, and so he's very hard to hear.
The speed at which Mr. O'Keefe was struck in a collision.
He does not state what he thinks the speed is. That's correct.
He never states how far, if at all, Mr. O'Keefe was thrown after being in a collision.
That's right. He does not.
When you don't know the speed, you don't know.
Brennan, aren't you trying to prove that this collision happened? You don't know the speed. You don't know how he was hit. You don't know where he was hit. You don't know his body position of how he was hit. Our expert doesn't say any of that. Are you trying to prove through cross that your expert doesn't know any of that? This is the strangest cross-examination. Sir, you're prosecuting this case. Why are we going through the list of what we don't know? And if you don't know, now you know. Maybe. I think if we don't know, we still don't know is the problem. I'm going to go back through the list of the things Brennan is saying we don't know.
Speed.
I'm going to start quoting the Cars movie in a minute if he keeps saying speed.
It is a different way. You would agree, Dr. Welcher has never stated in his report that he can identify the speed at which Mr. O'Keefe was struck in a collision.
He does not state what he thinks the speed is. That's correct.
He never states how far, if at all, Mr. O'Keefe was thrown after being in a collision.
That's right. He does not.
When you don't know the speed, you don't know the body position, and you don't know the angle of the body at the time of collision, you cannot replicate a collision with crash test dummies to a reasonable degree of scientific certainty.
Well, you're right. You can't prove that that actually occurred. That's the basis.
Brennan, how have you not learned in this trial? Brennan is trying to undermine him and say, my expert did the paint test because you can't do a crash test dummy test because there's not enough information. And the answer is, well, you can't prove that it happened. If you don't have the speed, the body position, the body angle, the point of rest, the point of collision, then you can't do a recreation. And the answer is right, you can't prove that it happened. I see where Brennan is going. I don't know why, but Brennan is trying to go with, but you can't do a crash test dummy test because you don't have enough factors. That's why Rentschler did his testing, because there's not enough factors to consider for a crash test dummy evaluation. But what ARCCA is saying is, we aren't doing reconstruction. We're testing the theory that you put out there. Your expert put this theory out there. We're trying to test to prove if your expert's theory is correct or incorrect. We're not solving for an unknown. We're peer reviewing your expert. Oh, Brennan walked right into that one. I'm going to back that up again because you knew he was going to get served, right? If he kept going down this line of questioning, you know what Dr. Rentschler is going to answer. Right, without all that information, you can't prove that it happened. It's just an own goal right there.
He does not.
When you don't know the speed, you don't know the body position, and you don't know the angle of the body at the time of collision, you cannot replicate a collision with crash test dummies to a reasonable degree of scientific certainty.
Well, you're right. You can't prove that that actually occurred. That's the basis. Yeah.
So,
If you don't have the
You
information, you can't replicate what happened. You can't determine, you can't state to any conclusion of accuracy what actually occurred if you don't have the evidence.
so if you were to do a crash reenactment, but couldn't state to a reasonable degree of scientific certainty,
They did a they did an accident reconstruction. They did do that. He's going to potentially open up a line of questioning that's more than they got into from direct. Because they did do a reconstruction, or they attempted to. Oh boy.
this replicated the actual collision. That wouldn't be scientifically reliable to a reasonable degree of scientific certainty, would it?
Well, if you perform a test and you state this is what I tested and this is the angle, then you can certainly say these are my conclusions. But if you don't know the throw distance, if you don't know the position, then you're correct. You can't actually come to a conclusion that it didn't occur. If you don't know how something occurred, how can you conclude that it actually occurred? It scientifically makes no sense.
You can't come to a conclusion that something occurred if you don't know how it occurred. Welcher said that is what happened. Rentschler says you can't prove something occurred if you don't know how it occurred, which should probably be the opening line of the defense's closing argument. Ladies and gentlemen, 2 days ago, you heard Dr. Rentschler sit here and tell you, You can't prove something occurred if you don't know how it occurred. Do you know how this occurred? Because after 34 days, let's assume, for closing, you still don't know how this occurred because the Commonwealth hasn't shown you. You've heard about sandwiches. You've heard about paint. You've heard about Karen Read's drinking. But you haven't heard how this happened. That's where you start, because now Dr. Rentschler has given you the answer. I'm going to back that up and listen to it again.
My conclusions. But if you don't know the throw distance, if you don't know the position, then you're correct. You can't actually come to a conclusion that it didn't occur. If you don't know how something occurred, how can you conclude that it actually occurred? It scientifically makes no sense.
So, if an expert
What's your next question?
does a crash test and they can't determine to a reasonable degree of scientific certainty.
Hank thinks he's winning. Hank thinks he's winning cross-examination. Listen to his question. Hank thinks he's winning cross-examination. Hank thinks he's got this expert. Right. So if you don't know all of that, how can you do a crash test? You can't. Your tests are unreliable. Wow, Brennan, that's a bold strategy. Listen to his question. Listen to Brennan's question. Right. So you can't do a crash test. We didn't do a crash test. You did a crash test. And that crash test is unreliable because you don't have enough information. It's exactly where Brennan's going.
So, if an expert does a crash test and they can't determine to a reasonable degree of scientific certainty that it replicates the actual collision, you would agree that would not be a reliable test to present to a jury, don't you?
I'm going to, very briefly.
Did you hear how smug his question was? He thinks he's proved a point. He thinks he's proved a point. And he thinks the point he's proving is that these experts can't come in and tell the jury that their results are reliable. He thinks that that's the point that he is scoring right now. That's 100% where Brennan's head's at based on that question. So if an expert comes in here and does a crash test without knowing that, those results aren't reliable. Wow, wow, wow. That's it's an interesting choice. The defense is coming back to the table with animation. I'm very interested to see where this goes. But Brennan is starting from the fundamental position that these experts are doing a reconstruction when what they're actually doing is testing his experts' conclusions. And I think the defense needs to make that more clear on redirect. I think they made it clear on direct. I think they need to lean back into it because, again, I see the points that Brennan is trying to make, even when I don't agree. But Brennan is going so far down the road of, see, the way we did it is right. They're trying to run crash tests without enough data. That's the direction he's going in.
Reports and evaluating the PowerPoint, would you agree there is no statement by Dr. Welcher ever in anything that you reviewed that he is claiming or stating that his paint test was supposed to be a reenactment, identifying the details of how Mr. O'Keefe was standing, moving, or holding his arm at the time of a collision.
He did not state that. That's correct.
So when you've made your criticisms, that you've done testing regarding Dr. Welcher, you don't have any evidence, any statement by him that he was trying to reenact the actual collision.
When I did that, there's one test with the arm like this. That's the only evidence that was presented in his opinion or in his case. I evaluated that. I have not seen any other explanation of what happened or how it occurred. Specifically, Dr. Welcher said in his report on page 9, he said, I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. If he did not recreate how he was positioned, if he did not determine the speed of impact, if he did not determine how Mr. O'Keefe's body moved, if he did not determine where he ended up, then he did not conduct either an accident reconstruction analysis or a biomechanical causation analysis. He did nothing of the sort.
Other than your opinion, let's get back to my question if I could.
I believe I answered at the beginning of that, sir.
I'm going to ask you again. My detailed question is, there is nothing in Dr. Welcher's report or any of his presentation
Oh boy.
that states he is trying to represent the exact posture, movement, and stance of Mr. O'Keefe when there was a collision.
I am now distracted. Can we please go back to looking at Brennan's face? Because Brennan thinks he's getting a serve. Can we go back to the part? Camera, back to the party answering the question, because Brennan's face says he thinks he is serving this witness. Now, I'm not reading that situation the same way, but can we go look at the witnesses? I am so distracted looking at the defense table.
It's not anywhere in there where he stated that, is it?
It's not stated. I'd be curious to find out what that, if that wasn't the intent of the test, I'd be curious to see what the actual intent was.
Is the answer no, it's not in there?
I think I just said that at the beginning of my answer, sir.
I'm going to ask you again, is the answer no?
The answer is no.
When you do crash tests, you have a controlled environment.
Welcher never said he was trying to recreate the incident. Well, Welcher said on the stand in front of the jury, that is what happened. I think it got stricken. And in Welcher's report, he says he did an accident reconstruction. And I think Wrenchler was incredibly restrained, saying, then if he's not doing an accident reconstruction, what is he doing? Finger painting? What is happening? Wrenchler didn't say, then what the fuck did you pay him $300,000 plus for if he's not trying to recreate something? It's the wildest line of questioning.
In some respects, don't you?
You do, yes, sir.
You get to control some.
I think him saying that is what happened got stricken, and then he was allowed to put in his opinion. But he said it because we heard him.
Or sometimes many of the variables, don't you?
You can, yes.
Real life sometimes is described in your world as chaos, right?
This sure
I
is.
suppose it could be under certain circumstances.
Testing is limited to the variables that you produce, but real life sometimes has variables you can't predict. Isn't that fair to say?
It's possible, yes.
Is it more than possible, doctor?
I don't know, is it?
What I'm asking you.
It depends on the situation and the certain variables. It depends on the case. It could be possible, yes.
Have you seen cases where the variables are impossible to predict?
Where the what?
Variables. Have you had cases? You've had many cases.
I really want this witness to say, no, I've never seen a filed case where I've come into court to testify where the variables were unknown. Because cases like that don't go to trial. He's not going to. But that's where my brain went.
You said, have you had cases where variables are impossible to predict?
It depends. I mean, it depends on what you're looking at. And if you want to conclude that something happened and this is how it occurred, you have to look at those variables. If you can't control for those variables, then it's possible you can't prove that it actually happened. So yes, if you're doing a certain test to prove something, you have to look at how those variables may affect it. but there's basic information you have to know to perform that type of an analysis.
So my question again is, are there scenarios where variables are impossible to predict?
There could be, yes.
Have you had cases yourself?
And then you can't prove what happened,
where
is what he
there were
said.
variables that were impossible to predict?
I suppose I probably have. I mean, it depends. If you don't know what happened, sure, then you don't know those variables necessarily.
How many cases have you done on pedestrian accidents?
Done hundreds of cases.
So you have a good background and basis to know whether or not there are variables that sometimes you can't predict, don't you?
Sure. As I said, it depends on the case.
When you did the crash tests in this case, did you actually do them?
I did not, no.
Were you even there when they happened?
I was not, no, sir.
So you're relying in part on Dr. Wolf's work.
I am, yes.
If Dr. Wolf made mistakes, would that affect your conclusions?
It depends what mistakes they are.
When you had, or when Dr. Wolf had the crash test dummy in test E and F on a forklift, you remember those?
I do, yes.
When it's on the forklift, it does not allow the crash test dummy after being struck to move, to be thrown.
These are good questions. He should have started with these questions. These are fair questions. What role does the arm being suspended or Randy being suspended, what role does that play? And how does that shift the analysis? I think those are fair questions. Because there's not a lot of other questions he can ask. He should have started with those, but okay. We're at, well, if there's too many factors, you can't prove it happened. I don't know where we go from there.
Does it?
Actually, if it's a force acting on it, it will move. It will like a pendulum. So if there's a force acting on it, you'll see which direction it moves. If there's a forward force, it will move. It'll swing forward or sideways or backwards. It can move.
Well, my question isn't direction. It's, can it show the throw? Can it throw or move
Well, it did get thrown.
the crash test dummy in its natural course after the collision to a resting spot?
No. In those tests, though, there wouldn't be any throw.
If a crash test dummy is restrained by a forklift,
There's just a code red sirens. The windows are open in court. They're so loud. But
if a crash test dummy is restrained,
we watched Rescue Randy get yeeted behind the vehicle and cheese grate his entire face. Yes, it can get thrown.
by a forklift, it does not allow the crash test dummy to be thrown, does it?
Assuming there is throw, that's correct. It doesn't.
It doesn't allow an observation of the crash test dummy to turn or fall, does it?
No, it
It's
does not.
spun.
Well, no, actually, it turns, sure. I mean, it can spin.
How about fall?
No. And a crash test dummy would just fall down anyway.
Have you seen crash test dummies where it is held in place electromagnetically, and when the collision happens, then the dummy can move? Have you seen that?
I have, yes.
Have you seen, excuse me, have you seen crash test with crash test dummy where there
The
was a
windows
light?
are open in court.
Sorry.
Brennan, just fucking wait. Jeez.
Have you seen crash tests with crash test dummies where there is a light string and somebody cuts the string moments before the impact or seconds
What?
before
I
the
have,
impact?
yes.
That wasn't done in this case, was it?
What? It wasn't necessary.
Was that done in this case?
It wasn't. I'll speak slower and a little clearer.
If you answer my question.
I just did answer it. I said it wasn't.
When the
Oh, shit. Wrenchler's like, let's fucking go. I'll speak slower. And Brendan's like, maybe if you would answer my question. And he's like, I did. Wrenchler's going to fucking fight with them. Notice there's no objections from Jackson. Right. If Jackson thought his witness was being a dick and saw that the jury was like, ew, bro, what? Jackson would be objecting. Jackson's not objecting because Wrenchler's just like, Sorry, I don't know where I went. I think that was internet on my end, but it might have been on YouTube's end. Apologies, chat. I think we are back. Hopefully we are back. So let us resume. I paused, but it definitely froze. Nope, we're back. Let's continue. It's not you. It's not you. It's not you.
And the car hits it, it doesn't replicate the drag that the car will have on the crash test dummy as it would a real person, does it?
You can see if there's any drag because it's on like a pendulum. So if there's any drag pushing it forward, it's going to sway that way. It's going to move the dummy. It's not going to move at the distance that it actually would. If there was any distance, it would move it. But you can actually see the motion. And you can see in the testing, the 24-mile-an-hour testing, there was no motion, which is not unexpected for that type of a test.
There is a difference between a crash on center of mass and a fender vault, isn't there?
There
know
is,
what?
yes.
A fender vault is a different type of collision
A who
than
what?
a center of mass collision. Isn't that true?
That's correct.
It is impossible to replicate all of the different scenarios with a crash test dummy on a fender vault collision, isn't it?
I mean, it depends on what you're trying to replicate, and it depends looking at the injuries or how someone was positioned. So if you know how they were positioned, you can try and replicate that, yes.
Could I have...
Brennan is trying to like out term of art the expert, and I just don't think it's going to work well.
59 of Dr. Rentschler's PowerPoint, please.
Boy, oh boy, oh boy. All right, I want to see his PowerPoint.
In your
too.
PowerPoint, you cited an article, Vehicle Pedestrian Collisions, Validated Models for Pedestrian Impact and Projection, correct?
Yes.
And you put snippets up on the board?
Yes.
Okay. And these snippets talk about an engagement with the pedestrian in the vehicle?
Correct.
Is there a reason why you took out a piece of that article that falls between those two paragraphs?
No, I don't think so, no. Those were the most relevant parts.
Did you cut out the part that says some frontal collisions are with the corner of the vehicle where the pedestrian is deflected to one side without secondary impact of the upper body with the vehicle front? Alternatively, the
Is this a front-facing collision? I'm sorry, I thought it was a rearward collision. Is this a front collision? Did it change?
transverse velocity of the pedestrian at impact may be sufficient to prevent head contact as the body rotates sideways off the bonnet. And these situations are known as fender vault. The models presented
But
here...
the bonnet of a car and the rear of a car aren't the same. Okay.
do not apply to fender vault. Did you leave that part out purposely?
Oh, yeah, I did, sir, because this isn't a frontal impact with a sedan over the fender of the hood of a sedan. This is with the back of an SUV, so it's completely different.
You've cited many, many sources where it talks about front-end collisions because that is the majority of pedestrian collisions, the front end, isn't it?
The majority, it is, yes, sir.
And so there is a difference between fender vault and a center of mass collision, isn't there?
That's correct. And that's why you see a center of mass, you look at the testing we did, that's the center of mass impact. On a frontal impact, usually, if you're hit by the front of a car, it doesn't usually get your center of mass, you're too tall. That's why you do a fender vault, or you flip onto the hood, or you flip over the top of the car. So yeah, it's completely different. It doesn't pertain to allegedly what occurred in this case.
So let me get back to my question. When the tests were
He
done,
answered your
E and
question.
F was a center of mass collision at 29 miles per hour, wasn't it?
That's correct, yes.
Right. E, are you considering E a center of mass collision?
Which was the
24 miles per hour.
No,
Good
it didn't hit the center of mass of the
Right.
dummy, it just hit the arm.
Exactly. So there is a difference. In this case, you don't know the position of Mr. O'Keefe's arm at impact, do you?
Nobody knows. I don't think his arm was even impacted by the car, so no.
You
I don't know the position of the arm at impact because it wasn't hit by the car.
You don't know the angle of his body at impact, do you?
The alleged angle,
So
He
ask
said
the
assumes
question again.
facts.
You have no information about the angle of Mr. O'Keefe's body at the time the defendant's Lexus was traveling backwards on January 29, 2022, do you?
we have no information that he was even hit by the Lexus. So there wouldn't be any information on the angle if his body wasn't hit.
Right.
When you talked about force equations with this jury, you cited a number of pieces of literature, didn't you?
I did, yes.
And when you cited the literature, you cited all literature regarding concentrated
Wow.
forces, didn't you?
No, that's not true.
There's a difference between concentrated and distributed force, isn't there?
Yeah, I talked about that on my direct, yes, sir.
When you showed your slides, for example,
I mean, he's a witness
the
that's going to
hand.
hold his own,
Yes.
that's for sure.
Could we see slide 8, please?
I saw a few of you ask in the chat, have I ever seen a prosecutor throw their case? No. I have seen prosecutors want to win so badly that they lose perspective. But no, not throw their case. I think losing perspective cost them their case.
Okay. Let's try slide 56.
Brennan thinks
You would
that
agree with me, Doctor, there's a difference between...
Brennan thinks he's going to pull the jury onto his side to say, see, you can't use a crash test dummy in this circumstance because there's too many unknowns. The way we did it was right because there were too many unknowns. That's the point he's trying to make. That you can't rely on the crash testing because too little is known. I don't see how that's helpful.
a concentrated and a
But no,
distributed
I think
load,
Brennan
wouldn't you?
thinks he's doing well.
I would, yes.
When you gave your opinions in this case, it was based on concentrated load, wasn't it?
No, sir.
When you gave your force
Shit. Concentrated load versus distributed load. Okay.
equations, was that distributed load or concentrated load?
That was the load at the center of mass. And so you can evaluate that on a distributed load. You look at acceleration and you look at bending moment. So you can do both.
When you gave your charts and numbers, was that based on concentrated or distributed load?
No, that was based on the distributed load with respect to the center of mass of that arm and where the accelerometer was.
But this was not a center of mass impact.
We're assuming a center
You
of
said
mass
center
is
of mass
the
of
most
the arm.
dispersed impact. So if we want concentrated, then we look at a focal point, and you can do that with the hand.
So
But
the-
center of mass, acceleration, and distributed across the entire arm, that's where it's the least amount of pressure, if we're talking about force over area. And that's what I evaluated in this case.
When you gave your demonstration about the hand with the different hexagons on it, do you remember that?
I do, yes, sir.
There was a difference between taking a small
Also, yes, to all of you that said, but yesterday Brennan said he'd be an hour on cross. Yeah, he sure did. And yet here we are.
object and putting pressure on the body as opposed to a larger, wider object, isn't there?
Well, it depends on what it's contacting. And certainly not a difference when you look at the size of that impactor and the size of the knuckles and the metacarpal bones.
So, for example, if somebody took a book and hit somebody off the forehead, it may or may not leave a mark. But if they use the same force and they took a high heel, the heel of a high heel, and hit somebody, there would likely be more damage with the high heel than there would with the book. Isn't that fair to say?
Well, soft tissue, but if the force is the same, you would expect the fracture to occur. You have to look at the distribution, you have to look at the strength of the bone, and you have to look at the overall force that's being applied.
Hey,
Now, you
Brennan,
said in your-
what books are you reading? Brennan? What book? What? But if you hit someone in the face with a high heel,
Your
okay.
differential diagnosis, you considered all evidence. Did you say that on direct examination?
I don't believe I did. I believe I considered evidence for a biomechanical and accident reconstruction analysis in this case.
So you didn't consider phone data.
Has nothing to do with biomechanics or accident reconstruction.
Did you consider text stream data?
I'm going to allow that.
Yep, I'll strike it. Did you consider Apple Healthcare data?
No, sir.
I'm going to allow it.
Did you consider phone temperature, battery temperature data?
I'm going to allow it.
Has nothing to do with biomechanics, sir.
I'll ask again. Did you consider it?
I did
answered
not,
it.
no.
You said it would be improper to ignore evidence. Are those your words?
That's a good
For a
question.
biomechanical analysis, yes, sir.
Have you been to the scene of an accident before or a collision?
I have, yes.
Do you know what a debris field is?
Yep.
Yes, sir.
And you've seen in your videos E and F, there's debris fields after the collision and the taillight brakes, isn't there?
So first of all, there's debris in the yard. What that's from, is there a collision? Was there a collision? Where did that come from? Where it was positioned? That's all conjecture and supposition. Those
But
aren't
that's
actual
not the
facts.
answer to the question.
Can you hear my question?
He just asked, well, now Brennan is saying, can you hear my question? He inserted a lot of information into an answer that didn't need it. They're talking about debris field. There's a lot of things that mess with debris field in this case, including snow plows and shovels and the rest of it. But he's just inserting all of the information he wants into that answer.
Oh, debris field? I'm asking.
Yeah, and I think it's inappropriate.
Excuse me, sir.
Oh boy.
In
The
a
feed
collision.
the feed didn't freeze. Brennan buffered when he started answering in the middle of Brennan's question. So that wasn't the feed at all.
Have you seen debris fields?
I have, yes.
Have you seen debris fields where a taillight is shattered?
I have, yes.
In fact, in your videos, yes or no, after the collisions in video E and F, there are debris fields, aren't there?
There are at a certain point, yes, sir, absolutely.
And so when you're looking at your studies, do you consider debris fields?
It depends on the evidence. It depends on how it was collected. It depends
do you
if it is
consider it?
accurate or reliable. But from a biomechanical standpoint, no. You
don't?
need to look at the debris field or alleged debris field of a taillight cover. That has nothing to do with the injuries or the position or the movement of
Could I
an
have Exhibit
individual.
73, please?
I have never seen an accident reconstructionist not consider the debris field. He asked if you considered it. I think it's fair to say I considered it, and due to all these factors, I disregarded it in this case because there's too much unknown, including the plows and shovels. But I don't think I've ever seen an accident reconstructionist say, no, I don't consider debris fields. Okay. This witness might start losing the point a little bit too, because he's frustrated
Do you
with
see
Brennan,
that,
which
sir?
seems to be Brennan's goal.
I do.
Do you know what that is?
Looks like possibly part of the taillight cover.
Right. Is that an alleged part of taillight cover, or do you think that's part of a taillight cover, sir?
I don't know specifically. It might be part of the actual taillight cover.
Well, when you studied this case and you looked at all the evidence and all these different things, did you look at these photos and see that alleged piece of taillight shard recovered from the front yard area of 34 Fairview Road? Did you consider that?
Well, I don't. Was that part of the one that was recovered by a leaf blower, or not?
This witness is
When you were doing
frustrated.
your ample study.
But again, Brennan is now asking this witness questions that go to the other witness the same way he did to Wolf, right? It's the exact same thing. You've just switched it. So you're being asked questions about things you didn't evaluate? Okay.
Sir,
Yes.
what I'm asking you is,
When you were looking at all the available evidence, did you look at this photo of this alleged taillight shard on the front lawn of 34 Fairview Road? Were you aware of it?
No. Oh, I was aware that there was debris in the yard, but again, that has nothing to do with the biomechanical analysis. If you can't prove that the impact happened, then everything after that doesn't actually matter, does it? Because all of that would be from something else. So
And that-
unless you prove
That explanation makes sense. right? I'm aware there's a debris field. I considered the debris field and I disregarded the debris field because we couldn't determine that a collision happened. So the rest of it's not relevant. He just had to explain it. And I think he explained it well there. He did not explain it earlier.
Alleged taillight yard on the front lawn of 34 Fairview Road. Were you aware of this?
No. Oh, I was aware that there was debris in the yard, but again, that has nothing to do with the biomechanical analysis. If you can't prove that the impact happened, then everything after that doesn't actually matter, does it? Because all of that would be from something else. So unless you prove the core issue at this case, the contact, the post-impact movement, the head injury, without proving that, everything else is ancillary to what you're attempting to conclude.
Do you have any evidence in your biomechanical studies how this alleged piece of taillight shard ended up on the front lawn of 34 Fairview?
I don't know, sir. I didn't evaluate or investigate that.
Could I have exhibit?
Brennan fought so hard to keep this witness from mentioning the core of this case and then stepped right into it with his questioning. Oh, there it is. Well, Brennan, I considered that all this existed, but because we couldn't prove that a collision happened, it's then ancillary, and so we haven't considered it.
76A, please.
Brennan has stepped into it a couple times with
Did you
this
see
witness.
this photograph, sir?
I do, yes.
Is that part of a red taillight shard or an alleged piece of a taillight shard?
It looks like it, yes.
Did you consider this in your biomechanical studies that this taillight shard was found in front of 34 Fairview Road?
Was found. Can you give me a precise distance from where the body was found and where that was found with respect to Mr. O'Keefe,
Don't be
with
silly.
respect to a reference point?
Oh,
Did you
boy.
consider this, sir?
There is none, so
Don't
no,
be
I did
silly.
not consider that.
Don't be silly. Excuse
Do you
me,
know
can
how
you
this
provide
taillight
the
light
distance?
shard got there?
No.
How it got there?
Yes.
That wasn't part of my analysis. There are certainly different possibilities of how that actually occurred.
Exhibit
Oh, dear.
99D.
Oh, Brennan, don't ask him. Because he's going to just fight right back with you. Excuse me, can you give me the precise measurements of where that was found? No, because there isn't any? Okay. So it's ancillary. He's going to do this with every single piece, isn't he? He's going to do this with every piece of taillight.
Do you know what that is, sir?
It looks like part of the light assembly.
Mr. O'Keefe's hat?
Oh,
Did you
that's
look at
his
this
hat.
photograph?
I see now, yes.
Did you know he was wearing a hat that night?
I did, yes.
And did you consider how that hat
Dropped food.
ended up on the ground in front of 34 Fairview?
No, sir, that was not part of my biomechanical analysis. There's a number of ways a hat can end up in a yard.
Right. Is one of those ways being in a collision with a Lexus?
I suppose that's a possibility, or someone could put it there. I mean, there's a number of different possibilities as to when or how a hat may appear in a yard.
Who do you think put it there?
Well, I have no idea. I haven't seen any evidence of how it got there, and frankly, it's immaterial to a biomechanical analysis.
Do you have a theory you want to share with us about planting evidence? Is that where we're getting at, sir?
Oh, shit.
By the way, the x-rays you looked at earlier, when's the first time you saw those?
I saw those when we got the...
Oh, shit. Hank has to be careful, though. Well, no, actually. Hank is just leaning all the way in. This witness has to be careful because if Hank keeps frustrating the witness, he is going to come off as just a pure advocate for the defense. And Hank is going to shift his neutrality because Hank's like, oh, you have a theory you'd like to share with us? Some jurors are going to be like, tell me more. And some jurors are going to be like, well, you're not answering the question. So the witness has to be careful because Hank is going to keep pushing him in that direction. Hank is going to keep pushing him in that direction. It's a spicy cross. It's really just going to depend on where the jury's at with this witness and with this case, how they read it.
When I was on the case initially, for the first trial.
No mention in your report about reviewing.
I'm going to back up because he asked, when did you first review the x-rays? And he was saying, when I first got the case. That was a spicy
By the way, the
answer.
x-rays you looked at earlier, when's the first time you saw those?
I saw those when I was on the case initially for the first trial.
No mention in your report about reviewing those.
It says I reviewed medical records and reports. That's how I actually word in every report I have. I just put generally that. It refers to medical records and reports, which includes x-rays, MRIs.
Exhibit 74,
Everything.
please.
He's not going to list each thing he reviewed,
Have you seen this photograph?
but
I
now we know that when he got the discovery, and this is what I presume from what we've heard in court. This is my presumption based on what we've heard in court. I presume that all came from the defense to the U.S. Attorney's Office because they subpoenaed the case file from Yannetti, and we learned that in motions before this trial. But if the defense has them, the only way the defense gets them is from the prosecution and the coroner. That's how they get turned over. So the prosecution had them prior to the first trial. Right. Okay.
have, yes.
Okay. In your studies or your testing, did you determine how Mr. O'Keefe's shoe ended up near the curb?
No, sir.
So he's had those x-rays. Hank's had those x-rays.
Exhibit 201A,
Everyone's had those
please.
x-rays. Wow. Welcher was so
Have you seen this photograph
confident
before?
with those x-rays, wasn't he? Or the lack of x-rays?
I don't know that I have.
Have you ever seen any container that had tail light shards that matched the defendant's Lexus that were removed from his sweatshirt and his shirt? Have you ever seen any container holding those?
I haven't. Well, I believe there was evidence collected like that, but yes.
Okay, could we have 201E, please? Have you seen this photo?
What's 201E? Is it the
I believe
tin?
I have seen that, yes.
Do you understand those are taillight shards matching the defendant's Lexus, the broken taillight,
Yes.
that were recovered from Mr. O'Keefe's sweater or shirt?
Objection.
I'm going to allow that. Did you consider that?
That's fair to ask.
I'll try. I'd rather try to reformat it than come sidebar. Did you know
It's where they were recovered from that was the issue.
that taillight shards were collected after Mr. O'Keefe's sweatshirt and T-shirt was scraped?
Objection.
I'm going to allow that.
I need to see this.
Jurors, this will be brief.
Jurors, this will be brief. Well, if it misstates things, it misstates things. Where did they come from? And they did come from the hoodie and the shirt after they were scraped, and they were put together, not independently. All right, we're going to fast forward. They've gone up to the ceiling fan, which means it's not going to be brief.
In your extensive study of the detail of this case, did you know that these pieces of plastic
That was
were
foundation.
removed or scraped from Mr. O'Keefe's clothes, specifically his sweatshirt and his T-shirt? Did you know that?
I was aware that samples were recovered, yes.
Were you aware that these samples were consistent with the broken taillight of Miss Reed's
And that's
Lexus?
misstating.
Did
That's
you know
why
that?
he had to change it to
Yes.
consistent.
Did you do any analysis how these
Because Brennan had said from, the evidence is consistent.
broken taillight shards got into Mr. O'Keefe's clothes?
No, I did not. The first step involved with that would be to actually perform a biomechanical analysis to look at the movement of the body, how the body was positioned, where it ended up. So without that knowledge, you can't determine exactly how or if those types of shards were deposited there as the result of an actual impact.
Your Honor, based on the last question, I wonder if Dr. finishes question. The objector will need to try based on the question that was asked. For the same reason I just indicated at the sidebar. You just reformatted and straight.
I'll try again.
Okay.
When you looked at these taillight shards that were
Objection. That's the problem.
The problem is
Go ahead, Mr. Brennan.
the taillight shards.
when you looked at these taillight shards that were consistent with the break in Miss Reed's Lexus, did you consider how they got into Mr. O'Keefe's clothes?
Objection. Same objection.
I understand the objection. Word it differently. Start with the different.
Yes, Your Honor. You see these pieces of broken plastic, don't you?
I do.
And you understand that these were found in the scrapings of Mr. O'Keefe's clothes.
I do.
And you understand that these broken pieces of plastic are consistent with the taillight of Miss Reed's Lexus.
I do, yes.
In your studies and reenactments, did you make any determination how these pieces of broken plastic got into Mr. O'Keefe's clothing?
No, when you look at those studies, first you have to know how the incident occurred. Then you can look at that and determine, if you want to, how that may have occurred. Because otherwise, there's, again, different ways, different manners in which that may have been deposited on the sweatshirt. Without knowing how this happened, you can't just then look at other evidence and try and predict how it happened. You need the actual evidence.
Right. He's saying cart horse. Cart horse. Until we determine A, I do not consider B. He's done a good job of explaining it.
To look at the event. This all goes to the event. You need contact with the arm, I guess apparently, to actually cause this incident to occur. And without that evidence of any of that happening, knowing how the body moved, knowing how it was hit, knowing where it ended up, any conclusions drawn off of information like this is just supposition, because you don't know the movement of the body or the vehicle. It's putting the cart before the horse.
Exactly. That's what I thought. He's explained it well earlier on, not as much, but as he continues to answer questions, he has explained it well. Until I determine A, I am not considering B. Right.
Could I have Exhibit 201D, please? Do you understand this is broken pieces of plastic consistent with the broken taillight of the defendant's car? Do you understand that?
I believe so, yes.
And do you understand this is a photograph of these broken pieces of plastic under a microscope?
Okay.
Well, I'm asking you. Do you
Okay.
understand
Well,
that?
if that's what
No.
you're
That's what
telling me, then
I don't want you to rely on me. If you didn't
You're
see them, it's
definitely
okay.
not.
I don't recall if I saw those or not.
Have you seen this picture?
I don't recall seeing it, no.
Now looking at this photograph and seeing these broken pieces of plastic under a microscope with fibers near the plastic, is that something you would want to have considered in your analysis, forming your opinion whether or not there was a collision between Miss Reed's car and Mr. O'Keefe?
Again, if you can't do a proper biomechanical analysis, then that evidence is not consistent. You can't determine how it occurred. You can't say that that's consistent with it. You can't just look at certain evidence and not do a proper analysis. If you can't even tell that an impact occurred, you can't look at tertiary evidence and say, well, this proves that it occurred. In order to say from a biomechanical and accident reconstruction standpoint that an impact occurred and here's how it occurred, you have to understand the mechanics and dynamics before. This could certainly support that finding and those conclusions, but by itself, I don't know of any methodology in any study or peer-reviewed article that says you can just look at alleged evidence and then form an opinion as to whether an impact occurred.
He keeps explaining the same
Can you
thing.
see with your eye that parts of those broken pieces
Can you
of
see
plastic
with your
are sharp?
eye? I spy.
They look sharp.
If you disagree, do you think they're not sharp?
Well, I don't have an opinion as to that, sir.
We'll take a look. Objection.
Sustained.
If you look at that for me kindly, can you tell me whether you think those pieces of broken plastic are sharp? Objection.
I would allow that.
I guess they look sharp. I have no idea if they are or not. It's under a microscope. When you actually put things under a microscope, it looks much different, and it is much different than
Okay, let's go back
Been
to
looking at the normal
20E. Perhaps that can help. Not under a microscope.
Brennan's like, I'm trying to help
If you
you.
pay particular attention to the larger one in the middle, that looks like a shark's tooth. Do you see
Yes.
that one?
Yes.
Do you think, doctor, that some of those appear sharp?
Some of those appear sharp, could possibly cause a laceration, sure, as opposed to an abrasion.
Do you think that any of those could cause an abrasion?
I don't think that you could get a consistent level of superficial abrasions along the entire arm of minimal depth of less than 0.5 millimeter through impact with the glass. To have that minimal force on every part of the arm to only cause superficial abrasions would be highly unlikely.
Do you think some of those sharp pieces, if they were lodged in Mr. O'Keefe's sweater, could cause an abrasion?
Oh, I was laughing while I was
It's
eating.
possible
Definitely
if
didn't
you
check.
had
Don't worry.
enough
I was
punctures and holes in the sweater to correspond with the abrasions on the arm. That would be, I suppose, that could be a possibility.
In your testing, not to belabor it, I'm just going to show you one.
Not to belabor it.
I want to show you video.
He just said, I mean, you would want to see the corresponding damage to the clothing.
E. Could we go to video E, please? Stop. In video
Right
E,
there. Thank you very
the
much.
arm that is
What?
sticking straight out. Who determined that angle, Dr. Wolf?
Yes, well, we positioned it just so it would impact in the general area of what was shown in Dr. Welcher's paint test study, which apparently is irrelevant and doesn't show the
Ooh, that might
alleged
be too
position
much.
of how the arm was at impact. But yes,
I like it, but that might be too much. That we've crossed into well sassy. That's a bit strong. But again, if you're annoyed with Hank, you're just like, get him. But it's we might take a bridge too far. But if you're already over this cross, you're just like, I don't give a fuck. Just let it fly. It's really just going to depend on where you're at watching this cross. If it's a bit strong, he's like, no, we were basing it on Wrenchler, but it seems that that's all fucking irrelevant. Sassy.
yes, we positioned it.
Also, did you notice what Brennan did here? This is what I don't like. Is that Brennan, here, I'm going to try to back this up just a little bit. Brennan is asking about the arm in the outstretched position after it's hit, not the position the arm's in to start. He paused it
Stop.
after it was hit.
In video E,
How did you decide this position? Well, the car
the
decided.
arm that is sticking straight out, who determined that angle, Dr. Wolf?
Yes, well, we positioned it just so it would impact in the general area of what was shown in Dr. Welcher's paint test study, which apparently is irrelevant and doesn't show the alleged position of how the arm was at impact. But yes, we positioned it in that manner.
When you say we, did you have input on the positioning of that, or did Dr. Wolf do it?
Well, I had input into how we were going to position it. It would probably be both of us, I would say.
So you and Dr. Wolf chose to position the arm straight out, correct?
In that test, we did, yes.
Is there a glass in Randy's hand?
There's not, no.
A drinking glass, no?
No.
In any of your studies, did you have a drinking glass in Randy's hand?
We did not have a drinking glass in the dummy's hand, no.
Sir,
And you
Randy
see
needs a
when the
drink after all of
taillight is
this.
shattering,
Give Randy a glass of whiskey. Randy deserves it.
those red things falling down. What are those?
Those are part of the taillight.
Continue a little bit, please. Stop. Did you count how many taillight pieces broke?
We didn't count the taillight pieces. We counted how many punctures or holes there were in the sweatshirt, which was
Right.
0.
If you had done this test and changed the arm angle, do you expect the damage would look different as far as the brakes and that taillight?
Well, we conducted a number of tests. It may look somewhat different, sure.
If you conducted this test and moved the arm angle, not another test, this
Yeah.
test, but you moved the arm angle, do you expect that the brake would look different?
That the brake would look different?
Yes.
It could look a little different. I mean, certainly the brakes looked a little different in the test, but they were comparable to each other.
You do not know how John O'Keefe was standing that night, do you?
Well,
No, I'm going to allow that.
You do not know how
Understand
John
that.
O'Keefe was standing that night, do you?
if he was standing, if the impact occurred, then no, nobody knows how he would have been standing.
You would not know what his arm angle was, would you?
No.
You would not know the exact speed of any vehicle that hit him that night, would you?
Sustained.
He's just going to keep answering. Nobody knows.
Debris, the broken taillight, is that traveling in a consistent or
I don't know if I would object if I'm Jackson at this point. Jackson might just be sick of Brennan, which is fine. And sometimes it's hard when there's objections not to just be like, I'm objecting to everything. We're done. But Wrenchler is going to keep answering. Nobody knows. Nobody has that information. No one knows how that happened. And has done it over and over and over in his answering.
a different direction?
What do you mean consistent or
Is
different?
it all going in the same direction or is it going in different directions?
No, there's some spread to the debris.
So the pieces don't all fall right in a pile with each other, do they?
They do not, no.
That's a
Continue-
good question.
Continue, please.
That is a really good question.
Stop.
Brennan, your point gets lost under all the
Do the
snark, but
majority of
that's
the
a good
pieces
question.
land on Randy?
No, they do not.
And so as they fall, if Randy were to fall, many of those pieces would not be among the immediate area of his body, would they?
If the dummy fell right there, no, they would not be.
Now, the dummy can't fall because the dummy is on a forklift, correct?
It's suspended like a pendulum, correct?
And you see in your test that the tail light at what you say is 24 miles per hour can be broken without the dummy's knees touching the vehicle. Isn't that fair to say?
That's correct, yes.
Okay. You can't tell the full movement and fall of this dummy the way you've set up this test, can you?
Brennan should have stuck to this line of questioning and only this line of questioning. So in these tests, the taillight breaks consistent with what we've seen without any lower body extremity. And the taillight is going in different directions. Some are still going out, some are going down. And leave it. That line of questioning alone would have been a good line of questioning. It probably wouldn't change how anyone sees this witness's testimony, but it would have made some points. Hey, so if it's on a harness, it doesn't exactly replicate it. Hey, the shards actually do go in different directions. They're not just linear. Okay. But it gets, the 5 good questions get lost in all the rest of the nonsense. And I don't know why that's his strategy.
Well, knowing the physics, you can certainly determine or estimate where it would be, but no, you could release it and it would fall primarily straight down. It would twist and it would fall down.
Is there something that could affect the dummy if you let it fall? Is there something that could affect its movement
Gravity.
after being hit?
Gravity could.
Like what?
Like, could its feet be twisted and then hit another object like a curb?
Start singing Defying Gravity.
Well, there's going to be very little lateral movement of its feet, but even if it did, then it's still going to fall over right where it is.
Can you continue, please? Can you see the feet, doctor?
Yes.
Are they twisting?
They are, yes.
Is that because of the rotation of Randy after he struck?
Yeah, that's the rotation of Randy. And again, yeah, as you said, that's not a normal person because there's no normal force acting on the dummy. We just have it barely touching. So a normal individual, you aren't going to twist to that extent because this is a dummy which is suspended with just a little contact on the
And
ground.
after being contacted by a vehicle enough to break the light, could it cause a person to stagger backwards?
I mean, you're making some suppositions here. There's no evidence that that would occur in this case, and not if you're spinning like that. You're not going to stagger backwards. First, you're going to spin if you get hit with your arm, as I described in my direct. But is it possible? I can't say it's impossible, but there's no evidence of that.
Could a person stumble backwards after being hit?
How are we back to the pirouette being the most reasonable thing? How are we back to the pirouette not being unreasonable? They're like, well, right, you wouldn't spin to this extent, but you would rotate. There would be other injuries, but the rotation he's like, well, there would be some rotation. Okay.
I'm going to allow that.
What do you mean by backwards? Because you'd be spinning. So what direction is backwards?
Could a person get their foot caught on a curb and sneaker come off and then stagger backwards and fall on their head?
Objection, Your Honor.
I'm going to allow that.
Doctor?
Can you answer that?
I mean, I guess you could somehow predict or have a possibility of almost anything happening. You could say someone could get hit by a car and do a couple of somersaults into the yard. I mean, there's no evidence of that. So it's just supposition, but I won't say it's impossible.
Do you think John O'Keefe did somersaults into the front yard of 34th Fairview? Is that what you're telling us, Doctor?
No, I don't think he even got hit by the car, sir.
That's not what I'm asking. I've heard that. I'm asking you.
Yeah.
But if the car wedged off a shoe, wouldn't the tire leave marks on the shoe? Just a question.
Did somersaults into the front yard?
No, there's no evidence of what he did.
Your Honor, to come sidebar quickly.
Now Brennan's asking to go sidebar, but the witness said, look, anything can be possible, but there's no evidence that it happened. So yes, anything is possible, but there's no evidence that it happened. He's like, there needs to be evidence that it happened.
Okay.
We're definitely not in a 1 hour cross is what the fuck we're not. Okay. This is a fairly long sidebar. He asked for a sidebar. The court did not assure the jury that it would be quick. She did not sound pleased that they were going to sidebar. This is not a quick sidebar at all.
I do.
All right. She should have just said, jurors, this will
Can I
be
have Exhibit
long.
166, please?
I think we're getting into a different line of questioning.
Did you see this photograph, sir?
I did, yes.
And do you see the cut on Mr. O'Keefe's nose, the left side of his nostril?
I do.
In your analysis of whether there was a collision with the defendant's Lexus, did you consider or know that there was evidence that a piece of glass or a piece of broken plastic was pulled from Mr. O'Keefe's nose?
Objection.
I'm going to allow that. I'm going to allow that.
Your Honor.
So, hold on. Let's get an answer, Dr. Rentschler. Your objection's noted, Mr. Jackson.
I was aware there was some piece of material allegedly pulled from the nose, yes.
Allegedly pulled from the nose?
Yes.
Okay. And that alleged piece of material, were you aware that it was perhaps a piece of glass or broken plastic?
Objection.
That's not an
aware?
evidence. That's not an evidence.
That is not the evidence.
That is not the evidence at all. That is not an evidence. There's a statement, but there's nothing in evidence about what it was beyond a statement.
Let's get an answer, Dr. Rentschler.
I backed that up.
Your objection's noted, Mr. Jackson.
What
I was
in the
aware there was
world?
some piece of material Allegedly pulled from the nose, yes.
Allegedly pulled from the nose?
Yes.
Okay. And that alleged piece of material, were you aware that it was perhaps a piece of glass or broken plastic?
Objection.
Are you aware of that?
That's not the evidence. That is not the evidence.
So,
Glass?
hold on, Mr. Jackson.
That's not the evidence, though.
Brennan,
I can
you're-
reword
If
it.
you're considering allowing him answer it, then Jackson's not going to shut up because that's not the evidence. The statement that is in was glass. He's moving the mark, which is why Jackson is so annoyed. The statement that was omitted from Karen Read was a little piece of glass. There's more to that quote, but a little piece of glass. And he's now trying to slip in glass or plastic. That's not the statement. That's not the evidence. So it's those little chips at what is in evidence that are pissing off the defense right now, as they should be. You can't say glass or plastic. And Jackson's not going to sit down until he rephrases it, and he shouldn't. Because no, you can't now say it's plastic. It's also argument. It's facts, not in evidence. It's argumentative. MB in the chat said Karen admitted it. This statement from Karen Read is a small piece of glass. There is no statement or evidence about anything else, which is why Jackson is objecting to hold this to the exact quote, which is a small piece of glass, not and or plastic. They're not synonymous. And Brennan is just continuing to push it.
Okay.
That's not the evidence. That is not the evidence.
And that's why
So-
Jackson is saying that's not what's in evidence.
Glass? No.
Hold on, Mr. Jackson. Mr.
That's not
Brennan,
I
what's in
can reword
evidence.
it.
Okay.
You're welcome. Are you aware of that object that was pulled from Mr. O'Keefe's nose? What material that was?
I believe it was glass.
The statement was that it was
Do you want
glass.
to know in your assessment about collision where that came from?
Well, I did evaluate that, and it's actually entirely inconsistent with coming from an impact with the vehicle.
I don't think that's what Brennan was expecting.
Can we have Exhibit 52A, please?
Is he going to play the clip again?
Do you know what that is, Doctor?
It's hard for me to see from here. I believe that's the drinking glass.
A drinking glass. Do you
Yeah.
know where that is in relation to where Mr. O'Keefe was found?
I believe it was found in the vicinity of where he was found.
And could I have Exhibit
That's a fair
195,
question.
please? You recognize that?
That is another photograph of the drinking glass, yes, sir.
197A, please. B.
Are we going to get to talk about the cannon?
C.
Are we going to talk about the cannon? Because Brennan's now showing him a bunch of pieces of glass. And if Brennan had planned to pull up all the pieces of glass, why say glass or plastic in your question? So Brennan is pulling up all the pieces of drinking glass because he's implying the drinking glass is the glass that was pulled out of John O'Keefe's face. That's the implication that it seems to me he's going with. But then the question is, how do they end up in the same place? And I imagine that's what's going to come up on redirect.
D. And in your assessment, did you know that a piece of glass that fit the broken drinking glass was found in the street area in front of 34 Fairview Road?
Yes, sir.
Okay. 98, please.
I think Brennan would have made a lot more headway if he had stuck to this type of questioning. Ask about the glass, ask about the harness, ask about what wasn't considered,
A little more, please.
and leave the rest of it
Do you know
out.
what that is, sir?
It's hard for me to tell from
Does it
back.
look like a drinking straw?
Okay, the black, that does appear to be a drinking straw, yes.
Have you seen that before?
I've seen that photograph before.
Okay. And do you appreciate that is in front of 34 Fairview Road?
Yes, I believe that's correct.
And sir, in your analysis, in your reconstruction analysis, did you consider the broken glass found near Mr. O'Keefe's body, the suggestion glass is found in his nose, and that glass that fit the broken glass was found on the street? Did you consider all those things in your reconstruction analysis?
Well, my biomechanical
Oh, we're going to hear more about the glass, aren't we?
analysis, I did consider especially the glass in the nose, yes, and whether that could have been as a result of the impact.
A result of what?
A result of the impact with the vehicle.
When did you find out about the glass from Mr. O'Keefe's nose? When did you learn that?
I don't recall specifically.
Well, was it before you came and testified last time, or was it before this time?
I honestly, I couldn't tell you. I know it was before this time. I don't know when I found out about it.
Weeks ago, months ago? Could you turn the lights on, please?
Did you watch the docuseries?
I have no idea, sir.
You don't know if it was weeks, a month ago?
I don't remember with that specific piece of evidence when I found out about it.
What do you mean you don't remember it? Have you seen it before?
Well, I evaluated certainly for my report for this case. I don't know if I had known about it prior to that.
Is it mentioned anywhere in your report about the piece of glass in Mr. O'Keefe's nose?
No, it's not.
When you received that information, did someone tell you about it? Did you listen? Did you watch? How did you evaluate this evidence?
It might have been in an interview or something that it was pulled from his nose, I believe.
Okay. So you saw and listened to something?
I believe so, or was made aware of it.
Okay. Just a couple more questions, sir. I had asked you at the beginning of your examination whether you denied that receiving information certainly helped prepare to understand what was going on during the trial. Do you remember those questions?
With respect to the trace DNA, correct?
Okay.
Where
approach.
where are you
Yes.
going? And not like in the words of the Dave Matthews Band, like actually where are you going? Like, where are we going with this? He's showing the defense whatever he's bringing back up.
Yes. 124 lines.
Tell me where you're going. See, the rest of that song goes on to say, because where you are,
Yes.
that's where I belong. And we can't get to those
You've
lyrics
testified a
because
few times under
I want to
oath
run away.
in this case, haven't you?
I have, yes, sir.
And you've testified recently for a short bit in April, didn't you?
I did, yes.
Looks like a transcript.
On April 28, 2025, did you testify in this very courtroom
I believe I did.
under oath,
Yes, sir.
like the oath you took today?
Yes. Or yesterday.
Now, when I read this, I'm not attributing this in any way to the defendant's attorneys.
What?
I read you this just for clarity. You were asked, did they inform you about witness testimony? And what did you say, sir?
That's not that's not proper impeachment. He said he was informed about it. And Brennan is saying, I'm not attributing this to the defense attorneys. Right. Because that's not who they were talking about. And that's not who he was talking to.
They did inform me, yes, about testimony in situations and events that came forth in the trial that I was not aware of.
Those are your words?
Yes, sir.
Page 125, line 7.
Okay.
I'm going to ask you if this is your sworn testimony, sir. On page 125, line 7, I'll read the question. And if this is your answer, you should read the answer. Were you asked,
And by calling and raising issues and telling you information, even if you weren't requesting it, it helped prepare you for your trial testimony, didn't it? What did you swear?
I said it certainly helped prepare me to understand what was going on during the trial, yes.
Where's the difference from what he said today? Because generally impeachment has to be that there's a difference in the answer. I don't see the difference. I just feel like I'm being gaslit because I think they're the same picture. He said, I knew what was going on with the trial, but it didn't change my opinion. They're the same picture.
The FBI!
I have no further questions.
All right, Mr. Jackson?
That's what we're ending on? That's what we're ending on. We're ending on impeachment that's not impeachment, that's a different way of saying the same thing. Okay.
Okay.
I guess we're getting into redirect. That was definitely more than an hour. 84 fucking years of cross-examination. Just wild. Hold on, chat. Indulge me. Because I totally forgot to grab the rest of my lunch. I left it in the kitchen. I'm going to run and grab it. Miguelina, will you let the app know we're moving on to redirect? I'm going to run and grab it real quick. I'm going to put on our lunch screen for literally a minute. I'm going to go grab it. I'm going to come right back. I will be right back because I am so mad at myself for forgetting and I need more snackies. It's just what needs to happen. So chat, give me 30 seconds. I will be back. We're going to put on the vibes. I will be right back. Thank you, Miguelina. It's not a ham sandwich, chat. Don't worry. But I will be right back. All right, chat. Thank you for the brief indulgence because I was very sad that I'd forgotten the rest of my snackies, which were cookies that I didn't get to eat yesterday at lunch. And so I ran into the kitchen and grabbed them. And now we are back to get into redirect. Is the defense going to rest today? Because I think there's enough time in the day for them to be done. But they're definitely not going to be done with evidence today because this took way longer today than I thought that it would. Man, oh man. So let's see what we have in the redirect because we should be getting to redirect. I see notepads with notes.
May I inquire?
Yes.
All right, to redirect.
Dr. Wrenchler, you were just asked a couple of questions about
He was asked a fuck ton of questions about all kinds of shit.
they
Oh,
provided
shit.
information about the prior trial, correct?
Correct.
That's why Jackson wanted to approach. They. Who's they?
The FBI!
What's going to happen? What's going to happen?
They is no one
Right, for the defense
associated
team.
with the defense team, correct?
That's correct. No one associated with you, and they provided information. And again, it let me know what was going on, but it didn't affect my preparation or my opinions. It in no way changed any of my opinions or what I testified to.
Thank you
So
for that.
to get through this, I'm going to let you just
you.
answer the question.
Sorry, Your Honor.
Wrenchler.
And with regards, and I appreciate that.
The court wants them to toe-tap gently around it, but Brennan left the implication that somehow the defense was feeding this witness information. He said, I'm not attributing it to the defense team, but he has to be able to clear it up.
Mr. Brennan asked you a couple of questions about they being your employer. Do you remember those questions at the beginning of his cross-examination?
I do, yes.
Who is your employer, actually? The actual employer that you work for?
ARCCA.
Okay. Wasn't them.
No,
It's a client, correct?
it was a client.
A
That's
completely
correct.
separate entity that hired you for that work, correct?
That's correct, yes.
Thank you. Thank you. You were asked about a fender vault collision, and you said, well, this wasn't a fender vault, right?
Correct.
What is a fender vault?
A fender vault is when you're hit by the front of a car and you're moving
So, again, they were not your employer. They were a client of ARCCA.
across the car. So you're moving across the center towards the driver's side of the car, and the car hits you. You go up over the car, and you fly over the fender
vaulted?
to the driver's side of the car. So you vault over top of the fender.
Dr. Rentschler, where is my, as I stand here, where is my center of mass?
Right about your belly button.
Right there.
Yes.
So what would happen if I was hit by a vehicle, front collision, and the vehicle struck me below my center of mass?
It's going to flip you.
I'm
Your center
I'm
of mass-
waiting somehow for Jackson to just do like a standing back tuck in a courtroom that has not enough room for it, because who knows what's going to happen in this trial. He's theatrical enough that he might try it. But it's just, you would flip. Okay, that's not what happened here.
mass will go. You'd go right up. If it was coming right at you and it hit you at your legs, you'd flip right into the hood or over top of the top of the car.
Is that what's described in the industry as a fender vault?
That is part of a fender vault, yes, but it's at an angle. So instead of going direct back, it's because if the person's walking across and you get hit, you fly kind of back and over the top of the fender.
Did that set of circumstances, physics, have anything to do with your analysis in this case?
No, none whatsoever. The profile of the car is completely different, the back of the SUV.
You were asked several questions about the debris field in the test F as in Foxtrot. Well, actually, you were asked about both test E and test F. Test E being the 24-mile-an-hour impact to the right arm of Randy, correct?
Correct.
And test F,
back to
the
Randy.
full rear impact, center of mass impact, correct?
Correct.
The law clerks are like, excuse me, Jackson. Excuse me, before we eat our ham sandwiches at lunch, chat is displeased with the disrespect to Randy. Mr. Jackson, when you do your redirect after the lunch break, can you please just Randy, not the dummy, just, you don't want to displease chat. I am teasing.
You were shown several photographs, exhibits of very tiny, tiny shards. Do you remember that?
I do,
Surprised
yes.
there wasn't an objection to that.
I'll get to that in a second. You were also shown some photographs of pieces of plastic that were claimed to have been found at 34 Fairview. Clear plastic, piece of red plastic, correct?
That's correct, yes.
In your review of all the data in this case, do you know when those pieces of plastic got to 34 Fairview?
I do not. No.
Do you know how those pieces of plastic got to 34 Fairview?
I do not, no.
Do you know who put those pieces of plastic at 34 Fairview?
I do not.
Were you aware in your review of the police reports that none of the
I'm
plastic
surprised there wasn't an objection to that.
that you were
but
shown was found at the
Brendan asked
time
it.
John O'Keefe's body was discovered and the area was initially searched?
That is correct, yes. I was aware of that.
You indicated that the cut on Mr. O'Keefe's nose, the right side of his nose, was inconsistent with coming from a vehicle, correct?
Correct.
Can you describe why you came to that conclusion?
Well, if you're standing at the back corner of the vehicle and it strikes the arm, and let's be clear, if nobody wants to say where the arm was or how it was positioned, if they're claiming the abrasions are a result of the fractured taillight, it has to strike the arm. You have to be standing like this. The debris goes forward with the vehicle. So it's with your arm like this, it already passes by the person. And if there would be any contact whatsoever, it would be with the right side of the face. The shard can't come out and then make a right turn and then
What?
somehow embed itself
It doesn't
on the left
bend
side of the
time
nose.
and
That's
space?
entirely inconsistent with the fracture and how the glass and the cover would actually move.
Dr. Rentschler, you were asked a series of questions about a hat. Do you remember that?
I do.
About some.
And well, I might say, what do you mean it can't bend time and space? It is the first time they've spoken about that in court. So it's one of those things that's like, wait, I didn't even think about it because we haven't seen a lot of pictures of it. And thinking about which side of the face is which is something that, especially if you don't have a good or any visual memory, is something they might not have even thought about. So it's another one of those things where the jury could sitting there going, oh, wait, right? Wrong side of the face. If the taillight is on, well, this side, then you're not going to have injury by the nose on this side. It would be on the side closest to the car. It's just not been discussed. I think it's helpful to just start tying together those little pieces with the witness versus leaving them for argument and or in closing, which there might not be enough time for.
Some shards of plastic material, correct?
Yes.
About a drinking glass,
Yes.
about a drinking straw.
Yes.
Doctor, if there was no collision, does any of that matter in terms of your biomechanical analysis and your reconstruction in this incident?
It does not.
Why?
Well, because if there wasn't a collision, it wasn't that debris or those items weren't a result of that impact. You can explain how that got there, I believe, easier than if you can't explain how the impact occurred. If the injuries don't match up, if you can't even prove what happened, then you can't use information or evidence if you have no idea how it got there to try and prove what you don't even know what happened.
Right, he's like, you can't work it backwards. You start with, how did this happen, and work forwards. You can't start with, well, there's debris, and work backwards.
Scientifically, it makes no sense.
Scientifically, is the first question that has to be answered is, was there a collision?
Objection.
Sustained, you have to watch the formal question.
Of course. In your expert opinion, based on all of your review of all of the data in this case, all of the testing that you've undertaken, do you have an opinion as to whether or not there was a collision
He already
with John
answered
O'Keefe?
this.
I do.
Objection.
Yeah, I'm sustaining that beyond the scope.
In your
It's
view,
not beyond the scope.
was there evidence?
But I don't know for sure if the judge is saying beyond the scope of cross, because I don't think it is, or beyond the scope of what opinions he gave. I don't think it's beyond the scope of the opinions in his report, but the opinion, if the opinion is in his report is that the injury to John O'Keefe and damage to the Lexus is not consistent with those two things colliding, then that's the language that they have to stick with.
Of a collision with John O'Keefe?
Right? Is there evidence of, or is it consistent with? Though he's already said it like 6 times.
In your opinion,
Is the injury
were
to
any
John
of the
O'Keefe
injuries that you saw
consistent?
suffered by John O'Keefe consistent with having been struck by the subject Lexus?
No, they are not.
Do you hold that opinion to a reasonable degree of scientific certainty?
That's within
I do.
the scope of his opinions. It's a much shorter redirect than I anticipated. However, Wrenchler threw it all in there on cross. If Brennan gave him an opening, Wrenchler was just like ninja stars. He was just like here. Wrenchler was going to tell Brennan what he thought. And if Brennan opened the door for it, Wrenchler was just like, boom. So there's not much more that's needed. Are the injuries consistent with the collision? No. Okay.
Doctor, you just said that you do not believe
And
that
recross.
there was a fender vault collision. Could it have been a clip?
Could it have clipped Mr. O'Keefe?
Yes. Not hit him, but clipped him.
Well, I don't believe that's consistent with the evidence and what occurred. I mean, someone can get clipped by a car, sure, but in this case, no, I don't believe the evidence indicates that's what occurred.
The glass. When you learned of the information of the glass in Mr. O'Keefe's nose, when do you think it was that glass was pulled from his nose? What date?
I think it was the morning when his body was discovered.
January 29, 2022?
Yes, sir.
Somewhere around 6:15 a.m., is that your understanding?
Sometime when his body was discovered, that's correct.
Do you know or understand that, did you see any evidence that Mr. O'Keefe had a drinking glass outside of 34 Fairview Road that morning after he got out of the defendant's Lexus? Do you understand that?
What do you mean evidence?
Drinking glass. Did you hear anything about that in your review about?
What evidence would there be? Is there a video or a photograph, you mean, of him holding a drinking glass? Because
There's statements-
otherwise there's a drinking glass there.
There's statements by Karen Reed. There's statements by Karen Reed is what he's getting at.
But there's no evidence that he had it.
We have a clip, right? Okay. Judge, could I come sidebar?
I heard him say we have the clip right. I think that's what he's talking about. So I think they're going to play clips of Karen Reed that are in evidence. And so they're going sidebar. I'm going to zoom past the sidebar because there are clips from that interview. It was a long sidebar. Fans up? Really? I guess we are fans up. Okay.
Found
Oop.
whether or not
They came back. Okay. Brennan was back at the mic, so I'm going to gain that down a little bit because it was so loud when he came back in. All right, we're back from sidebar.
you were asked about whether or not any plastic taillight shards were found near Mr. O'Keefe's body.
I guess he's not playing the video. You know why he's not playing the video? Because this witness said he didn't consider it. So you can't just play it and be like, you didn't consider this? What do you mean you didn't consider this? He didn't consider it. I think it's also outside the scope of redirect. So the court's not allowing him to play it.
Do you know the limits of the search
I'm sure he's annoyed.
that the Canton Police Department did around Mr. O'Keefe's body? How small of an area they searched when they first went there?
I do not know, sir.
Did you ever see a video of somebody with a leaf blower blowing snow off the ground?
I did see that, yes.
And did you see the confined area in which that happened?
Well, I mean, I saw the area where he was blowing with the leaf blower.
Have you seen any information or evidence whatsoever that the pieces
Are there measurements of what size area they were blowing with the blower? Are there measurements?
of taillight that were found after that search, have you seen any evidence that they were found in that exact area, or were they found in different areas on the lot?
Measurements.
I'd have to go back and look. I don't recall specifically.
And so when there was a snow blower or a leaf blower search in that area, there would not be a piece of plastic taillight to find if it was never there, would there be?
If
Right.
it wasn't there, you wouldn't find it? Is that what you're saying?
That's what I'm saying.
Sure.
Okay.
If it wasn't there, you wouldn't find it. Good. Bones are inside the body. If it's not there, you won't find it. Cat track of snow.
Did you notice in the injuries to Mr. O'Keefe, most of them are on the right side of his body?
Well, we have the abrasions and then a half centimeter abrasion. And then we have the laceration and scuff on the left side. And then the skull fracture, it's a
of the
little bit to
head.
the right, but it's mainly on the back of the head.
And the bruise on his knee?
That's the half centimeter. It's not a bruise. It's a half centimeter abrasions, about an eighth of an inch.
When you're conducting an investigation or you're doing your analysis and you keep saying the physics and the physics,
my lights back on
do
because
you
now it's
add a
getting
little bit
darker
of common
outside.
sense in the equation when you're considering the evidence?
Well, you can sit back or step back and look at whether what someone's claiming makes sense in the bigger picture.
So when you have common sense and you look at the big picture, it's not just physics. It's considering all of the evidence, right?
Well, it depends what you're looking at. To certain parts of it, the biomechanical analysis, you look at the physics. It tells you what it is. I mean, if you don't like it and you don't think it fits, well, sorry, it is what it is. That's the science. So you have to step back. I mean, you can look at it the bigger picture if things make sense. You know, if somebody was standing on the side of the road with their arm like this while an SUV backed up at them and they didn't flinch or they didn't put their arm up, that's kind of the smell test bigger picture. That doesn't make sense. But the physics, you can't deny it. You have to accept what science tells you.
Good night. That's the line you were laughing about in the document.
Brennan, have you not learned with this witness? You haven't learned with this witness. You have not learned. And Brennan walked away from the mic, so I'm going to gain him back up again. Oh, Brennan, this witness is going to go, right, well, it just doesn't, that doesn't pass the smell test. The shit's out of the horse on all of it at this point. Except maybe. The FBI! Real close on that one, though.
An SUV backed up at them and they didn't flinch or they didn't put their arm up. That's kind of the smell test bigger picture. That doesn't make sense. But the physics, you can't deny it. You have to accept what science tells you.
Can't deny it. That's the line you were laughing about in the documentary. It's one of your answers that you were all celebrating, isn't it?
Objection.
Isn't it?
The objection sustained.
How'd that taillight break, sir?
How did it break that night?
How did, oh, I don't know. There's no evidence of how it broke.
Thank you. No further questions.
All right. You're all set, Dr. Wrenchler.
Thank you, Your Honor.
Not a helpful end to cross for Attorney Brennan. How did the taillight break that night? I don't know how it broke that night. Do you? Not a strong end to cross. Yeah. Brennan ended with a foot stomp of, isn't that what you were all laughing about in the documentary? How did the taillight break that night? That is not a good end to cross. You want to end your questions with something memorable for the jury that is helpful to your case. I don't know if this leaves the jury with something memorable that's helpful to his case. So I'm going to just back it up real quick and hear it again.
How did, oh, I don't know.
Sustained.
How'd that taillight break, sir?
How did it break that night?
How'd that taillight break, sir? How'd it break that night? That's the question.
Oh, I don't know. There's no evidence of how it broke.
Thank you. No further questions.
All right. You're all set, Dr. Wrenchler.
Thank you, Your Honor.
Is there an objection? So, subject to us discussing it. Mr. Jackson? Mr. Jackson? Subject to me taking a look at it and us discussing it. It's not coming in right now. Okay.
Who is zipping the microphone into a bag? I can't hear what Jackson is saying.
And
Oh, that's probably Dr. Wrenchler. That's fair. He would have to pack up his things to get off the witness stand. Fair, fair, fair. Can they turn off his mic? Okay.
subject to us discussing it. Mr. Jackson?
I can't hear if Jackson said the defense rests. That's what I was rewinding for.
Mr. Jackson? Subject to me taking a look at it and us discussing it. It's not coming in right now. Okay. They've been marked for identity.
They're taking care of evidentiary issues before the defense rests, but they're going to rest. They just need to take care of the evidentiary issues.
I'm going to see counsel for a couple of minutes over here.
And counsel's going to sidebar. We're going to zoom past the sidebar. The defense is going to have to make sure all their exhibits are in before they rest, just to make sure there's nothing that is left out. That's a long sidebar. They go to the only fan. Oh boy. All right, let's see if we can scrub past the sidebar. I see the judge.
Regarding the power.
Let's back up.
May be seated.
All right, so Mr. Brennan, I'm going to take a recess. You go ahead and look at that PowerPoint. I'll come back out in 10 minutes regarding the PowerPoint.
Oh, the jury must be gone for the day. Okay. Yeah, the jury must be gone for the day. Well, that's the end of today for the jury. They're taking a 10-minute recess. The court camera went to the only fan. Let's see, did I miss it? Oh, yes, I did miss her sending the jury out. Okay. Let's for completeness, the
Jurors, we're going to release you for the day. We will see you tomorrow morning. Those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. We'll see you tomorrow morning.
Rise to the jury.
All right. The jury is out for the day. The defense is going to rest subject to Dr. Wrenchler's report coming in. So the court takes a 10-minute break and then is supposed to come back out. Oh, we are very close to in real time. So the court is coming back out. Let us continue on.
Court is back in session. You may be seated.
All right, so I had a minute to look at the PowerPoint. Are you in agreement on the PowerPoint?
We're not. I do not want to admit it. I don't think it's substantive evidence.
Okay. Mr. Jackson?
Exactly the substance of this. Dr. Welch's
Okay, so just to reorient, the jury is out. They're talking about evidence. Subject to this evidence coming in, the defense will rest. Tomorrow will be rebuttal and possibly a jury trial conference. We'll hear at the end of the day what she says with the attorneys, maybe. But they're arguing over whether or not Wrenchler's PowerPoint is coming in or whether it remains as just a demonstrative.
Which was not objected to, right?
I'm going to... the attorneys aren't at a microphone. It is the end of a long day, so I'm going to gain this up. The court's just going to be very loud.
I don't think it's substantive evidence.
Okay. Mr. Jackson?
It's exactly the substance of this. Dr. Welch's
It sounds like Jackson says it's exactly as substantive as Dr. Welcher's PowerPoint is, and the court, I think, asks, but that wasn't objected to.
Which was not objected to, right?
No, the court keeps saying that, yes, there are things that are less like evidence. Yes, there are things that...
But did he object to the PowerPoint coming in?
It's been well under pressure. I don't know what Mr. Lesson's going to do regarding the PowerPoint. That's the question.
is whether this PowerPoint is admissible, and it is. There's nothing in it. We've taken out all hearsay, our discussion, the opinions or thoughts, thought processes. These are all the tests that were completed and done, exactly as Dr. Wolf's PowerPoint was done. Dr. Wolf's PowerPoint is in evidence. This PowerPoint should be in evidence.
Is there anything in this PowerPoint by way of videos that is not already in through Dr. Wolf?
I believe
No.
the video of
Welcher?
I believe the video of the drop test is in Dr. Welch's PowerPoint. There are most of the videos are included. Oh, no, I'm wrong. Please slow down. So the videos are the same, but the videos that Dr. Rentschler.
JK, I'm reading the chat and taking notes. But no, there's nothing to read ahead. I'm listening to court, reading chat, and taking notes.
Used because of the side of the case that he was handling, the biomechanics side of the case that he was handling, were slowed down significantly to show the deformation of the arm, the force impact on the elbow, the hand, forearm, about which he testified. So what he did, and I remember asking him this before I ever saw the PowerPoint, is there going to be anything different? He said, I use the slow motion cameras more than Dr. Wolf does because I need it.
Okay, so I need you to tell me tomorrow which slides specifically answered that question for me. Okay, whether they're in evidence or not, and which ones are not, regarding the videos.
Is the court suggesting that it's not going to let just the entire PowerPoint out?
Maybe. I'm going to take a look at it. There's an objection before me now,
I realize that.
so I have to rule on the objection.
Okay. I think all the videos that they showed in the PowerPoint are already in evidence.
So I will take a look at this, okay?
Okay.
So if you let me know, and if you want to let me know tonight, I can let you know first thing tomorrow. All right.
Have you heard briefly?
Yes.
Very briefly?
Yes.
I am objecting. It's not admissible. It's hearsay. It's a strategic decision. The past introductions have been strategic. The defense did not object to Dr. Welcher's. I did not object to Dr. Wolf's, but that was a strategic decision. I'm objecting.
Okay.
The defense objected to Shannon Burgess. Only a select amount of documents were allowed. I wanted the whole thing in. I was precluded properly from introducing it because it was hearsay and they objected. I'm objecting.
Okay.
There's no hearsay. They objected to certain slides. We took out the slides. If they had an objection to the PowerPoint, they should have.
Oh, no.
Objection before.
He can object again, and he's objecting again. Right. Which is also a strategic decision. He objected to the slides that were hearsay to not even being put up on the screen and used as a demonstrative, and now he's objecting to them not coming in as evidence. There are two different objections.
Displayed for the jury. The jury has now seen the entire PowerPoint. I think it's tactical. It's not strategic. It's tactical. They still like it because it goes to the case. If they didn't want to get certain things before the jury, which is exactly what admitting it into evidence does, brings it before the jury so that they can see it, they should have objected in a timely manner. When they objected, they chose certain slides, certain data on certain slides, and we took all of that out at their request and at the court's instruction. We did that with the court's instruction, with the
Right, so I could come in.
Court's instruction, and there was no objection to playing it before the jury. Given the fact that it's been displayed not in part, in whole, as it now assists for the jury, assists for the court, for quadruple K for identification, it should be admitted.
Okay.
Just like Shannon Burgess. It's no different.
All right.
Shannon Burgess's PowerPoint is in evidence.
No, it's not. Only parts of
So-
Burgess's PowerPoint are in evidence.
Mr. Jackson, when you let us...
Only parts of... Just back up for a second. In court, things can come before the jury as demonstratives that do not become evidence and as evidence. Oftentimes, reports do not become evidence. PowerPoints do not become evidence. And demonstratives do not become evidence. The defense is arguing, look, a number of these reports and PowerPoints have come in as evidence. This should come in as evidence. The prosecution objected to the things they didn't want put up. We took them out. They already made those objections, so now it should come in. The Commonwealth is still arguing these are still hearsay. There's stuff in them that is hearsay. And it is a demonstrative, not an exhibit. And the defense said, these other things came in. The court said, was that over your objection or without objection? And the Commonwealth's arguing, no, the defense didn't object to the PowerPoints that came in. They objected to Burgess's, and only part of Burgess's came in. Okay. That's what they're arguing over. Should this demonstrative come in as evidence? A lot of the things in it are already evidence. Things like the scientific studies, the hand with the circles on it and things like that, those are not necessarily evidence.
Let us know which slides answer my question about slides that are not in evidence, and
So which slides are not in
you want
evidence?
to put in evidence, the videos, just the videos. Let me know that, and if need be, I'll hear you all on this tomorrow morning as well. Okay. All right.
There are parts of those. I'm going to try to gain this back down because now it's overclocked, the audio today and yesterday. The videos are already in. So the videos shouldn't be a problem.
On this tomorrow morning as well. Okay. All right. Is that it for today? Will we see everybody just tomorrow morning? What else?
Mr. Leslie needs to, I didn't mean to interrupt.
After the defendant rests, we will not be calling any witness.
What?
Further.
What? Wait, what? Wait, what? They're not calling any rebuttal witnesses? What? I am backing that. What? Huh. Okay. You probably should have told the court that before you had the jurors come back tomorrow. Because what the fuck are the jurors going to do tomorrow? There's nothing else to put before the jury. Oh my goodness. We're going to roll that back one more time.
I didn't mean to interrupt.
After the defendant rests, we will not be calling any witness, putting on any further evidence.
Okay. All right.
No rebuttal for the Commonwealth. So the case is done. That's it. All the evidence is in. Oh boy. Okay. I want to see what else is going to happen here. Holy shit.
Your
Well,
Honor, it's late.
They won't close tomorrow. They'll call the jury to not come in tomorrow and they'll do their conference tomorrow. I want to hear what they say about scheduling. But no, they're not going to close tomorrow. But they probably will close on Friday.
All right.
Wow.
Your Honor, it's late in the day. We would like to renew our motion for required finding of not guilty after the close of all evidence. It won't be a lengthy argument.
Yannetti is saying we'd like to renew essentially our motion to dismiss, our motion for a judgment of acquittal, a motion for a finding of not guilty. They call it different things in different jurisdictions, but a dismissal. He said it won't be a lengthy argument.
But I'm happy to be heard on that in the morning if the court prefers when we got tomorrow morning.
Okay. Is that all we have left now?
Yes. and
I have
jury
no idea what
charging.
Mr. Alessi wants to talk about, but would
I'd like to respond to that.
Oh, I know exactly what the fuck Mr. Alessi wants to talk about. He wants to talk about whether those exhibits you said were going to be in evidence are in evidence. He's been asking about it for days. Until you see them written down with your own eyeballs in evidence, you need to know they're in evidence. That's fucking exactly what Alessi wants to talk about.
Your Honor, and the answer is, given Mr. Brennan's answer with no more witnesses, my issue is moved.
Okay, great. So,
Oh. Moot. Alessi looks pleased as punch over there. Alessi sat down and went, no, we're good. We're good. We're
The only other technical thing is we need to move in the 3 items of evidence, the documents associated with the
Hoodie.
sweatshirt.
Yes.
I think they've been marked for identification.
No, they were marked as evidence, right?
They're correct, Marcus exhibits.
Yeah, they're exhibits.
But no, they're come into evidence, Your Honor. I mean, ruling this.
Are they,
I thought they were marked as identification, not evidence. If they're in evidence, they're in. If it's identification.
so I need to find that. It would be my intention that they
You kept saying you were going to mark them. Nobody's marked them on the record yet. Emily, what are they all
get
fighting
put
over?
into evidence.
Housekeeping. They're doing housekeeping. The photos of the hoodie have not been marked on the record. The court keeps saying, I'm going to mark them, but we don't know if the court is going to mark them. So they keep asking to mark them.
Not going to display them and bring a jury in just to see those at this point.
Not asking for that.
Okay.
As long as they're in evidence and I can use them in closing argument, then so be it.
If I can, for clarity, Your Honor, there
we get the number?
I have Y.
Ask for the number. Excuse me, can we get the number?
So that's not an exhibit, Mr. Alessi, if that's how it marked. That's identification.
I have a different parlance. I'll use this court's parlance. Yes, it's YYY, ZZZ, AAA,
Those are marked for identification. They need evidence numbers, and he should say, okay, so tell me which YYYY is. Like YYYYY. What number exhibit is it?
So that means that, all right, so that's for identification. Letters are identification,
Yeah, we
numbers are
know.
exhibits.
Your Honor, I understand that. We all know what we're talking about, and Your Honor agreed that they're going to be in evidence.
Right. So
Give us the fucking evidence numbers. Just tell them. Is it evidence number 212, 217, 227? What number is it?
and I've ruled that they're in evidence.
Yes!
I just need to know for this record whether they're in evidence or not. What you tell me, you just told me they're in evidence. They're not. They're exhibits. They're identification.
Holy fucking shit.
Now they will become exhibits. Can we do that now? Do we have them? Where are they? Oh, Jim, they're in there? Okay.
Yeah, and Your Honor, my whole point in wanting to be heard is that they're not in evidence, and I want to make sure they get it. That's my point.
And at the end of the court day yesterday, everyone said, we need to make sure these are in evidence. And the court said, yes, I'm going to mark them into evidence, but they never did it on the record, so they don't have an evidence number. And she's like, so those are marked for identification. No shit. It's the end of an 8-week trial. Everyone keeps saying they're going to get marked, but it hasn't actually gotten done. And Alessi keeps saying, you say you're going to mark them, but it's not actually been done yet. A lot of you are asking me, Emily, is this on purpose? No. This is everyone is exhausted at the end of an 8-week trial. Everyone is tired. They're going to get marked. There's a lot that has to happen. And they've not taken the time to do it on the record. She's ordered that they'll come in. They just have to get marked. But somebody has to keep on top of it. And that somebody's Mr. Alessi, because he's a dog with a bone on this, and he should be. Until he has an evidence number, it's not getting done. And now it should get done. Just do it now. There's time. Yesterday got all off the rails. Just do it now.
What number are we at, Madam Court Reporter?
To the 230.
Great.
Okay, and we'll
230.
do A, B, C, D.
So is it Y, Z, A, and B?
Do it.
I think I have it.
Now it's done. Somebody's opening a Snickers in that courtroom. I don't know how it is, but somebody is eating a Snickers. Hold on one second. I need to just gain this down. I have no idea what that was.
I don't think I have it. Counsel, I'm not sure I have those.
All right, so we will make, so as of now,
they're looking for
in
them.
evidence. Tomorrow, we need to physically put the sticker on those.
Can I just get the numbers while we're waiting?
Yes.
230A,
I'm sorry, say that one more time.
230A.
They're 230 A, B, C, and D. But now Jim is looking for the physical exhibits. It is like, I don't even see these. With this many exhibits, this is part of court that happens. If any of you work in court or start working in court, you have to keep your own list. And I would have the list printed out of all of the things I thought I would put into evidence, and I would write it on the side of that list. Because oftentimes you're the only one in court. But it is one of those things you have to track because this stuff happens. And Jim is like, I don't see it. Right.
A through C, 23C.
All right.
Council, there are four,
Four of them,
A through D.
just so the record, this is limited in saying different things. They were marked for identification as triple Y, triple Z, quadruple A, and quadruple B.
Okay.
And all I need to do for my records is figure out which one is which in terms of the whole court's marking. So as you do that, I'm good and I'll get out of here.
Right.
We will do that first thing tomorrow morning.
That's fine.
All right. We will, so.
Look, this is going to get done. It is now just a cluster because of how everything happened. And the cluster that they are having is that for the record, you need to make sure that Y, Z, 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 A, and B all get marked accordingly as 230 A, B, C, and D, which means you cannot mark Y as D. Y needs to be marked as A. And for everything that's gone on in this trial, we've had very little issues with tracking down the evidence. This thing is a thing. But helpful to the lawyers is that Mr. Alessi can just rewind the tape and watch himself holding up the different pictures and determine which one was which. So at least that's helpful.
Everyone is in agreement, then I will let you have tomorrow without the jury. We'll have our charge conference here in person, and I'll give you the rest of the day to get your closing arguments ready. I'm imagining that you don't want to argue tomorrow morning at 9 o'clock. Is that fair?
That's fair.
Mr. Brenner, are you in agreement?
I'm in agreement. I'm not interested in arguing tomorrow.
Okay. All right, so we'll give you tomorrow.
Brennan said, I'm not interested in arguing tomorrow. You've got to do a charge conference. You've got to do the charge conference. Yes, you do.
We'll have a charge conference tomorrow. I'm going to ask the court officers to call the jurors tonight as soon as possible. This is great that you did it. I was going to give you until 7 o'clock tonight, but if you're certain, then the court officers will call the jurors now and let them know they don't have to come in tomorrow. And then when they come in Friday morning at 9 o'clock, we'll do arguments and charge. Tomorrow morning will be the charge conference. Since we don't have jurors, do you all want to come in at 10 o'clock
Yes!
instead of 9 o'clock?
Fuck yes.
Does that work for the Commonwealth as well?
Look at the court reporter. The court reporter is like, yes. Yes, please. Yes. Yes. Look at the court reporter. Look at the court reporter. The court reporter is going, yes. Yes, please.
Yes.
Okay, so I'll see everybody tomorrow morning at 10 for the charge conference. Do you have them now, Jim?
I do, Judge. And just for the record, Y, Z, Z,
Oh, he
Z,
found them.
A, and B are 223A through D. If you want to look.
In the same corresponding
Good
order,
work,
so you
everybody.
know what they are, Mr. Jackson, in order, okay?
223.
223.
Thank you. My only other question, Your Honor, was regarding the parameters of closing argument. Last year, we were relegating.
God. The sirens. I had to turn that down. The defense is asking about closing. And the sirens are so loud. And it seems that they found the items and that the items have been marked into evidence as 223 already. So they don't need to be remarked because Jim found them. So that's what Jim is saying, just for the record, before we get into the rest of this.
Morning at 10 for the charge card. Do you have them now, Jim?
I do, Judge. And just for the record, YYY, ZZZ, AAAA, and BBBB are 223A through D.
So they were already marked. The reason they're 223 is because they were already marked and nobody had it. So that's Jim found them, the clerk. So they are not going to be 230. That would be the new number. They were marked last time. I would have to flip back through my notes because when things get marked into evidence, I also mark the number in my notes. The judge probably did too. Who knows what notebook it's in for her, but those would generally get noted somewhere. So they are, in fact, 223.
In the same corresponding order. So you know what they are, Mr.
There
Jackson.
we go.
In order. Okay.
223.
223.
Thank you. My only other question, Your Honor, was regarding the parameters of closing argument. Last year, we were relegated to 1 hour. I would ask 1 hour and a half.
I appreciate that the court clerk said, can we let the sirens pass? Yep.
No, I got it, but yeah, you can.
The defense is asking about closing argument.
I would ask. I would ask for an hour and a half for a final summation, given the case, the length of the case, the amount of evidence that's been adduced. I think that's outrageous, and the court normally allows only an hour.
You might get an hour and 15 minutes out of me. Let me see it out an hour.
He's asking for an hour and a half. He's not asking for 7 hours for closing. Just give him an hour and a half. It's a reasonable ask.
Let me see. You would not have got an hour and a half by asking.
The court said you might get an hour and 15 minutes out of me. At least Jackson's laughing at the response. I'd be like, are you joking me? We have the whole day.
Only an hour.
You might get an hour and 15 minutes out of me. Let me see it out an hour. Let me see. You would not have got an hour and a half by asking for 2 hours. Mr. Brennan, what are you looking for? Do you want the same?
I don't have a position. I'll take whatever the defense is.
Let me think about it.
Did you hear what Mr. Brennan said? Brennan said, whatever the defense needs, I don't have a position on it. And she said, I appreciate that ask. You would not have gotten an hour and a half out of me by asking for 2 hours. You might get an hour and 15 minutes. It's not horse trading.
All right. So we will see.
Thank you.
All right. So I'll see everybody at 10
She's going to give them an hour and a
tomorrow morning.
half.
Is there anything else we need to discuss?
No, thank you, Your
All
Honor.
right. We'll see you tomorrow morning.
All rise to the court, please.
Holy shit.
Goodbye.
Never has a goodbye felt more ominous. Goodbye. I think the court will probably end up giving them an hour and a half. I would be surprised if she didn't. And even if she only gives them an hour and 15 minutes, I still think if they go over a bit, she's not going to stop them after all of this. So, at the end of day 31, not only are we done with the defense case pending the PowerPoint of Dr. Wrenchler being admitted into evidence. No, Emily. Pending the PowerPoint of Dr. Rentschler being admitted into evidence, which is going to be discussed overnight. But the Commonwealth at the very end of the day said, when the defense rests, we are calling no further witnesses. Isn't that a surprise? There are so many things that Hank Brennan fought for in this case and then just kicked the doors open on anyway. He fought and fought and fought to split up Dr. Wrenchler's testimony and allow Dr. Wrenchler to testify twice. And the court granted it. And then he's like, nah, we're good. I wonder if the ARCCA testimony changed his mind on calling back Dr. Wrenchler. Or, no, Welcher. Shit. I wonder if Dr. Wrenchler's testimony changed the Commonwealth's mind about calling Welcher. Did I do it again? Wrenchler, Welcher, we'll fix it in post. Did Wrenchler's testimony change their opinion on calling Welcher, or is it the x-rays? Is it the x-rays? Is it better to not put Welcher back on the stand to get excoriated over the fact that there are x-rays? I wonder if the Commonwealth didn't anticipate the defense bringing in the x-rays, because it was glaring. It was one of those moments where all 50,000 of us in here went, what do you mean there's fucking x-rays? We were told there were no x-rays. And now there's x-rays? Well, now that we're at the close of evidence, should we pull up where Rentschler talks about the x-rays? I think we have the timestamps. Maybe we'll pull it up. It's in today's case brief over on the Emily Show channel, but maybe we have a minute. Maybe we'll take a look. But either way, the Commonwealth fought like hell to allow that testimony to be split up. And the defense fought and fought to keep that testimony from getting split up. The Commonwealth won that fight. And then they're like, nah, we're good. We're good. So at the end of 31 days, we're at the end of evidence at the Karen Read case. That's it. All of the evidence is in. So what's left? Well, the charging conference, which is the conference where they go over the jury instructions, the instructions that the jury is going to be charged with. At that hearing, we will hear about what instructions the defense is asking for, the Commonwealth is asking for, how they'll be structured, what lesser included crimes are going to be offered with count 2 or not offered with count 2. There might be discussion of that. There will be discussion of that necessary witness / missing witness instruction. We'll talk about that more tomorrow because that will come up in the conference tomorrow. And we know that Alessi is going to renew his request for a further instruction about the Commonwealth's representation during Dr. Wolf's testimony of the holes on John O'Keefe's hoodie. Those are the things they're going to talk about at the charging conference. So tomorrow's going to be a half day, if not less. And with tomorrow being a half day, they will just go through the jury instructions and finalize them. And then on Friday, they will do closing arguments. Ladies and gentlemen of the chat, we are on time, right? That's what she says to the jury. Members of the jury, members of the chat, our humans of the chat, I assure you, we are on schedule. Well, we are on schedule, everyone. Closing arguments Friday. And the court will probably take about an hour to read in the jury instructions. It might be a little longer than an hour. So an hour to read in the jury instructions, maybe an hour and a half to read in the jury instructions, and then an hour to an hour and a half of closing each. So maybe 3 hours of closing, an hour and a half in jury instructions. That's a half day. And then the jury will have about a half day to deliberate, maybe a little less. So the jury will get this case to begin deliberations on Friday. And then the jury will have to decide if they want to deliberate a little longer on Friday or take the weekend. Because last time, everyone thought this was going to be a real quick case. And, well, the jury was out deliberating for an extensive amount of time. And we learned well after the fact that the jury was mostly deliberating regarding count 2. Count 2 is the involuntary manslaughter. Count 2 has lesser included crimes. The jury instructions are complicated as to count 2. They absolutely are. And we didn't see the attorneys address count 2 at all in their closing arguments last trial. And I think we will see more mindfulness around how count 2 is discussed from both teams when we get to closing. I am stunned that we got to the end of the day and we are done with evidence. So while the defense did not rest in front of the jury, the defense has, for all purposes, rested, pending one item of evidence getting entered into. So when the jury comes back Friday, the defense will formally rest. The prosecution will say that they have no rebuttal. The court will read the opening instructions. Then you will get closing arguments, then the closing instructions, then the jury will deliberate. We're at the end of evidence. That was a quick turn of events. A number of you have asked, what is the process for closing argument? The prosecution goes first, then the defense, then the prosecution. The prosecution bears the burden, so they get to do their closing, the defense closing, and then their rebuttal. Sometimes people call it their like opening closing, the open close, and then, but we will see. So that's the end of evidence in the Karen Read trial. 31 days of evidence, 8 weeks of trial. Wow. I did not think they would be done today. The Commonwealth has been saying up one side and down the other. We're going to call Wrenchler. We're going to call Harnett. We're going to call whoever the person is from UC Davis. Wow. 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 I'm really surprised. Really surprised. All right, you guys, don't forget to like the feed. I keep forgetting to ask, and then I keep forgetting to ask. So don't forget to ask. Veritas in the chat said, "What about Proctor?" No Proctor. No more witnesses. The evidence is in. That is all of the evidence. They are not going to hear from another witness in this case. The next thing the jurors are going to hear is the judge reading jury instructions, closing argument, and then the judge reading them the final jury instructions. That's it. So, what about Proctor? No Proctor. Karen Read's not testifying. No one else is testifying. I saw a number of questions, and I'm going to grab one. With the fact that the Commonwealth gets to go twice, do they still get the same amount of time? Generally, the court will generally split up the amount of time they get over their two parts of closing. They don't get to do an hour. If the court gives them an hour and 30 minutes, the Commonwealth doesn't get to do an hour and 30 minutes each time. They get to portion out that hour and 30 minutes over their time. So they could do an hour and 15 minutes, then 15. They could do 45 minutes and then reserve it. It just depends. And the defense asked for a lot. Question, can the defense reference Proctor? In closing, they can. His name's come up. They know he exists. Yeah, they can reference him. They're going to ask for a instruction regarding the necessary witness. And when they ask for the instruction regarding necessary witness, it's because the defense wants a jury instruction in there to argue more. Look at who the Commonwealth didn't call. Look at who they're hiding from you. Look at what you didn't hear. That's what they want to hear. But the text messages are in evidence and they can use those. All right. Thank you, Miguelina. Let me grab that file. We're going to take a look real quick. It's in today's case brief if you want to go look, but we're going to take a look real quick at what Wrenchler said about the x-rays. For any of you who haven't seen it, if you want to go watch the case brief from yesterday, you can. And it's on the Emily Show channel, but we're going to grab this real quick because I want to see what he said too. I do. That is just not showing up nearly the right size, but that's okay. It is. It went in smallin'. It's fine.
You are aware, Dr. Wrenchler, that Mr. O'Keefe suffered no fractures.
Because I'm playing it from file. No worries.
Of any kind in his hand,
there we go.
Correct?
So there were no fractures noted in the autopsy report, but they didn't actually x-ray, from the records I've seen, either his hand or his arm. So there was, at least according to the autopsy report, no overt fractures, but the x-rays I saw, none of them were the arm, and the autopsy report said no.
The x-rays I saw? So what, you only saw part of them?
Sternum, spine, I think it said torso. They didn't
The x-rays I saw weren't of the arm?
say that there were no
wow.
fractures there.
Was there any evidence in the medical records that you reviewed of any indication whatsoever of a fracture in Mr. O'Keefe's hand?
No.
Was there any indication whatsoever in any of the medical records you reviewed that there was a fracture of any bone in the right arm of Mr. O'Keefe?
Not that I saw. Again, it wasn't x-rayed.
Was there any indication?
It wasn't x-rayed.
In the medical records and the autopsy that you say you reviewed of any fracture of any bone anywhere in the body of Mr. O'Keefe?
Yes.
Other than the occipital bone or the skull?
There's a couple bones in the skull that were fractured, but other than the skull, no.
Correct. So
they weren't x-rayed. He said it very clearly. No, they weren't
type as well?
x-rays. Oh, I went back too far. I messed it up.
Correct.
This is why they're not recalling Welcher. He would get scorched. And why let the defense ask Welcher again how much he got paid? Because if you're the defense, aren't you asking this guy how much he got paid again? You're going to be like, hey, buddy, remind me again how much you're getting paid? Why bring that in front of the jury again? Wow, wow, wow. Let me get that right back to where we were about the x-rays.
you are aware, Dr. Welcher,
I rewound it,
that Mr. O'Keefe suffered no fractures of any kind in his hand, correct?
So there were no fractures noted in the autopsy report, but they didn't actually x-ray, from the records I've seen, either his hand or his arm. So there was, at least according to autopsy,
from his hand or his arm. Well, the jury saw it.
report, no overt fractures, but the x-rays I saw, none of them were the arm, and the autopsy report said no sternum, spine, I think it said torso. They didn't say that there were no fractures there.
Was there any evidence in the medical records that you...
They didn't take x-rays, and it didn't note that there were no x-rays. Listen to him. He's like, it noted no fractures here, but it didn't note no fractures to the arms. So that's inaccurate on two counts. One, there were x-rays taken. Two, it was noted. And today, Brennan was cross-examining Rentschler about that exact point. Oh, you're just regurgitating what it says in the medical examiner's records. Because the medical examiner's record says that there's no fracture to the right arm, wrist, hand. And he's saying, no, it says the this and the this and the this, but there were no x-rays. Oh yeah, he would have 100% got scorched on this.
Of any indication whatsoever of a fracture in Mr. O'Keefe's hand?
No.
Was there any indication whatsoever in any of the medical records you reviewed that there was a fracture of any bone in the right arm of Mr. O'Keefe?
Not that I saw. Again, it wasn't x-rayed.
Was there any...
Again, it wasn't x-rayed. Yeah, he would have. The whole thing would have been about the x-rays. And after the issue with the hoodie, I can understand why the Commonwealth might not want to end on that. And this is a great question. Barry said, who's in the wrong, the Commonwealth or Welcher? I don't know. I don't know who's wrong. I don't know if he didn't see them. I don't know if they didn't give them to him. I don't know. And I don't know if we will know. Because, well, did he not see them in a drive? Did pages get left out? Who knows? But they got to the defense. They got to the defense witnesses. They got to the other witnesses. So how the hell did they not get to Welcher? Or did he not see them? But you know what the prosecution doesn't want to do? Is open that fucking can of worms before closing. Because I don't know if the prosecution knows what Welcher's going to say. Because here's the position Brennan is in. Brennan can't call Welcher up and be like, what the fuck? Because there's still a sequestration order. And you know it's the first thing that Jackson's going to ask. So did you talk to Mr. Brennan before your testimony today? Because fair's fair. And what's Welcher going to say? No. And then Welcher has no idea what's coming, or shouldn't. Or yes, because then Brennan called him up, and that's terrible too. A couple of you are saying, could Lally call him? No. Prosecution team. He's still under sequestration. So no one from the prosecution team could call him and be like, why did you not know there's x-rays? Why don't you know that there's x-rays? And I don't think they trust what Welcher is going to say. Would you? So, evidence is done. The defense isn't going to just try to call Welcher in. They're definitely not going to try to fly Welcher in. No, they're done. Why would they? The defense has a place where they can leave it to argue, and I imagine the defense can trust that the same way everybody went, there's x-rays, that the jury did too. The defense is there looking at them, and they have enough between the law clerks in court and the 5+ lawyers that they have in court. Someone is watching the jury at all time from their team. And if they said there's x-rays and all the jurors went, you don't need to make the point anymore. There is nothing else you need to make the point on. You just let it go. Because I think the points have been made. And at some point, if the jury is ready to get this case, belaboring it more isn't going to help. Nurse M said, why didn't Alessi present it to him? Because did you see how much Welcher was kicking and fighting with Alessi? I think the impact is in bringing it in with the friendly witnesses who you can ask about the x-rays. Because he said he didn't see them. And based on the court's prior ruling, oh, you didn't see this? No, I didn't see it. I didn't consider it. Objection sustained. And then you lose your moment. You lose the impact of the moment, and it just goes by the wayside. Instead of being like, oh, these x-rays, let's talk about what's on them. And everybody goes, the fuck? Welcher said they didn't exist. So he didn't consider them in his report. And there wouldn't be foundation for them because they weren't brought in with Dr. Scortibello. So you would also need to lay foundation for them to come in. So no, you bring it in with your friendly witnesses, not with this witness. And you don't step on your moment. So that was strategic. Freaky is freakiest show. I think I put the spaces in the right places. What do we do after Friday? Well, it depends. We're probably going to be on verdict watch because I'm not going to expect a verdict on Friday. So we'll probably be on verdict watch, and there will be a new episode of the Emily Show on Monday, and we will be on verdict watch, and then we will go from there. A lot of you are asking, are you streaming tomorrow? Oh yeah, I 100% want to see the charge conference. I am more interested in the charge conference than most things. I want to see all of the charge conference. So yes, we're streaming tomorrow at like 10-ish Eastern. So we'll be here when court gets started. It'll be about an hour later, thank goodness. And then I will look at timing for a members only stream, depending on what the court day looks like tomorrow. So don't worry. And then Friday, we'll be back for closing arguments. So now's the time to get the Lawnerd app. First of all, it's where all of the info goes about merch and other things. But it is also where we can keep you in the loop on verdict watch. Because after they're done with closing arguments and final charging, I'm going to answer some questions and then we're done. If we need to stream again, the app is the fastest way for me to let you know that we're going live. There are times where we will set up a live and we cannot go live. We cannot get the information out to you fast enough on YouTube. The app is where we will tell you. And there's times I can't even, I don't even post on other socials because we're getting stuff set up so fast. The app is our first and best and most reliable way to let you know. And we'll be on verdict watch while I'm not traveling. Hopefully. But I do have my travels next week, so maybe I've said that too fast. Daydream 1013 says, it's my birthday today. I'm so glad I get to spend it with the Lawnerds and this wild trial. Today was like we were on a roller coaster. Perhaps the Incredicoaster, which made me horribly motion sick this last time. perhaps seeing credit coaster, and all of a sudden it just comes to a screeching halt. You are just going and going and going, and then it's like, "Ah," and you're like, what the fuck just happened? Because all day, and then just screeching halt, and they're done with evidence. Wild day. Wild day. KPAC, thank you for the compliments in the chat, said, EDB, you are the coolest. I don't know. As a law enforcement officer, this case is so egregious that all of my coworkers, which usually are not pro-defense, well, right, because, you know, the defense shenanigans, I get it. Law enforcement doesn't get to see the best of defense attorneys most of the time, are all team Karen Read. So much doubt. I don't think I've seen anyone in law enforcement not have a lot of questions about this case. And even when I talk to friends in law enforcement and lawyers and stuff, and I say things, they're like, no. And I'm like, no, I'm not fucking with you. I'm not being hyperbolic. I'm not exaggerating. I'll tell you when I'm exaggerating. When I say we've been here for 800 years, I'm exaggerating. No, I'm not exaggerating. This and then this and then this. And they're like, no. And I'm like, dead ass, yes. No. Yeah, it's on. It's happening in court. No. Yes. It came out in evidence. No, it's not just internet bullshit. No, we saw the witness testimony and people's heads hurt. They're like, no, that's not right. Every single one. And I think what gets confusing sometimes in the conversations, especially conversations online, like the conversations most lawyers and law enforcement will have is, can they prove this first? That's where the conversation starts. What have they proven in court? Before you even get to a conversation of what do you think happened, it's, did they prove this case? And that is really where I cover these cases from. What has the Commonwealth proved? And did they prove it beyond a reasonable doubt? Did they prove to you what happened? There are so often cases where you get to the end of the case and you're like, no, yeah, that's pretty confident that that's what happened. Like you get to the end of the Taylor business case, and I started covering that case as we got to the defense case because the prosecution case was so sad and graphic. But you get into the very end of the prosecution case and you're like, oh no, I'm pretty clear on what happened. The only thing I'm not clear on is whether or not some of her defenses will work. How are they going to present the insanity defense? That's the only question. I'm clear on what happened. Like, yeah, I don't have any questions about that. And that's the same with a lot of the cases we've watched. You get to the end of the prosecution's case and you're like, yep. Yeah, I don't have any questions about that. Pretty confident on how that all went down. That is not this case. Even at the end of the Gwyneth Paltrow case, and a lot of people came into that case really not liking Gwyneth Paltrow and probably still don't particularly care for Gwyneth Paltrow as a human. People have lots of very strong opinions about her as a person. But what I saw as we got to the end of that case is people were like, she didn't cause that. She shouldn't be in this lawsuit. She didn't cause that. I mean, I don't really like her or Goop or whatever people think, but this case isn't right. And I see that with Karen Read too. There's a lot of people who have a lot of feelings about Karen Read as a person. And feelings being what they may, okay. But did the Commonwealth prove what she did in this case? Because her aside is not really the point. Did the Commonwealth prove what they say she did beyond a reasonable doubt? That's the point. I mean, the internet doesn't particularly care for Gwyneth Paltrow, but at the end of the day, you look at that case and you're like, that's not what happened. The way he said it happened is not what happened. So I don't really give a shit how anybody feels about Gwyneth Paltrow. That's not what happened. It didn't happen the way the person who sued her said it happened. That's where I'm at with this case too. I know people have feelings one way or another about Karen Read. I don't really feel one way or the other. It's not somebody that I know. I think the interviews are a bad idea, but that's not a judgment about her as a person. But did the Commonwealth prove what they say she did? That's the question. Not the rest of it. So that's kind of where we're at. I saw a couple of you asking if I poll. I don't poll on questions for the jury. But we'll take a poll at closing arguments about whose closing you like better. And we will take some polls on whether you think the interviews were a good idea or a bad idea. We can take some of those polls. Some of those interviews were not helpful. And I think we're going to see the defense lean into conversations around count 2 a bit more, because count 2 could be a sticking point for them if there are jurors who are like, yeah, but those interviews. Yeah, but she drove there drunk. She dropped him off. The taillight's broken. They're going to have to address count 2 for the jurors that are like, okay, but. Because count 1, I think it's not hard to articulate the lack of intent. And that goes for count 3 as well. But for count 2, it's not an intentional crime. And that becomes a different conversation. And I think count 2 and its lessers need to be explained to the jury so they understand it. So we will see where they get to. Michael said, Brennan's losing it with this cross. I think Brennan just like sat down and gave up at the end of today. He was just like, It's wild. Because they just sat down. SVT Medic said, isn't it the Commonwealth's job to prove what happened? Yes. Yes, it is. Yes, it is. Gabby said, this witness has a smile on his face when Brennan is asking these nonsense questions. He did, and Brennan asked him at one point, is it funny? Brennan's cross today was way spicy. He dialed up the snark and pushed and pushed and pushed about it. And then sat down on the weirdest, like, wah-wah of a question, and then said there's no rebuttal at all. I don't even know. Today was strange. Robin said, as neurodivergence rules keep me safe because I hate going into the principal's office. I appreciate it. And it's pretty funny watching the attorneys just being like, no, like everybody was fed up today. Everybody was done today. Everybody seemed hot. Everybody seemed tired. Everybody needed a Snickers. Everybody was done today. But you saw the moment where Dr. Rentschler was like, yeah, fuck it. No, we're not doing this anymore. He was like, that's what you said. That's what you asked. This is what I think. This is what I saw. Rentschler was not here for Brennan's bullshit after lunch. Brandon, thank you for the gift of memberships. I appreciate it. And in the chat, I saw at least 3 of you ask, and Cheryl Ray included, any chance Brennan can change his mind? No. He represented to the court, no rebuttal witnesses. The court is calling the jurors, and is probably done with that now, and telling them not to come in tomorrow. It's done. It is done. And the court said I was going to give them to 7 p.m. No, it's done. We're done. Brennan said that they were done. We are done. He represented that to the court. There's no change of mind. She said, if you're sure, we'll call the jurors. And can we talk about the fact that we still have all of the jurors? Like it's us. They still have all of the jurors? They haven't lost a single juror. That's wild to me. They haven't dropped an alternate. Nothing. They're invested. And I want to see them get the little ball thingy and call the ball numbers. I want to see it. They have all their alternates. Wild. Absolutely wild. And some of those jurors, a substantial number of those jurors, are going to be pissed when they are picked as alternates. Can you imagine? You sit there for 8 weeks. 8 weeks. And then they're like, you're over there. Sorry, you don't get to decide. Yeah, I know. And here's the worst part about the alternates. Here's the worst part for them. They still don't get to talk about the case with the other jurors. While the jury's deliberating, these jurors cannot talk to each other about anything but like food and weather and family, and if they're rewatching Gilmore Girls or whatever. They can't talk about the case. So they finally get to deliberate. And this is sometimes why on longer cases, deliberations take longer. Everybody's like, can't you go back there and just vote and be done? They want to talk about it. They haven't been able to talk about the case. And jurors take their duty seriously. They haven't been able to talk about it with anybody. And they finally get to sit down in a room of 12 and talk about it and be like, what the fuck is up with this? What about this? What about this? What about that? What about that? They finally get to talk to each other. So jury deliberations, even if they agree, might take a little longer because they actually finally get to talk about the case with each other, the only people who have experienced this thing with them. And then the alternates are kept separate from the rest of the deliberating jury and still can't discuss the case. Because if a juror is no longer able to continue deliberation, that juror is removed and an alternate is switched in, and deliberations are supposed to start new with the new juror. So the alternates still can't talk about it. So they get all the way to the end with the alternates. They get selected as alternates, and then they have to fucking sit there. And they still can't talk about it. I would fall over. You still can't talk about it. I would stop. I don't want to be a juror. Could you imagine? And then you still have to wait. And then if you don't get subbed in, I guess the only thing you do is get to ask the other jurors for their numbers and be like, can I call you? Can we talk? Can we talk? Please, can we go get dinner? What is happening? The jurors won't be sequestered. We haven't seen any indication that they will be. It is in the day of cell phones and I don't know, billboards and the rest of it. It's kind of difficult to sequester the jurors anyway, because, well, during certain cases and high profile cases where jurors were sequestered, they took the TVs like out of the room and stuff. They can't even do that because the jurors all have their phones. So they can't. Stuck waiting until a verdict is reached by the selected jurors. Yes. The alternates have to wait until a verdict is reached and they still can't discuss it. Have you ever served jury duty? I've been called to jury duty. I've been called into courtrooms. I have sat down and then I have been excused. So no, I have not sat on a jury. I've done lots of jury trials, but I have not sat, but as the lawyer. So let's see. Barry said, Emily, is an unmarketed benefit of keeping your bar license, in addition to the work you do, the ability to perpetually avoid jury duty? No, because I'm not licensed in the state where I live. So no, I think if I got called for jury duty here, it would be different, but I haven't been. I'll tell you how that goes if I do. But no, I did not extend my license to where I live, because when there's things that come up that I want to handle, they're all in California anyway. So no, nope. And most of the time now I just hire attorneys and do consulting. So it's not, though California keeps raising our bar rates. It's gotten to the point where I'm like, really? But no, it's needed. But no, me being licensed out of the state, I think helps. But I think a lot of defense attorneys would be like, former prosecutor, I'm not sure how that will go. So maybe not. Though I do think I can be harder on prosecutors because it's a job I used to do. So it's harder to be critical when it wasn't your vibe. I think I have a little more grace when it's not my thing. I think I'm a bit more critical of prosecutors. Though I can be more complimentary when they do things well. It's really nice to see a good prosecutor do their job well. It's noticeable when they don't. The prosecutors in the Brooks case, I don't know how I could ever. They were incredibly thoughtful, incredibly patient, very mindful. And I don't know how they kept their cool. I really don't know how they kept their cool. They were so organized. They were steadfast. And you know that they were frustrated with him, and they kept their cool in a way that I don't think I would be able to, in a way I don't know if many people could. They kept their cool in an incredible way. And they were so mindful of not just trying their case, but also protecting the appellate record, which is something that I have not seen Brennan do well in this case. Mindful prosecutors look out for their case, but they protect their case on appeal as well. So if there's a question about doing something, they will go the extra mile to make sure that it doesn't become an appealable issue. So even if there's something they could keep out, they might just say, you know what, I'm not going to fight on this because I don't want it to get overturned on appeal for this thing. And you really saw that with the Brooks prosecutors going the extra mile to protect their case on appeal. It is the second part. You are protecting your case. You are putting your case before a jury. You're protecting the rights of the defendant, and you're protecting your case on appeal. And that is a lot of sections of stuff to keep in line. And we saw it actively play out with the Brooks prosecutors. We did not see that play out as much with Brennan. Brennan was much more comfortable in a gray zone. And there are things that Brennan didn't put into evidence that, like John O'Keefe's hoodie. If Brennan had tried the case more like Lally, all the photos from the criminalist would have just come in with the criminalist. But he didn't. So it opens the door for the defense to make that argument. Why is this the only picture that wasn't put in? It's a good argument. You can't have that argument if you're just putting it all in. Let the jury see it, let the jury sort it through, and let the jury decide. But when you keep stuff from the jury and you keep stuff out, it can turn around to bite you in the ass. And that is a line that Brennan's been real comfortable walking. So it is. Really is. Really is. David, thank you for the super chat. David said they know they have no case and they're just yodeling it at this point. Oh, YOLOing it. I don't even know how I got to yodeling, but my brain put a D somewhere where it shouldn't be. Emily, it's all the talk of force and loading. I know. We had the impounder today and everything. My brain just went full yodeling. But it really was a strange fizzle to the end of the case. It was just like, womp. I don't know. You all experienced it with me. I don't know how to explain it. I don't know how to explain it. The end of the case. I'm so stunned. It's just that terrible question that he ended on. And they're like, we're done. What the fuck? I still don't quite believe it. Scott said, can the jury review demonstratives? Not in deliberations. No, they can't. So they can use them when the witness is testifying, but the testimony is emphasis. Is emphasis. The evidence is what they can review in deliberations, not the demonstratives. What's the significance in out? The court was talking about what items of evidence and what slides were coming in and out. Today was so fucking weird. A lot of you were like, what's the last question? I stopped listening. I have it in my notes, but it was, it was really actually the weirdest. Should we just do it again? Brennan was trying to have a moment, it felt like. And he was like, what happened to the taillight that night? I'm being hyperbolic. Can you tell me what happened to the taillight that night? You ordered the code red. That's how it felt. Can you tell me how the taillight broke that night? And he's like, nobody knows how the taillight broke. Womp. I'm going to back up to that question because it felt like he was trying to have a moment, like a big moment with Rentschler. And then it was just like, wah, wah. Let's see if I can pull that back up. Emily, are we just rehashing? Yes, and we're going to do it more tomorrow. Don't worry, there will be more rehashing tomorrow. That's not where we're at. Don't you worry. Before we start talking about other cases, which at some point is going to happen, this got letterboxed all weird at some point. Did this change? Huh. That's odd. The closed captioning aren't back up. And the stream quality changed since the stream ended. That's very, very strange. Let me try to find that last question because it got letterboxed all funny. That's really weird. Let's see. This is today's stream. I'm just trying to find that last question because it was a really strange way to end. I know I talked about the fact that you want to end on a really strong note on your redirect or recross for your case. And that did not happen here. All right, let's bring this up. We'll pickle cleanse before we end the stream. Don't worry. Chat, motion granted. We will. We might need to just call the pickle Randy. It might need to be Pickle Randy at this point. So.
I have no further questions.
All right.
That was I have no further questions.
Isn't it?
The objection sustained.
How'd that taillight break, sir?
How'd it break that night?
How'd
that taillight break, sir? How'd it break that night?
Celebrating, isn't it?
Objection.
Isn't it?
The objection sustained.
How'd that taillight break, sir?
How'd it break that night?
I don't know. There's no evidence of how it broke.
The last thing the jury heard in the Karen Read case from a witness was, I don't know, sir. There's no evidence of how it broke. Period. A weird place to end your recross. And Brennan should have been able to anticipate that he wasn't going to make much headway with this witness. But alas, I'm going to answer some more questions. And then tomorrow we'll be back an hour later to do the charging conference. I'm going to do my best to grab as many of the jury instructions that I think they're going to use as I can, so we can put them up on the screen. And so we also have the jury instructions, but it's not as easy as one would think. Carrie Reed said hi to my mom, Linda. Hi, Linda. We watched together despite being 1,800 miles apart. Carrie, you are not the only one. I know I am mom's favorite YouTuber, which I love because there's times that people join Team Baker and they're like, oh, my mom's been watching you. I'm like, And I love it. So hi to all the moms in the chat. A lot of our chat watches with friends that are all over the place and they see each other in the chat to talk about it. Both are former marching band nerds and attend DCI in Indy. We will be at DCI in Indy this year. I got to talk to Travis last night and ask him how he was doing. He is exhausted, but like happy. He's like in his routine. They feel really good about the different acts that they have done. He's like, my feet hurt a little bit, but my body doesn't hurt anymore. He's like, I've gotten around the hump of how much my body hurts. And I'm like, good job, buddy. He's like, I'm going to fold laundry tonight and then go to bed. I'm like, good for you. So Loch Nessie, thank you for the gifted memberships. So yes, T is doing great. And well, we've got just about a month and a half that I will get to go do DCI things before trial starts in Coburger. So then we will be in trial together. All of you are like, Emily, what are we going to do? You're going to get everything you need to get done between now and November, done in July. Emily's going to go see her kid and we're going to stream some other cases. And then we're going to be back in trial for months and months and months and months. But don't worry, it's not that I'm going to stop streaming. I'll be here. Our schedule's just going to get a little scattered. We can hurry the defense along, but Brennan is allowed to ask questions about a ham sandwich for 15 minutes while making smart remarks constantly. There was a lot of snark. I do appreciate that Jackson came back after lunch and stopped calling Randy a dummy. I feel like things did improve for Randy after lunch. But today was a lot. Why didn't Jackson say how long Proctor held the evidence? Because it's not in evidence. No, it is in evidence. The evidence, he can argue it in closing. The evidence we have is when it got picked up by Trooper B and when the crime lab got it. And that there's no chain of custody in between those two things. That's what's in evidence. So it can be argued that for that amount of time, it was just accessible because that came in with Trooper B. So anybody could just walk up. And that was over a month. So it did come up there. This witness probably doesn't know it, which is why he didn't ask this witness, but it will come up in argument. And the jurors are going to be so happy. Maybe not that they get a day off tomorrow, but that they are like done. David said, Judge be like, shucks, why did they have to remember those? I think it was just housekeeping. I really do. I don't attribute anything more than that to it. The judge said multiple times that those were coming in. And then when the clerk found them, they had actually been marked into evidence, but I get it. I get it. I get after watching this case that there's not a lot of grace left there. There's more question and then verify. There's not a lot of grace. And well, with the way the lawyers represented things at times in this case, I was like, I'm going to need you to show me. I'm not taking anybody's word for it. You're going to need to show me. You're going to need to show me. I'm going to just need all the documents. Like I can't. Chrissy said, EDB, after watching you for 2+ years, I just applied for school to finish my paralegal. You gave me faith in the justice system again. Chrissy, here's what I will say. I think that the foundations of our system are good. We need good people in our justice system, and we need it to be open to the public so that people can see what's happening, so that when things need to change, they can. And I think that only comes with transparency. And it's helpful. I only know what I know about the cases I worked and the things that I've seen. I don't know how they do things in Massachusetts. I'm still fucking questioning things. I still have questions. I don't know how things work in South Carolina. There were times in the Murdaugh trial, I was like, what is happening? And there were times I was absolutely delighted. I was like, what is the cloak of righteousness? What is this? I love it. I love the hear ye's. There are things about seeing how our legal system works and each state being so different, and then the federal system being different on top of that, that I hope is helpful. But it's important that cases have transparency. My concerns come in is when the transparency in cases causes negative impact to the courts. The courts will just be like, fuck you, get out. Somebody can come sit. We're not streaming anything. And I think what we'll see is courts are going to start doing what Idaho's doing. Idaho's like, we've got cameras, we're controlling them ourselves. That's their compromise. And I'm fine with that. But, remind me, another day, we are going to have to talk about the legacy media losing their minds over the way that Idaho is accessible. There's a whole bunch of shit going on with that. But I think the way that Idaho in the Koberger case has said, the court is streaming the court cameras, they're fixed cameras, so everyone has access to it the same way from the same place. I think that it is a level playing field. So if you want to access it, you can. That's it. Everyone has the same access, and people can't be shut out of access. I think that that is an important thing. But we've got some stories we got to talk about for sure. So I think we'll see courts go the way of Idaho with the courts controlling the streaming. I think as we get into the rise of, AI videos and voice duplication, our system is going to get stress tested on foundational grounds of evidence and proving that evidence is real. And it's going to be something that our entire court system, our judges and lawyers need to understand. And I worry that many do not understand nearly what the capabilities are and what's coming. And so that when I take a look at where I can help in my profession, that's the thing that my attention is turned towards, is how we can make sure that we still have good procedures for verifying that evidence is real. Because we already saw it in the, I'm going to forget it again. I think it was the ASAP Rocky case where the witness is like, nah, that's not my voice. Those aren't my voicemails. That's not my voice. Somebody did those, and was starting to try to argue that those voicemails weren't real. So we're going to see that more in courts where people are saying, no, that's not it. And it's gotten, it's going to get more complex. And then we've got the lawyers like out here citing cases in federal court that ChatGPT made up. So the court system and technology are going to have some very big reckonings. Sweet and Savage says, does that mean we get a members only tomorrow? That is my goal. I'm going to talk to the team about what time, but we will have a break between the two. I imagine we will be done with the charging conference within a few hours. So that is the goal. And we will post a time. I will decide tonight, and then I will let you guys know. But yes, my brain is starting to pause on me. Allison in the chat said, wait, made up cases? Yes. I had a video about the ChatGPT lawyers, but yes, it made up its own case law. And the lawyer, it seems, presumed that ChatGPT was like scraping the paid legal sites that you use, Lexis, Westlaw, whatever. It seemed the lawyer thought that it was just scraping those sites and they could like get around paying for those, which can be fairly expensive. And case access can be fairly expensive, period. And so instead of paying for the legal research sites, thought ChatGPT was just pulling from those. It wasn't. It just made it up. It formatted it and everything. So, yep. Let's see. Alessi 100% knew there were x-rays. Strategic way to discredit him later, I think. Oh yeah, Alessi 100% knew there were x-rays. I think Alessi was surprised by the answer. I really do. Stacy said the people in Massachusetts should demand a refund. I don't even know how they do that, but they've paid for Welcher, Burgess, and Brennan. Barry Adams says, how's long to know which details are important, facts, and to take the rebuttal off the table when overbought experts expanded? Well, it definitely happened, didn't it? The rebuttal came off the witness just immediately. Just immediately. Water Unleashed says, I think Welcher is the one to misrepresent the holes in the back of the hoodie to Brennan, which is why Brennan won't call him. Maybe Welcher was like, hey, but what about this? Maybe. I don't know if Brennan was just lost in the sauce and was like, well, I saw them. And I was just like, I don't know. But it might be. Welcher might have pointed it out. Sydney said, could the defense have asked if given $325,000, what type of testing would they do? Yes. Here's why. The door was open for it when Brennan started asking, were you constrained? And he was saying, I was constrained by budget and what have you. Well, could you have done this kind of testing? Could you have done crash testing then? I think Jackson could have said, so if you were given a budget of, say, just picking a number here, $350,000, how much could you accomplish with that? I don't think he needed to, though, because I think the point was there. But yes, he could have, because Brennan stepped right into that line of questioning with many. Brennan had had some good crosses in this case, and he had some points that he could use to argue. So he had some good points, but they got so lost among all of the other fighting with the witness that I don't even know if he'll argue them. So, it is what it is. Rich the Italian Plumber said best law channel on YouTube. Thank you, Emily. I mean, I just try to do what we do here. There are many great law channels, and what I love is how many different perspectives you get from different lawyers. We all see things differently. We've all had different areas of practice. We've all had different life experiences. And so what I love is that there are so many different perspectives. It gives a really fulsome way of looking at cases. And then you can kind of see where you fall and hear what everyone has to say. I think it's fantastic. I love how big and broad the internet is. It's great. Casey Cat, thank you for the gifted memberships. Stacy said, do you think they hit Proctor hard enough to discredit the taillight pieces? I think that the Proctor not being shown to the jury is a hit for the prosecution. I think that the jury will be frustrated that they didn't hear from Proctor, and it is the prosecution's duty to call those witnesses, not the defense's. I think that the taillight pieces in combination with all the accident reconstructionists may matter, but the jury might take the approach that Rentschler took. And they can if they want to. The jury can take Rentschler's approach and be like, was John O'Keefe hit with a car? Was it intentional? Was it not intentional? And take that methodology from him. It's the last thing they heard. It's a logical methodology to follow. Did John O'Keefe get hit by a car? Start there. Because the experts talked a lot about the force falling backwards. Okay. I know the prosecution's going to play all the clips of Karen Read. In closing, I clipped him. Could I have clipped him? Could I have done this? But then how is Brennan going to articulate how John O'Keefe ended up where he was? how the injuries to his arm happened. How is he going to argue that? I don't know. But I'm really interested to see how the closing goes. EDB, what do you think was the prosecution's strongest argument or witness? Oh, Christy, I'm going to have to think about that one overnight because we are too close in recency to the defense witnesses. The prosecution leaned heavily and will continue to lean heavily into Karen Read's statements. And I think they are going to rely on her statements as their best witness. I don't know if that will work because Brennan really did step in it with Dr. Russell, who said, no, I discounted those entirely because of trauma and stress and grief. No, I don't. But the weight a witness's words can carry can't be underestimated. And we're going to see how he uses them tomorrow. But then again, the defense is going to come in and say, look, they're basically using Karen Read's statements like duct tape for a case that doesn't exist. So they've just duct taped it around saying, look, there's a case. What there is are a bunch of statements to the media. So we'll see. Noelle said, please name the pickle Rescue Randall, the pickle. Rescue Randall is funny. Randall, Rescue Randall. It's a fair point. Can we pull the best words of the day after closing? Yes, we can. I need to go and put a few more up. I have them in the notes that I haven't put into the different cases. But Shank of the evening was fantastic. Do you think Hank regrets asking questions and calls it quits? I have no idea what he thinks, but I think there are definitely times that he looks like he's like, oh shit. Oh wait, I was trying to, I got lost where I was. Apologies. FL fan, I will review the charges when we go through the charging conference tomorrow. It's going to be a better time for it because I'm not sure exactly which lesser includeds are going to come in for count 2 until they go through the charging conference tomorrow. But generally, count 1 is the second degree murder. Count 2 is the involuntary manslaughter. And count 3 is the hit and run causing death. Counts 1 and 3 are intentional crimes. There's a mens rea element to them. Count 2 is involuntary and then has those lesser includeds. I don't know if all those lesser includeds will come in. Nicole in the chat said, will the missing person instruction be read? We don't know until tomorrow. They haven't argued it yet. So they're going to argue that tomorrow. There will be some legal arguments that happen tomorrow. It's going to be important. Emily, remember, not everything in Massachusetts is awful. No, I remember. This case has been challenging, but I do not attribute it to the entire state. There is pizza from Antonio's, wings from the hangar. UMass, if you know, you know. Come back and visit sometime. I need to. I haven't been back to Amherst since college. Boston, yes. Amherst, no. It is needed. It's been too long. And it would actually be fun to bring my kiddos now that Travis has some more experience with college campuses and the rest of it. It will be very fun. Christy said, anyone else's first case with the Lawnards? We have lots of new Lawnards, lots and lots of new Lawnards. And what's been fun is with Travis, some of his friends in DCI have family that is watching. And Travis was like, so guess what? So I look forward to also seeing some of the other parents from Travis's core as well. Helen said, excited for Travis. I watch with my friend Kate, surprised by the effectiveness of the science-wielding boss lady witnesses who finished out the trial. Yep. There are, it's helpful when the jury can see and understand what's happening. It was not helpful, and I was very much interested to see what the new experts from the Commonwealth would have to say. I am optimistic, sometimes to a fault, that there will be answers provided. Sometimes it doesn't happen. And I was optimistic that there would be some answers provided. So I was hoping that we would see more from the Commonwealth's experts. But by the time we got to neurosurgeon Wolf Hungry Like he was like, oh yeah, I see injuries like this all the time. When somebody's drunk and slips and falls backwards, or when somebody has a heart attack and falls backwards. Yeah, we see injuries like this all the time. I was like, huh. Well, that's interesting, isn't it? because what it sounds like to me is Dr. Wolf said that that means there's another reasonable explanation. If there are two reasonable explanations, then the jury is told in the instructions they must pick the one that points towards not guilt. Does that mean juries always do? No. Sometimes the jury actually wants to split the baby. And they're like, yeah, I don't think she intended it, but she was driving the car drunk. Count two is something the defense, no matter how confident they feel, count two is something that they need to be mindful of. And we will talk about that. This is a great question, GG Mars 36. EDB, do you think the media can have a huge impact on a case? Why do you, or you think, I think this is, okay. Do you think the media can have a huge impact on a case? I think there are times that the amount of attention can impact a case. I don't always think that that is good attention, but sometimes it is. We saw in the Depp Heard case that there were rebuttal witnesses that came to light because they saw the case playing out. And they're like, wait a second, I know that I was there. I know that that's not true. So I think that can be helpful. In the Murdaugh case, people were calling in bomb threats on the courthouse, and the courthouse had to get evacuated. That is not helpful at all. It's not helpful at all. People email the judges, people email the attorneys, people want to insert themselves into the case, and that's not helpful. But I do think it can be helpful for the attorneys to see what the opinions are online, to see people having a conversation. I don't think people should try to insert themselves into the case, but I also think the attorneys can learn a lot from seeing the conversations that happen. And I also think local communities learn a lot when there's attention on a case because they're watching it play out and they're like, I didn't know that was happening here. I didn't know that was happening here. Oh, GG, Mars, it's fine. I just took my brain a second to figure it out because I'm very tired. You're all good. So I think it can be helpful for local communities to see what their judges are doing. How do you know if the judge you voted for is great? You don't sit in their courtroom every day. A lot of you that vote for judges, do you just call up a lawyer you know and ask them? Go, hey, who are you voting for judge? Because I get those texts all the time. Do you know any of these people? Are they good? Or do you just look at a last name and go, that sounds fine? How do you know? Because a lot of people don't have regular interaction with the court system, which is a good thing. It's a good thing, but also it makes it really hard to engage with the court system because it feels so different. It feels so stodgy and unapproachable. But you can go into your local courthouse and ask those in the front, hey, are any of the courtrooms in trial? I want to go watch a trial. You absolutely can. Hey, I want to go watch a trial. Hey, I voted for this judge. I want to go watch. I want to go watch what they do. You absolutely can. So it's really just up to you. Ellie said, Emily, have the defense rested? Asterisks, yes, and. The defense is done with their witnesses. They have not rested before the jury yet because there's an item of evidence that needs to be entered in tomorrow. So pending that item of evidence, they are done with their witnesses. So it's an asterisk. Yes, they're done, but they're not all the way done. Was the x-rays of my cousin Vinny moment? I would have to think about it a little bit more. But for me, the x-rays were, are you kidding me that there's actually x-rays? And it wouldn't have been a big deal if Welcher hadn't doubled down on it so much. And he doubled down on it on cross because of Alessi. Because Alessi asked those questions. But it was a moment where you're just like, what? Wendy Queen said, thank you for streaming trials like this. I love it too. Please send all the positive vibes to my bestie, Sarah May. We are helping her senior kitty cross the Rainbow Bridge tomorrow. I am sorry. I'm sending all of the love. It is blessed to have pets live a very long life, but it also is gutting when they are at the end of that very long life. And it is a uniquely different type of grief. Grief is, we're not going to get into grief today. It's the end of trial. Emily's going to get all emo. Grief begets other grief. And we've all had a very long emotional experience over the last 31 days, because even though there are moments in this case that are lighthearted, where the jury laughs, where we laugh, where we talk about the things that happen in court, or things that happen in court are ridiculous or horrific or fucking wild. At the end of the day, we're looking at a case that is now in its second round, where for me, there are not enough answers. And everyone involved in this case deserves those answers. And it is an incredibly sad case at the core of it, even with the ridiculous moments, even with the ridiculous questionings, even with the ridiculous mispronunciations and Alessi's thesaurus and the rest of it. There are moments of this case that don't feel as heavy. But at the core of it, it is a tremendously sad case and a very, very frustrating case. And I think that's why a lot of you noped out and are just watching the case briefs. So you're not even hearing me say this. A lot of you noped out and are just watching the case briefs and are like, girl, I can't do this to myself again. And then a lot of you are like, I don't even know. I'm so frustrated. I get it. I get it. It's a frustrating case. And not having answers is uncomfortable. And then having to wait for a jury to make a decision. We'll talk about the counts more tomorrow. But again, you never know what jurors are going to do. And that's frustrating too. Will it make it easier for the defense to argue a pared down case, not worrying about trying to show everyone that there's a conspiracy with a million different people? Will it make it easier for the jury to see? Because I think in the last trial, there was room for the jury to be like, there's something going on. The defense is trying to show me something that I don't agree with. We didn't get that this trial. The defense spent more of their time focusing on, look at what the prosecution's doing. Last trial, it was, look at what Jen McCabe's doing. Look at what Brian Albert's doing. Look at what Colin Albert's doing. Look at this, look at this, look at this, look at this. It was too much. And some jurors are like, no, you're focusing on everything but the question. Here, I think the defense has narrowed back down to focus on the question. What did the Commonwealth show you that Karen Read did? What did they prove to you? And I think it's a stronger position to argue from versus look at what all these other people are doing. It's taken away a lot of the distractions. But there's also a lot of stuff in this case that the jury does not know. And I think some of that's going to get held against the prosecution. Where's Trooper Proctor? Why didn't you hear from him? What is the prosecution not telling you? And that's why I think the X-ray moment matters. Getting back around to answering the question I was answering, that's why I think the X-ray question matters. What did the prosecution not show to the jury? The X-ray is just an easy one. What else? The holes on the back of the sweatshirt? What else? Trooper Proctor? What else? People in the house? What else? That car that was parked there? What else? What did the prosecution not show you? What questions did they not answer? And why are they only telling you what Karen Read said? That doesn't match with the evidence. What else? It'll be interesting, won't it? I've seen a number of you ask, unless it's one person asking a lot, I've seen a number of you ask, how many jurors deliberate? 12. Which is a very fair question because in different jurisdictions, it's different amounts, which I had completely forgotten about until I started doing this because in California, it's just 12. But it's different depending on where you live. It can be 8, it can be 6, it can be 10. It just depends. 12. 12 jurors will deliberate. So tomorrow, jury trial charging conference, day 32. The jury will not be there tomorrow. We will be. And the attorneys are going to argue over the jury instructions. The jury instructions, it might sound horribly boring. It's like, lawyers law. It is one of the most important parts of a case for the lawyers because it's the outline of what they argue and it is what the judge tells the jury to do. It is the roadmap the judge gives to the jury on how they do their job. And the way those jury instructions are worded matters a lot. As you guys are saying in the chat, words matter. These jury instructions will matter, and the jury won't be there at all tomorrow. They've got a day off. We've got a part of a day, And then we've got a members only live at some point. And then the lawyers are going to be working tonight and tomorrow on their closing arguments. They probably already have outlines of them. And then Friday, jury instructions, closing arguments. The judge is going to read instructions for like an hour. And everyone's going to say, can we put this at 1.25? And I'm going to say no, because the judge reading the jury instructions the way they are on the sheet is important. And we're all going to sit here together and eat breakfast as the judge reads the jury instructions, and then it'll be closing arguments. And away we go. So this trial is almost done. The jury's going to have this case on Friday. Law Nerds, I will see you tomorrow. Thank you for being here. Thank you for being a Law Nerd. Mary, this was a great question. I was in my sign off, and this question grabbed my attention because it's so good. So the jury instructions aren't always the same. No, they're not. There are standard jury instructions that you give in every case. There are modifications of those jury instructions. Half the time they look like a fucking Mad Lib, and you have to put things in and take things out. There sometimes are multiple versions of a jury instruction about a thing. So you have to pick if you're going to use jury instruction A, B, or C, depending on your case. What crimes you're going to explain to the jury and how needs to be argued. And if certain instructions are coming in or out. Sometimes lawyers have to write their own instructions for a situation like the hoodie with the holes. That might be a special instruction. The defense is going to argue to put in that necessary witness instruction. So there is a form set of instructions, but what comes in and out matters very much about what happens in the case, what the lawyers argue for, and what the judge says. And then Friday, they'll get the jury. Also, don't forget, y'all, last night and tonight, massive moon. So don't forget to go outside and see the I think it's a strawberry moon this month. We're not back to beaver moon yet, only in November. But it was massive here last night. It was very cool to see. So hopefully you have good views and you can go enjoy, walk outside, a little bit of the evening sky. It was lovely. I will see you tomorrow in chat for the charging conference. All right, you guys, don't forget to get the app, because this is the part of the trial that you can't nope out of. You're in it now. We're in it for a few more days. Hang in there, Law Nerds. I'm going to say goodbye. I will see you tomorrow, mods. Thank you for riding. Thank you, everybody. See you soon. Thanks for joining me on this stream. If you don't want to miss a moment in court, you need the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android where I can keep you in the loop with everything happening in court. And of course, when the jury has a verdict. So if you don't want to miss a moment of this trial coverage, make sure you get the Law Nerd app. Thank you for being here, and thank you for being a Law Nerd.